ಅದಕ್ಕೆ ಪಾಸ್ವರ್ಡ್ ಗೊತ್ತಾಗದೆ ಅವತ್ತು ಎಷ್ಟು ನಿಮಿಷ ಆಗುತ್ತೆ.
ಏನ್ ಮಾಡ್ತೀರಿ ಕೆಲವೆಲ್ಲ ಅದು ಕಲಿಯೋರಿಗೆ ಬ್ರಹ್ಮ ವಿದ್ಯೆ, ಕಲ್ತಾದ್ಮೇಲೆ ಅದು ಯಾವ್ದೋ ವಿದ್ಯೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಬೇಡ ಅವೆಲ್ಲ ಮಾತಾಡೋದು. ಅವನು ಎಷ್ಟು ಫೋನ್ ಪುನಃ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗು ಮಾತಾಡಿದ್ದೀನಿ. ಫೋನು ತಗೊಳ್ಳೋದಿಲ್ಲ ಅಂತಂದ್ರೆ ಅಷ್ಟು ದುರಾಂಕಾರ ಮನುಷ್ಯನಿಗೆ ಇರಬಾರ್ದು.
ಅವನಿಗೆ ಫಸ್ಟ್ ಬಂದಾಗ ಒಂದು ಪೇಜ್ ಟೈಪ್ ಮಾಡಕ್ ಆಗ್ತಿದ್ದಿಲ್ಲ, ಅಷ್ಟು ತಪ್ಪು. ಹದಿನೆಂಟು ಹೋಗ್ತೀನ
ಹಾ
18 ಹೋಗ್ತೀನ
18ಕ್ಕೆ ನಾನು ಇರೋದಿಲ್ಲ ಊರಿನಲ್ಲಿ. ಅಲ್ಲ ಊರಲ್ಲಿ ಇದ್ದಲ್ಲ, ಇದ್ರದ್ದು ಒಂದು ಕ್ರಾಸ್ ಇದೆ. CG18 ನಲ್ಲಿ ಒಂದು ಕ್ರಾಸ್ ಇದೆ. ಈಗ ನಾನು ನಿಮ್ಗೆ ಒಂದು ಇಂಟರ್ನಲ್ಲಿ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಅದ ಇದ್ರ ಕೇಸು ಅವನೇನ್ ಮಾಡಿದಾನೆ ಅಂದ್ರೆ, ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಸುಟ್ಟಾಕ್ಬಿಟ್ಟಿದ್ರೆ, ಮ್ಯುಟಿಲೇಟೆಡ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆಫೀಸ್ನವ್ರು ಕೊಟ್ಟಿದ್ರೆ ಅದನ್ನೇ ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾನೆ. ಮ್ಯುಟಿಲೇಟೆಡ್ ಅಂದ್ರೆ ಸುಟ್ಟು ಹಾಕಿರೋದು ಮಧ್ಯ ಸುಟ್ಟೋಗಿದೆ, ಅದು ಕೊಟ್ಟಿದ್ರೆ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಅವನೇ ಫೈಲ್ ಮಾಡಿದ್ನ, ಅದು ಹೆಂಗಾರು ಆಗಲಿ. ಅದ್ರ ಮೇಲೆ ನಾನು ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು, ನಾವು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವ್ನು ಹಾಕಿದ್ದಾನೆ. ಅದ್ರ ಮೇಲೆ ಕಾಮೆಂಟ್ ಮಾಡ್ಬೋದು, ಕೊಡ್ಲಿ ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿ ಸುಮ್ಮನೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಸರ್ ಸಾವಿರ ಬಂದ ಮೇಲೆ ಮಾಡೋಣ ಕೊಟ್ರೆ ಅದು ಪೆಂಡಿಂಗ್. ಇದು ಸ್ಕುಟಿನಿ ಆಗಿದೆ, ನಂಬರ್ ಆಗಿದೆ. ಇವಾಗ ಅವ್ರೆಲ್ಲಿ ಕಳಿಸಿದಾರೋ ಗೊತ್ತಿಲ್ಲ. ತಗೊಳ್ಳಿ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಕೋರ್ಟ್ ಎಲ್ಲ 6. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ನೋಡಿ ಗೈಡ್ಲೈನ್ಸ್ ಹಾಕಿರ್ತಾರೆ
ಇಲ್ಲ ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ ಹೈಲೈಟ್
ಅದು ಗೊತ್ತಾಗ ಸರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಮೇಡಮ್ RFI ನೆಕ್ಸ್ಟ್ ವೀಕ್ one date ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತಲ್ಲ. ರಿಗಾರ್ಡಿಂಗ್ ಪ್ಲೇಸ್ ಬಟ್ ಅದು 2024 ಗೈಡ್ಲೈನ್ಸ್. 2013 ಮೇಡಮ್ ಫ್ರೆಶ್ ಕೇಸ್ ಅದು ಬರುತ್ತಲ್ಲ, ಬ್ಯಾಂಕ್ ಬರುತ್ತೆ ಅದು ಅಲ್ಲ ಅದಲ್ಲ ಇನ್ನೊಂದು ಮುಂಚೆ ಕೊಡ್ತು ಆ ಕಡೆ. ಇದು
Wait for that. Wait.
Serial number 1. Serial number 1. Admit ಆಗಿದ್ಯಾ? ಆಗಿಲ್ಲಲ್ಲ?
It's a consumer matter for tomorrow. GM consumer. Agency ಬಂದು state commission execution ಇದೆ ಸ್ವಾಮಿ.
Execution is fine.
Execution pending ಇದೆ.
Good. Debt appeal 1343 has been transferred from the court number 2. We can hear groundless lawyer also, no issue. So can it be this 14% on 13 of November, it can be listed.
In urgency.
No, it is urgency, but it is not that urgency. Actually, I am going on 14/11 to Delhi.
Yeah. When are you coming back?
Coming back in the December. Either it may be given in the 5th of December. I will attend by VC.
Sorry, first week of December.
5th December.
Can't fix that way because we do not know the seating arrangements. Yes.
May I please, Your Lordship?
Okay.
Yes, Lordship, Lordship,
Yes,
petitioner is a senior citizen and he is a retired principal scientist and he's an 83-year-old person. So we have filed this writ petition. There is some order against some order of the CAT. So there is some irregularity. Lordship, he is
Only cat or dog also?
CAT, my lord.
When do you want?
Lordship, tomorrow if it is possible.
Tomorrow?
Yes.
Is
my
it
lord.
so much urgent?
Yes, my lord.
Sorry.
Yes, this is the only source of income of him.
No, not.
Lordship, arbitration writ matter, Lordship has issued emergent notice. I was asking for a stay, but emergent notice has been issued.
Service
And
ಆಗಿದೆಯಾ?
I am not able to, so for substituted service,
Ah.
any date convenient, I'll file.
Sorry, next week.
Grateful.
Kindly, my for
Yes.
attainment, my lord. Serial number 24, my lord.
34,
24, my
24. ಯಾಕೆ ರೆಡಿ ಆಗಿಲ್ಲನೋ?
la, my lord. Senior counsel.
2016 matter.
Next 2 weeks.
Second week of January, at the request.
Your lordship,
ಅಲ್ಲೇನೋ
What
ಏನೇನೋ
is
ಇದೆ
the appellant?
before senior division president.
I
Huh?
appear to the appellant in 24.
In 24, you appear for appellant. He wants time. Do you have objection? Okay. All right.
your lordship, serial number 27, please, my lord.
Hmm.
27, my lord.
You know,
Serial number
27.
27, I am appearing for respondent, my lord. Pray for a week's time.
RFA.
1411 ಇವತ್ತಲ್ಲ interest ಇದು
Your lordship,
RFA. Can we have this in the second week of December?
ಇವತ್ತಿನ
Second week of December.
Lordship, serial number 30, my lordship. Serial number 30, my lordship.
Serial number
30, my lordship. 30. 30, my lordship. 30.
30.
Yes, my lordship.
ಮತ್ತೆಲ್ಲ ವಜನ್
Yes,
ಕೊಟ್ಟು ನಾವು
short
ಕೆಲಸ
account.
ಮಾಡೋದು.
Yes.
29.
We press short accommodation, my lordship.
30,
Yes,
2021 matter,
yes, my lordship.
CAT.
Yes, my lordship.
Why time? ಏನಿದೆ ಅದರ?
My senior son is admitted hospital, my lordship, due to.
To hospital.
Yes, my lordship.
All right, call next week on health ground pleaded by counsel appearing for the petitioner.
Yes, my lordship.
Serial number 36, my lord.
30,
36.
ಸುಬ್ರಹ್ಮಣ್ಯ ಭಟ್ರಿಗೆ ಹೇಳಿದ್ದೀನಿ.
all right. Next week, date ಕೊಟ್ಟಿದ್ದೇವೆ ನಾವು. Coordinate which, all right, next week.
Lordship's kind permission, serial number 38, age is appearing.
38,
Yes, my lord. Writ petition filed by state, short accommodation, Wednesday, my lord. We have informed the other side also.
you have informed the other side. ಉಳ್ಬೋದಾ? All right.
Lord, may I mention of serial 27, my lord, please?
27th,
27, my lord. I have informed the other side. I am for respondent, my lord.
ಅದು 38 ನಲ್ಲಿ
Court of,
No, 27, serial number 27, my lord.
27.
I pray for 2 weeks' time, my lord, please. I appear for respondent. I have informed the counsel for appellant also. Sorry, petitioner.
2018 matter.
My lord.
ಏನಿದೆ? 5 ನಿಮಿಷ ಸಾಕು.
Allala.
5 minutes.
Petitioner counsel wants to appear physically and argue the matter. He resides in Dharwad.
Wednesday ಅಂತ ಹೇಳಿ.
Come into this, my lord.
Physically, to threaten the judges.
Please. No, my lord.
All right.
2 weeks, my lord, please. Grateful. Grateful.
ಬಂದಿದ್ದಾರಾ ಸಾಹೇಬ್ರಲ್ಲಿ?
2 weeks. Yes, next.
Lordship, serial number 38, Wednesday.
30,
38.
38.
On
ಏನೋ AG appear ಆಗ್ತಾರೆ ಅಂದ್ರೆ.
Yes, my lord. Yes, my lord.
ಯಾವತ್ತು ಬೇಕು?
Wednesday. my lord.
Day off.
Obliged.
Yes.
Lordships had earlier pointed out, small question is there, a small issue which can be
Discord.
disposed of.
All right.
This
Yes.
cost has been deposited, my lord. I have filed a memo also on 7/9/23.
Coordinate bench order. Coordinate bench order.
Yes, yes,
Cost is paid.
paid.
Then you have to argue the matter, not
7/9/23. But I had filed a memo along with the receipt, my lord.
Correct. Then 2013 matter. But
And,
argue ಮಾಡ್ಬಿಡಿ.
date fix ಮಾಡಿ, I will argue.
Date fix ಮಾಡಿ. ಇವತ್ತು ಬಂದಿದ್ದಲ್ವಾ? ಇದು ಡೇಟ್ ಅಲ್ವಾ ಇವತ್ತು?
Address
Is it
ಗೆ ಅಂತ
exempt
ಬಂದಿದೆ.
from yes. Costs ordered by the coordinate bench wide order dated, directed by the coordinate bench wide order dated 30 August 2023 has been remitted. First of all. Call this matter, ಯಾವತ್ತು ಹಾಕ್ಬೇಕು?
As your lordship.
ಅಲ್ಲ ಹೇಳಿ, ನಿಮ್ಗೆ ಯಾವ ಡೇಟ್ ಬೇಕು? ಚೂಸ್ ಸಮ್ ಡೇಟ್.
After 10 days, any date.
ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ. Call this matter on so and so. First of all, this date is chosen by the counsel for appellant himself. Okay. Coordinate the with by this bench. Yes.
My lord, I am required to take steps, my lord, in respect of
4 and 8.
yes.
Steps to be taken. Deceased ಅನ್ನೋರು.
ಹೌದು, ಇಬ್ರು ಡಿಸೀಸ್ಡ್ ಆಗಿದಾರಂತೆ. 4 and 8.
Unclaimed.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 7 ಗೂ ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು.
7 held sufficient. ನೋಡಮ್ಮ, 7 held sufficient ಮಾಡು. Steps within 10 days, failing which ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿರಿದೇನಾ?
ಇದೆ.
Okay. Steps within 1 week. Finally, first off, if steps not taken, next time heavy costs will be levied. Okay.
Apologies, my lord, 10 more days time.
ಯಾಕೆ ರಾಜು?
ಅದು 1945 ಸೇಲ್ ಡೀಡು ಸ್ವಲ್ಪ ಪಾಣಿಗಳೆಲ್ಲ ಟೈಪ್ ಮಾಡಿಸ್ಬೇಕಿತ್ತು.
10 days?
10 days.
No. The other one date. Call so and so for compliance. Whichever. R4 steps ತಗೋಬೇಕಲ್ಲ. ಯಾವಾಗ ಡೆತ್ ಆಗಿದೆ ಏನಾದ್ರು ಗೊತ್ತಾಗಿದೆ? We ordered 23. Appeal abates as against respondent number 4. Since no steps are taken, despite coordinate bench order dated 28 February 2023. First.
He died on 23/2/2022.
Okay. ಆಗಿದೆ. Already that order is there. The coordinate, I don't know, coordinate bench said, while order dated 28/2/23, the coordinate bench said like this. First up, it need not be repeated. First up, call this matter week after next.
It has to go to APC.
Appearing for the petitioner, your lordship.
Yes.
Your lordship, we would like to withdraw the petition, your lordship. The instructions from the petitioner is that he doesn't wish to pursue this matter anymore and will be dismissed as withdrawn, your lordship.
Is he unhappy with the court or what?
No, your lordship is not unhappy with the court. It's just an instruction that we've been given, your lordship.
Counsel for the petitioner submits that his client is no longer interested in prosecuting this WP. First off, she adds that he is not unhappy with the court process. First off, in the above circumstances, the appeal is disposed of as having been withdrawn, dismissed as having been withdrawn, courts having been made easy, or government advocate Thorsbeck. Yes.
Grateful, your lordship.
Okay. But G, non-compliance of office raising scrutiny bench. Scrutiny bench nalle raise ಮಾಡೋದು. ಅದನ್ನೇನು ಬೇರೆ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ನಾಗ ಮಾಡಕ್ ಬರ್ತಪ್ಪ ಕೊಡಿ. Jurisdiction to be stated correctly at WP memorandum. Type copy of to be furnished. But ಏನು type copy ಬೇಕಾಗ್ತದಾ? ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ ನೋಡೋಣ. ಪಾಸ್ವರ್ಡ್
ಐ ಕಾಲ್ ಮೈ ಫ್ರೆಂಡ್, ನಮಗೂ ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ. ಅವ್ರು ಯಾರೋ ತೀರ್ಕೊಂಡಿದಾರಂತೆ, ಅಯ್ಯೇ ಹಾಕ್ತೀನಿ ಅಂತಂದ್ರು. one of the parties to the petition, not my friends. So he may want to file an IA for
Call after 2 weeks for taking steps in respect of some deceased.
That's what he told me over phone. Nanatra petition copy na kotilla.
After 2 weeks.
After 2
Full
weeks.
stop. In the meanwhile, petitioner to furnish a copy of the petition along with all the documents on the, to the panel council appearing for
R3.
R3. Okay. ಇನ್ನೆಲ್ಲ ಮುಗಿದು ಹೋಗುತ್ತೆ.
Okay for the petition.
ಏರಿ
Office objection ನಿಮ್ಗೆ.
ನಮ್ದಾ?
Office objection. Affidavit
Hearing ಆಗಿಲ್ವಾ?
Agil. I will comply. I'll comply. I'm sorry, I did not realize. I'll comply it in the course of the day, if my lords permit.
ಅದು ಕರೆಸಿ ಇವ್ರನ್ನ ಯಾರು ಇಂಪಾರ್ಟಿಂಗ್ ಕರೆಸಿ ಅಫಿಡೇಟ್ ಮಾಡಿಸಿಬಿಡಿ. ತೊಗೊಂಡ್ಬಿಟ್ರೆ ಆಯ್ತು. ಪಾಸು.
In the course of the day.
ಪಾಸು.
Great.
May I submit one thing? I'm ready with the facts of the matter, my lords. I'm not carried judgments, my lords. If my lords may, I'm ready with the matter, my lords.
ಎಲ್ಲ ರೆಡಿ ಅಂದ್ರೆ ಪಾರ್ಟ್ ಎಲ್ಲ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಮೇಲೆ ಯಾವ್ದನ್ನು ಮಾಡಲ್ಲ.
Oblige, my lords. I'll do.
ಇಲ್ಲ ಇದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡ್ಸ್ಕೊಂಬಂದು ರೂಲಿಂಗ್ಸ್ ಎಲ್ಲ ತುಂಬ್ರ ಅದಕ್ಕೊಂದು ಡೇಟ್ ಹಂಗೆಲ್ಲ ಕೊಡಲ್ಲ ನಾವು. People are unhappy with the courts.
My apologies.
Great.
Yes.
Lords, I appear for the petitioner. Praise 1 week time, my lords.
ಯಾಕೆ ಎಲ್ಲ ಟೈಮ್ ಕೇಳಿದ್ರೆ ಕೊಡಕ್ಕಾಗಲ್ಲ. ಇದು ಕಾರಣ ಬೇಕಲ್ಲ.
My lords,
ಡೆತ್ ಡಿಸೇಬಲ್ಮೆಂಟ್. So
I have recently joined this chamber, my lords. I have recently joined this chamber. He is suffering from a Madras eye, my lords. Today, he's suffering from
Mallikarjun Reddy is suffering.
Yes, my Madras eye, my lords.
Madras eyes. Application haki.
Please, my lords, within a week I'll come.
Call next week for compliance.
Grateful, my lords.
Yes. I'll hing brief. 1 week for compliance. Failing which petition stands rejected. Yes.
Might appear for the petitioner, my lord. Today, during the course, I will pay the process fee and PF, my lord, today, my lords.
ಯಾವಾಗ ಕೊಡ್ಬೇಕಿತ್ತು ನೀವು?
So, my last ಇದ್ರಲ್ಲಿ 15 days ಆಗಿದೆ ಸರ್. I ಕೊಟ್ಟಿಲ್ಲ ಸರ್. ಇದೇ ಇವತ್ತೇ ಕೊಡ್ತೀವಿ ಸರ್.
ಅಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿದೇನಾ?
ಇಲ್ಲ
ಇಲ್ಲ
ಇಲ್ಲ ಸರ್, ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ.
Yes. Compliance to be done within 3 days. Failing which petition stands rejected.
Please.
Yes. Karnataka Bhavan. You can appear for him, na? Resident Commissioner, New Delhi, Karnataka Bhavan. Learned EGA is requested to accept notice for respondent number 2. Petitioner to furnish copy of the petition along with all documents to the learned EGA within 1 week and file acknowledgement within 1 week in the registry. Failing which petition stands rejected. Yes. Comprehensive order. Yes. Devanathan.
Petitioner.
Respondent.
Okay. Ask madam to sit down. Please be seated.
My
Sit.
lordship,
You can sit behind also. Yeah.
my lordship, I already appeared before the committee because I have a parallel
Seating.
this one before the court hall number 4. And I'm appearing there as a 14%.
You want to appear in person here?
14%. I already appeared.
Are you ready in the matter?
I am ready with the matter.
May I request, my lords, the trial court matter is scheduled for the 16th. My senior has a difficulty. May I request Thursday?
Which place you are coming from?
My lordship,
I am asking a question. Please answer. Which place you are coming from?
I'm coming from Bangalore only.
Bangalore only? One date.
Thursday.
Otherwise, I would have said, give
My
cost.
lordship, this is an urgent matter because the proceeding before this one is posted on 16th. And this court has passed an order requesting the consumer court to stop the proceeding
Till next date of
till
hearing.
next date of hearing. So now next date of hearing is 16th in this one. And this, there are many lapses on the part of this other side.
Not, lawyer wants some time, 2024 matter. Within 1 or 2 weeks, certainly heavens will not fall down. or are they going to follow?
My lordship, this one, it is very urgent before the.
ಎಲ್ಲರಿಗೂ ಅರ್ಜೆನ್ಸಿ ಇರ್ತದೆ. ಕನ್ಸ್ಯೂಮರ್ ಮ್ಯಾಟರ್ಸ್ ನಲ್ಲಿ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇರ್ತದೆ? ಬರ್ತದೆ. ಒಂದು ಡೇಟ್ ಕೊಡೋಣ. ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಇದಾರೆ, ಆ ಡೇಟಿಗೆ ಮಾಡ್ಬೇಕು. ಪ್ಲೀಸ್ ಅಗೇನ್ ಅಂಡ್ ಅಗೇನ್ ಯು ಶುಡ್.
Consumer court matter can be taken up, and because it is
Then it will be defeated. This petition, object of filing
it is
petition.
posted for the order. Orders may be
Therefore,
destroyed or
let him not-
destroyed.
Nothing ಇಲ್ಲ. Call this matter. ಯಾವತ್ತು?
Subject to my lord's
ಅಲ್ಲ
convenience.
ನಂಗ್ ಬಿಡಿ, ನಾವ್ ಇಲ್ಲಿ ಇರಲ್ದೇ ದಿವಸನೂ ಇಲ್ಲೇ ಇರ್ತೀವಿ. ನಿಮ್ದು
Any date next week, my lords. My
Huh?
senior is unwell today. That is the only reason I am
Next
requesting.
week,
Anytime next week or Thursday, my lords, because they are saying 16th. is the
Thursday.
night. Please,
Thursday.
in my lords hands.
Thursday ಯಾವ ಡೇಟ್ ಆಗ್ತದೆ?
Date.
Thursday, I believe is
14.
14th.
No, 14th, I have matter before the total number 4th.
Oh.
13th.
13 ನಮ್ಗೆ ಬಹಳ ಮೆಟರ್ಸ್ ಇರ್ತದೆ. ಆ ರೀತಿ ಆಗಲ್ಲ. Call after 2 weeks on sides. Till then, entry order shall continue. Yes.
2 weeks date could be.
ಕೊಡಿ, ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ. Call on sides at the request of. ಡೇಟ್ ಕೊಡಿ, ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್. ಓಕೆ.
26th. May I like this?
26th?
ನಮ್ಮ ಅಣ್ಣನ ಮದುವೆ ಇದೆ. 26th.
ಓಕೆ, 26th. ಓಕೆ, ಗ್ರೇಟ್. ಅವರ್ ಟೈಮ್ ಕೇಳಬಾರ್ದು. ಪ್ಲೀಸ್ ಫೈನಲಿ, ಪ್ಲೀಸ್ ಫೈನಲಿ. ಯಸ್. ಹಾ.
My lords, I appear for the Respondent Union of India in this matter, my lords.
Yes.
My lords, in this matter, your lordships have disposed the matter since it pertains to Kaveri water dispute, my lords. Your lordships have relied on Article 262 and disposed the petition. The
Correct.
party in person has filed a recall application, my lords, and for the last many dates has not turned up. Your lordships will recollect before this very bench also on the last date he was not there.
My colleague. This court wide order dated 23/10/2024 had said as under. After noting absence of petitioner party in person. First up. That order was made to enable the party in person to come and argue, as its text would make it apparent. First up. Today also, party in person has not turned up. There is no representation either. First up, in view of the above, petition is dismissed for non-prosecution.
I'm deeply grateful.
IA for
recall
is dismissed for non-prosecution.
I'm grateful, my lords.
Respondent
ಏನಿದು
number,
ಹಿರೇಮಠದ್ದು?
land grabbing court. The respondent number 2.
There was
has
some
filed-
issue arose the last time, na? ಏನದು, what was the issue?
My
with
lordship,
this?
objection filed by him,
Ah.
rejected by the land grabbing court.
Objection to
Complaint.
complaint.
The allegation is I have encroached 13 acres 28 guntas. But I have filed an application before the Forest Rights Committee with in respect of 4 acres 20 guntas. I will restrain.
Your claim to that 4 acres.
Yes.
But committee, let committee decide. Till then, they will not take my body.
Last occasion, your lordship made.
That's what I felt. For rest of the land, you are entitled to take. Correct? Huh?
Committee will consider it. Committee, the matter pending with
Has to
committee.
consider my application.
Committee will consider.
Correct. Committee is a party here.
Not.
But committee in ಮಾಡ್ಬೇಕಲ್ಲ. Committee in party ಮಾಡಿ. Petitioner is directed to array. ಎಂತ committee ಅದು?
Forest Rights Committee of the village.
Forest Rights Committee na? Forest Rights Committee. ಯಾವ village?
Chetnahalli Gram Panchayat.
ಚಟ್ನಹಳ್ಳಿ.
Honali Taluk.
ಆಮ, ಚಟ್ನಹಳ್ಳಿ ಹೊನ್ನಾಳಿ ತಾಲೂಕಾ.
ದಾವಣಗೆರೆ
ಈ ತಾಲೂಕು ಲೆವೆಲ್ ಅಲ್ವಾ
ಅದು
ಕಮಿಟಿ?
ಪಂಚಾಯತ್ ಲೆವೆಲ್.
ಪಂಚಾಯತ್ ಲೆವೆಲ್.
ಪಂಚಾಯತ್ ಲೆವೆಲ್.
ಚಟ್ನಹಳ್ಳಿ ಪಂಚಾಯತ್ ಕಮ ಹೊನ್ನಾಳಿ ತಾಲೂಕಾ.
ದಾವಣಗೆರೆ district.
In Davangere district. First. Next. The order sheet nekak. The short grievance of the petitioner against whom the proceedings under land grabbing act ಇದೆ ಅಲ್ಲ, so and so have been taken up is as to non-consideration of his claim filed under rule, ಎಷ್ಟದು rule?
Rule 11.
Rule 11 of the Karnataka Forest, the 2000 rules ಏನದು?
Rule 7.
ಕೊಡಿ. ಕರ್ನಾಟಕ ಎಂತ ಏನು ಅನ್ಕೊಳ್ಳಿ
Rules.
ಅಲ್ಲಿದೆ ಕೊಡಿ.
Scheduled tribes and
ನೋಡಮ್ಮ, under rule 11 of recognition of forest rights.
11(1)(a).
Huh?
11(1)(a).
11(1) small a. Yes. ಅದು ನೋಡಮ್ಮ, ಅದು so and so. So, full stop. Learned counsel for the petitioner vehemently argues that when his application for regularization of an extent of 4 acres,
20 guntas.
20 guntas of land in question is pending, comma, the proceedings before the land grabbing so and so court cannot go on. First stop. Next paragraph. Learned counsel appearing for the learned AGA on request appearing for the respondents submits that the proceedings under the 2007 Act, Land Grabbing Act, and the proceedings under the rules are different from each other, and one cannot interdict the other. First, this submission he makes after noting the undertaking of learned counsel appearing for the petitioner that in respect of the claim before the committee is confined to 4 acres,
20 guntas.
20 guntas of the subject land, and rest of the land belongs to the forest department, over which he has no claims whatsoever. First, next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, we are inclined to grant a limited indulgence in the matter as under and for the following reasons. First, rules ಯಾವ yearದದು?
2008
rules.
2008.
The subject 2008 rules, 2007 rules provide certain rights to the members of scheduled tribes and other traditional forest dwellers. And in terms of that, they have made,
only
the petitioner has made an application under the provisions of Rule 11(1)(a) thereof. Full stop. The said application is stated to be pending consideration on the file of newly added respondent, now newly added respondent committee. Full stop. If the application is allowed, comma, the question of the proceedings now going on before the, at the hands of land grabbing court have to come to an end. First up, prosecuting the proceedings before the land grabbing court, therefore, need to be stalled till after the committee takes up the claim of the petitioner and decides it in accordance with law. First up, an argument to the contrary would offend the sense of justice justice, and therefore cannot be countenanced. Full stop. Only for the following reasons, Madi. And because and following continue. In the above circumstances, this petition is disposed of with the following directions. A. The respondent committee is directed to consider and dispose of petitioner's application filed under Rule 11(1)A of 2007 rules within an outer limit of 8 weeks and report compliance to the Registrar General of this court. First off, the petitioner shall fully cooperate with the proceedings before the committee without seeking one single adjournment also on any ground whatsoever. Next paragraph. The land grabbing court, so and so there, is requested to keep its proceedings in proceeding number
LGC G number 371 of 2023.
23. In suspended, in suspension till after the claim of the petitioner as mentioned above in the preceding paragraph is heard and decided. Okay, great. All contentions of the parties in the subject claim application are kept open. No course. Okay.
NBW is NBW is 10(7) ಅಲ್ಲಿ
10(7) ಇದೆಯಾ?
The learned counsel for the accused hereby directed to keep the accused present before this court next date of hearing.
Because everything is stayed now. Yes. Disposed of the matter. Intellella writ of prohibition claim ಮಾಡಬೇಕು. Okay.
Lord. Respondent, my lord, he applied for the post of graduate primary teacher, my lord.
Okay.
Respondent, my lord, applied for the post of graduate primary teacher, my lord, under 3A category, my lord.
3A.
Yes, my lord. My lord, the said post was reserved for low vision.
Physically disabled.
Yes, my lord. Under
Ocular
Disabilities Act.
disabled.
Yes, my lord. Under Disabilities Act, my lord. If my lordships may kindly peruse the notification, which is at page 74 is a relevant portion which I can point out, my lord.
74.
Please, my lord. 6th, my lords. There is a table, my lord.
ಮಂದದೃಷ್ಟಿ.
Yes, my lord. ಪರಿಶಿಷ್ಟ ಜಾತಿ ಒಂದು ಹುದ್ದೆಯನ್ನು ಮಂದದೃಷ್ಟಿ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಮೀಸಲಾಗಿದೆ.
Vertical and horizontal reservation ಇದೆ.
Yes, my lord.
Court ಹೆಂಗ್ ಟ್ರೀಟ್ ಮಾಡ್ತದೆ? Tribunal how we treated your contention.
The present respondent, my lord, she is 100% blind, my lord. The reservation is made for low vision. But my lord,
Not for blind.
No, my lord, not for blind.
How court treats this?
Please, my lord, in para 10 of the KT judgment, my lord, what it says, my lord, central
Page.
in page.
Whether blind cannot work. What is
Lord,
mandadrishti?
I have few judgments, my lord.
One
What
second.
yes,
Let us understand first.
please, my lord, please.
Not equal to blind.
Look, identification of post is required, my lord. Just because there is reservation, first of all, my lord, notification does not prescribe post for 100% blind. It says only
Blind.
low vision blind, low vision. Below 40%, if there is disability, that can be reserved for the.
Blind ಇದ್ರೆ ಕೆಲಸನ ಮಾಡಕ್ ಬರಲ್ಲ. ಅದಕ್ಕೆ ಕೆಲಸ ಮಾಡಿ ಬರ್ತದೆ ಅಂತ hold ಮಾಡೋದು. ಕ್ರಾಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಮ್ಮಲ್ಲಿ ಒಂದು ಒಬ್ಬ ಜಡ್ಜ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು. for the blind judge is appointed by us. I was in the committee. Who ಯಾರು appear ಆಗ್ತಾರೆ?
ಅಲ್ಲ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
How court has, the tribunal has the reason?
Please, my lord, in para 10, what the KAT says, my lord.
Para 10 of page.
My lord, I beg a pardon, my lord, the pagination is not done properly in my petition, my lord.
Paragraph.
Paragraph 10 of the KAT order, my lord. May I read, my lord? From a plain reading of the notification dated 9/10/2012, the orders of 29/11/2002 and 4/8/2012 specifically relied by the learned AGA as the basis of rejection of the candidature of application is untenable on the facts and law, since the said notification orders are untenable in the light of notification of 9/10/2012, which holds the field. The order of 9/10/2012 adopts the Government of India notification of 15/3/2007, in which serial number 59, in which the categories of disabled suitable for the job of primary graduate teacher, primary school teacher, teacher student of primary of elementary school in all subjects such as reading,
Correct
writing.
there.
That is what, my lord. They say
That's
that,
writing.
yes, ma'am.
Therefore,
Based on that, yes, ma'am. Based on that. But, my lord, the notification is very clear, my lord. It says,
that notification is subservient to central government notification.
may I,
That's reason that way.
there are a few judgments of Supreme Court, my lord.
Saying which year?
My lord, 2013, my lord.
Thereafter, two more judgments have come. One Tamil Nadu judge's appointment.
Please, my lord.
I think these two judgments are one, at least 2013 judgment is considered in that. Now, how?
My lord, my submission is that, my lord.
Our question is this.
Yes, my lord.
How total blindness, to borrow your words, will come in the way of discharging the duties of a teacher? Total blind person can render justice. One judge is appointed by us, another judge is appointed in Tamil Nadu. Maybe other judges are also there.
Lord,
And John Milton, who wrote great epic, The Paradise Lost and Paradise Regained, at least Paradise Lost.
Please, my
Because he wrote Paradise Regained after getting the vision.
Please.
He was a blind. And justice, goddess of justice. Of course, very recently we removed her. Our is another thing. But how this comes in the way?
My lord, this, my lord, apparently this may be taken as a precedent also, my
It will
lord.
be.
All, yes, my lord.
It will be.
My lord, if my lords may kindly see our notification, my
Your
lord.
notification, you have said,
We have
nothing
reserved,
new.
my lord, we have given reservation for 100% blind people, my lord.
For them
For the
also.
post of music teacher, there are separate
No, we are
reservation for 100% blind.
How blindness
Yes, ma'am.
will come in the way of discharge of duties of a teacher?
But the said post, my lord,
You may
deals with the teaching, my lord.
teaching blind
Social studies, social studies.
reading ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ, teach ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ವಾ? How? That you have to answer. Quoting judgment will not help. And law has much marched thereafter. 2013, 11 years ago, after that judgment,
Yes, my lord.
the Supreme Court said, the blindness does not come in the way of discharge of duties of a magistrate. And therefore that person came to be appointed.
Lord, the our notification, my lord, we have categorically reserved certain posts for 100% blind, my lord.
Which is, where is that?
That is at page 196, my lord.
196.
Please, my lord. We have categorically distinguished blind, low vision, and leprosy cured. These are the three categories of reservation, my lord, as envisaged in the Act also, my lord. Disabilities Act also, my lord.
Disabilities Act provides
1995.
it provides for
Yes, my lord.
classification of
Section
the
32.
persons on the basis of vision,
Please, my lord.
degrees of vision,
Please, my lord.
50% to minimum is 40%.
40% ಅಂತ ಹೇಳ್ತಾರೆ. Below 40%, my lord.
Now, our question is,
Please, my lord.
how
For a moment, if my lords may kindly peruse page 196, my lord. 196, we have categorically reserved certain posts for certain disabled persons. For blind, my lord, we have reserved for primary school music teacher.
ಎಲ್ಲಿದೆ?
Page 196, my lord.
Have you made any
Annexure
appointment?
R1, my lord.
96 classification ಆಯ್ತು.
ಅದೇ ಅಲ್ಲೇ hearing impaired ಅಲ್ಲಿ ಪ್ರೈಮರಿ ಸ್ಕೂಲ್ ಎಷ್ಟು ಸೆಕೆಂಡರಿ ಸ್ಕೂಲ್ ಎಷ್ಟು ಬ್ಲೈಂಡ್ ಅಂತ ಎಲ್ಲಿದೆ?
If my lords may kindly see in the table top, my lord, blind, low vision, leprosy cured. ಮೇಲ್ಗಡೆ. This is a notification.
ಅವ್ರಿಗೆ ಬೇರೆ ಇವ್ರಿಗೆ ಬೇರೆ
Yes,
ಆಗಿ
my lord. We have
reservation.
categorically that.
ಇವ್ರಿಗೆ ಎಷ್ಟು ಜನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ರಿ ಈ ಕ್ಯಾಟಗರಿಯಲ್ಲಿ?
I beg your pardon.
Have you appointed anyone under this category?
Under this, I have to take instructions, my lord, on that. But my lord, if the petitioner, if the respondent herein had applied for the post, that is primary school music teacher, she was definitely entitled for that post, my lord.
ಈ ಬ್ಲೈಂಡ್ ನಲ್ಲಿ
Please, my lord.
ಬ್ಲೈಂಡ್ ನಲ್ಲಿ ಯಾವ ರೋಸ್ಟರ್ ಪಾಯಿಂಟ್ ಅಲ್ಲಿ ಬರುತ್ತೆ?
Both.
Horizontal ಅಲ್ಲಿ ಬರುತ್ತೆ.
ಇಲ್ಲ
Yes, ma'am.
vertical horizontal ಎರಡು
Erdu-
both vertical and horizontal.
Yes,
ಅದರಲ್ಲಿ
Yes, ma'am.
ಬ್ಲೈಂಡ್ ಗೂ ರಿಸರ್ವೇಶನ್ ಮಾಡಿದೀವಿ.
low vision.
ಅವ್ರಿಗೂ ಮಾಡಿದ್ದೀವಿ separate.
ಎರಡ್ ಕಡೆ ಮಾಡಿರ್ಬೇಕು ತಾನೇ?
Yes, ma'am.
ಅದೆಲ್ಲಿ ಮಾಡಿ?
ಈ notification ಅಲ್ಲಿ there is no classification as such. Sub-classification notification ಅಲ್ಲಿ ಇಲ್ಲ. That is not done in the notification. ma'am.
ಅದ ಬ್ಲೈಂಡ್ ಮಂದ ದೃಷ್ಟಿ.
Yes, ma'am.
ಹಾ.
That is in
ಮಂದ ದೃಷ್ಟಿ
page,
ಎಲ್ಲಿದೆ? ಪೇಜ್ ನಂಬರ್
page 74.
ಮಂದ ಬುದ್ಧಿ ಅನ್ನೋ ವರ್ಡು ಇದೆ.
Page 74, my lord. The table is at page 74.
ಪೇಜ್ 74.
74, my lord.
ಅದರಲ್ಲಿ
ಅಲ್ಲಿ ಬರೇ ಮಂದ ದೃಷ್ಟಿ ಒಂದೇ ಹೇಳ್ತಾರೆ. Only low vision there, it is reserved. It is not reserved for 100% blind.
ಮೈ ಬ್ರದರ್ಸ್ ಕ್ವಶನ್ ಈಸ್
Yes, my lord.
ಇದೇ ನೋಟಿಫಿಕೇಶನ್ ದಲ್ಲಿ ಬ್ಲೈಂಡ್ ಅವರಿಗೆ ಎಲ್ಲಿ ಮಾಡಿದಿರಿ ಅಂತ ತೋರಿಸಿ.
That sub-classification is not there.
ನಾಟ್ ದೇರ್.
Not there, my lord.
ಮತ್ತೆ ಅವರಿಗೆ ಕೊಡು. ಪರಿಶಿಷ್ಟ ಜಾತಿ coupled with ಮಂದ ದೃಷ್ಟಿ.
ಪರಿಶಿಷ್ಟ ಜಾತಿ ಒಂದು ಹುದ್ದೆ ಮಂದ ದೃಷ್ಟಿ ಅಭ್ಯರ್ಥಿಗೆ there are total 3 reservations for disabled person, my lord. That is one for hearing impair, one for
That is
low vision.
3%
Yes, my lord.
in terms of act.
Yes, my lord. 3% in terms of the act. 3%. One is for low vision, one is for, my lord, hearing impaired, and one is for leprosy cured. That is how I am
But
pointing
under
out in.
this notification,
Yes, my lord.
where have you reserved for blind? Blind ಅಂತ ಇಲ್ಲಿ ಇದ್ದುಕೊಂಡು ಮಂದ ದೃಷ್ಟಿ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರೆ we would have understood.
Yes, my lord.
Blindness is a more disable element. It has more disability elements. Is it not?
Yes, my lord.
And you have not reserved for it or that person.
There is no sub-classification.
ಅದನ್ನ ಕೊಟ್ಟಿದ್ರೆ you would have justified this
Yes.
action. That's what my brother is saying.
Let
ನೀವು
notice.
ಅದನ್ನ ಮಾಡಿದ್ರೆ
Yes, my lord.
then we would have understood. Blind ಅವರಿಗೂ ಮಾಡಿದಾರಪ್ಪ ಹಂಗಾಗಿ ಹಿಂಗಿದೆ ಅಂತ.
That
ನೀವು blind ಅವ್ರನ್ನ
classification-
ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿ. The object, see, ಮಂದ
Yes.
ದೃಷ್ಟಿಯವರಿಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ಡಿಸೆಬಿಲಿಟಿ ಲೆವೆಲ್ ಕಡಿಮೆ. Somehow they can manage.
Yes, my lord.
ಬಟ್ ದೃಷ್ಟಿನ ಇಲ್ದರಿ ದೃಷ್ಟಿಹೀನರಿಗೆ ತುಂಬಾ ತೊಂದರೆ ಇದೆ.
My humble submission is that, my lord, this notification coupled with the the circular which I have produced at 196, my lord, we have categorically reserved suitable post for suitable disability, my lord. That is my submission, my lord. This submission was made before the KT also, my lord, that the particular post which is reserved for blind and low vision is different.
We're asking you now.
But, my lord,
Whether
I
this
understand,
post-
my lord,
No.
that classification is not there.
1 second.
Please, my lord.
Hold back. Whether this post
Please, my lord.
could have been reserved for blind also? Arguably, yes, because
Yes, my lord.
of your page 82.
194.
Huh?
196.
196.
Please, my
Come to 196. ಅವ್ರಿಗೆ ಏನೇನೋ ತೊಂದರೆ ಇರ್ತದೆ. ನಾವು ಹ್ಯೂಮನ್ ಆಕ್ಸ್ ನೋಡ್ಬೇಕಾಗ್ತದೆ ಅವನ್ನೆಲ್ಲ. They are differently abled people. The Supreme Court said we should not call them as handicapped at all. 196. Plus she scheduled caste.
Yes, my lord. 3.
Correct ಇದೆ court. ಏನು ಯಾವ ಪೋಸ್ಟ್ ಅದು?
This is for graduate primary teacher, social studies, my lord.
1 second. Come to 196, column 1.
Yes, ma'am.
Primary school teacher, secondary school teacher, special teacher, grade 2, drama teacher, dance teacher, music teachers.
Yes, ma'am.
Yeah, you're all, they can be blind.
This First
not this-
column, which we have shown, my lord, it is all meant for blind people, 100% blind.
Correct, but you have not done any provision for them. Had you made that provision, we'd have appreciated.
Sub-classification is not done.
Not there, will not trouble.
My lord,
Give that
notice may
post
go,
to
my
that
lord.
blind lady and belongs to scheduled caste.
Let notice go, my lord.
ಯಾದಕ್ಕೆ ಕಾರಣಲ್ದಂಗ್ ನೋಟಿಸ್ ಕೊಡಕ ಯಾರು ಅವ್ರಿಗೆ ದುಡ್ಡು ಕೊಡೋರು ಯಾರು ಲಾಯರ್
See subsequent Supreme Court judge. But my lord,
ಏನಂತೆ?
if my lords may
ಕೊಡಿ
kindly.
ಕೊಡಿ ನೀವು had you done provision for that for category also would have understood. Blind ಗೆ ಅಷ್ಟೇ ಕೊಡದಂಗಿದ್ದು ಆಕ್ಯುಲರ್ ವಿಷನ್ ಇರುವಂತವರಿಗೆ ಮೇ ಬಿ ಇನ್ ಡಿಗ್ರೀಸ್ ಮೇ ಬಿ ಲೆಸ್.
My lord.
Number 1 ಅಲ್ಲಿ
Yes.
blind ಇಂದ ಸಿಗೋದು.
ಹೌದು.
ಅದೇ
ಹಾ.
ನೀವು ಬ್ಲೈಂಡ್ ಆಮೇಲೆ ಲೋ ವಿಷನ್ ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಕೊಟ್ಕೊಂಡು ಬರ್ಬೇಕು.
ಕರೆಕ್ಟ್.
My lord, this will be.
ಕೊಟ್ಟಿದ್ರೆ
Yes.
ಈಗಾಗಲೇ ಒಂದು ಇದ್ರಲ್ಲಿ ನಾವು ಈಗಾಗಲೇ ಕೊಟ್ಟಿದೀವಿ ಅನ್ನುವಂಥದ್ದಾಗಿದ್ರೆ ಎರಡನೇದು
ಆ ಪ್ರಶ್ನೆ ಬರ್ತಿತ್ತು.
Sub-classification ought to have been done, my lord. That is there, my lord.
ಕೊಡದೇನೆ ಇದಕ್ಕೆ ಹೆಂಗ್ ಹೋದ್ರಿ?
ಅದು ಮೂಲೆಗೆ ಬರಲ್ಲ. That will be fraud on the policy.
But my lord, my submission is that, my lord, if my lords may kindly see footnote 3, see, my lord. Persons with disabilities, appointment of person with disability against vacancy in identified post, contention that post of a driver is not suitable to be manned by blind person held, a given post may be identified as suitable for one category of disability, but same could not be identified as suitable for another category entitled to benefit of reservation. Lord,
This judgment applies.
Yes, my lord.
Where for blind ಮತ್ತು ಮಂದ ದೃಷ್ಟಿ
Yes, my lord.
ಇಬ್ಬರಿಗೂ ರಿಸರ್ವ್ ಮಾಡಿರ್ಬೇಕು. ಅವಾಗ ಈ ಪ್ರಶ್ನೆ ಹೇಳ್ತದೆ. ಇವ್ರಿಗೆ ಅಷ್ಟೇ ರಿಸರ್ವ್ ಮಾಡಿ ಅವ್ರಿಗೇನು ಕೊಡದಂಗಿದ್ರೆ ಬರೋದೇ ಇಲ್ಲ. ಆ ಜಜ್ಮೆಂಟ್ ಆಗಿದೆ. ಇನ್ನರ್ ವಾಯ್ಸ್ ಆಫ್ ದಿಸ್ ಜಜ್ಮೆಂಟ್. ಐ ರೆಡ್ ದಿಸ್ ಜಜ್ಮೆಂಟ್ ಆಕ್ಚುಲಿ.
But my lord, identification of suitable post for suitable categories,
No,
that is my submission, my lord.
that's all. We understand how the suitability is lost if a person is blind because you have reserved for them also. 196.
Lord, this is for social studies, Kannada subject, my lord.
Which subject this lady will teach?
Social studies, Kannada subject, my lord.
Other candidates are ಏನ್ teach ಮಾಡ್ತಾರೆ?
Other candidates which we have reserved for blind, they are all music teacher.
No,
Yes.
no. Kindly come to that one.
196, my lord.
196. Primary school music teacher.
Yes, my lord.
Secondary school assistant grade 2 assistant master arts languages. ಹೌದಾ?
Yes, my lord.
ಹಂಗಾಗಿ even drama, how blindness will come in the way of her performing the duties of a teacher is the question. Yeah, the employer has prerogative of prescribing what should be the criteria for appointment, etc.
Yes.
But you are not a Mughal government. We are a welfare state. You can't say that. Had you provided a seat, we'd have understood. Yes, for blind also, you have made provision. You have made favorable reservation for lesser disabled.
Low vision.
Absolutely disabled or illegal.
That
How are you
reservation
going
is
to
not done.
justify that? Barkley. Please be seated.
Okay.
The state and its officers are knocking at the doors of writ court for assailing State Administrative Tribunal's order dated 21/12/2023, whereby application number 3400 of 2023 filed by the respondent bracket nalli scheduled caste dash absolutely blind complaint having been favored, relief has been accorded to her as under. No, para 17, page 33, the full para 1, 2, 3, 4 ಇದೆಯಲ್ಲ ಅಲ್ಲಿಂದ ಹಾಕಿ. Next para. The short question argued, very effectively argued by the learned AGA relates to a favorable reservation for the class of disabled candidates. Il bracket nalli partially blind manda drishti andrenu
Low vision.
low vision
Please.
bracket nalli low vision first she vehemently submits that reservation for low vision constitutes one class and reservation for the blinds constitutes another. Semicolon. This subtle difference existing between these two classes having been lost sight of, comma, the tribunal has made the impugned order and thus it has an error apparent on its face warranting interference of this court for setting the injustice at naught. First off, in support of her submission, she draws our attention to the recruitment notification dated
Dated, my lord. Dated 21/3/20.
21/3/2022, a copy whereof avails at Annexure A2, wherein first stop. 22. And other notification dated 26/7/2311.
Next.
11. Full stop. Next one. Having heard the learned counsel for learned AGA for the petitioners and having perused the petition papers, we decline indulgence in the matter. Alone sentence melgade. In support of her submission, she banked upon two decisions of the apex court with so and so, so and so. Next one. We decline indulgence in the matter in as much as it is not the case of the petitioners that a person having low vision cannot perform duties of the post to which stake is made by the respondent, who happens to be blind, as contradistinguished from a woman with low vision, Full stop. In fact, the government notification dated 26/7/2011 classifies persons of various disabilities and posts wherein they can be accommodated in the public employment. First, the very first category belongs to people with candidates with blindness. And the second is earmarked for candidates with low vision. First off, the candidates with the blindness are permitted to stake their claim for the kind of work which the candidates with the low vision can do. First, admittedly, in the subject recruitment notification of 2022, comma, no reservation is afforded for the candidates with blindness. First. Therefore, the tribunal is more than justified in banking upon the central piece of delegated legislation, namely
Notification dated 15/3/2007.
the notification dated
15/3/2007.
15/3/2005.
15/3/2005. 7.
Huh?
7, my lord.
7.
Yes, ma'am. In para 10 of the judgment.
Which should override the comparatively lesser delegated legislations, namely 2011 notification of the state. First up. Next. The vehement submission of learned counsel for the petitioners, the learned AGA appearing for the petitioners, that the kind of work which ಯಾವ ಟೀಚರ್ ಅವರು
Graduate, primary graduate, social studies teacher.
ಪ್ರೈಮರಿ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ ಹೆಂಗಿದೆ ಅದು
GPTS.
ಹ?
Graduate primary.
ನಿಧಾನವಾಗಿ ಗ್ರಾಜುಯೇಟ್ ಪ್ರೈಮರಿ
Teacher.
ಟೀಚರ್
Social studies Kannada subject.
ಸೋಷಿಯಲ್ ಸ್ಟಡೀಸ್
Teaching in Kannada. GPT ಅಂತ.
ಸೋಷಿಯಲ್ ಸ್ಟಡೀಸ್ ಟೀಚಿಂಗ್ ಇನ್ ಕನ್ನಡ.
Kannada, yes.
ಏನ್ ಬರ್ತದೆ ಸೆಂಟೆನ್ಸ್ ಹೌದು does in ordinary course cannot be discharged by persons with absolute blindness, comma, though their educational qualifications do satisfy the rule requirement, comma, is bit difficult to agree with. First off, as already mentioned above, the 2011 notification in so many words states states and the inverse secondary school assistant grade 2, comma, assistant master arts and languages who suffer from blindness. Read the sentence. Arts and language. Can accommodate blind candidates. Full stop. If that be so, it is difficult to sustain contention of the kind. First, how blindness would come in the way of discharging duties of a teacher of the kind is difficult to appreciate. First off, the history is replete with instances wherein even blind people had achieved great things. And one such instance is of John Milton, the great author of epic poems, Paradise Lost and Paradise Gained, Regained. Full stop. The apex court, which is that, where is our, the apex court in the case of so and so held that a blind person can be appointed as a judge or magistrate, and accordingly has directed such appointment, which is our court judgment. Why is he sitting in the chamber? Google out that judgment where apex court said blinds can be judges. We had a great lawyer, perhaps madam may not be knowing.
Yes, ma'am.
We had one Mr. Radha Krishna. He was a great lawyer,
Yes,
very good lawyer.
yes, ma'am.
He was assisted by his wife. He
Yes,
used to argue every page he would have read by his spouse, and he would make submission in the court. Which is that judgment? Google out. All right. In so and so, ಬರ್ದಾಕ್ಬೇಕು. ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ಎರಡು ಇದೆ. ಕೂತ್ಕೊಳ್ಳಿ.
Yes.
Be seated. Next paragraph. There is yet another aspect. The 2022 recruitment notification does not provide for reservation for the blind people, blind candidates. First up, had such reservation been provided, arguably, we could have countenanced the contention of learned AGA that the post in question is earmarked for candidates of low vision as contradistinguished from candidates with blindness. First up. Thus, the order of the tribunal has brought about social justice to the class of persons whom the nature has placed at a disadvantageous position, arguably, well, assumedly. First up. Next paragraph. Above all, having enumerated the impugned order of the tribunal, bit articulately and bit inarticulately, it cannot be faltered by juristic arguments. First up, sustaining contention of learned AGA would offend the grand policy of the state as enacted in ಯಾವ act ಅದು? Which is that
It
act?
is the Persons with Disabilities Act 1995.
ಅದಾದ್ಮೇಲೆ ಮತ್ತೊಂದು ಹೊಸ ಕಾನೂನು ಬಂದಿಲ್ವಾ?
2016 ಅಲ್ಲಿ ಇನ್ನೊಂದು ಬಂದಿದೆ.
ಬಂದಿದೆ.
2016 ಅಲ್ಲಿ ಬಂದಿದೆ.
PWD Act 2000 earlier. So ಅದು ಆಗಿದೆಯೇನು? ರಿಪೀಲ್ ಆಗಿದೆಯೇನು? ರಿಪೀಲ್ ಆಗಿದೆಯಾ? ನೋಡಮ್ಮ, erstwhile so and so and now the 2016 Act. First, action of the state and the entities which answer the definition of state under Article 12 have to be consistent with the grand policy statutorily enacted. First, in the above circumstances, this petition, one sentence, learned AGA banked upon the rulings of Supreme Apex Court in National Federation of the Blind, Supra, ಅಂತ ಮಾಡ್ಕೋಬಹುದು. ಇನ್ನೊಂದು ಯಾವುದು?
I had only produced this judgment.
ಅಷ್ಟೇ ಸರ್, ಒಂದೇ ಒಂದು. First, this aspect, this judgment is considered by the Apex Court in the subsequent decision. ಅಂತ ತೊಂಬರ್ಬೇಕು.
Yes, ma'am.
ಯಾವ್ದು ಕೊಡ್ಬೇಕು ನಮ್ಗೆ?
Please.
So and so. First, having considered the said judgment, decision, comma, Apex Court granted relief to the candidate who was suffering from absolute blindness. Blindness. First, therefore, the inner voice of this decision does not come to the aid of the petitioners. First, it hardly needs to be stated that a decision is an authority for the proposition that it lays down in a given fact matrix, and not for all that, comma, that would follow from, that would logically follow from what has been so laid down. Lord Halsbury in Quinn versus Ledham. First, in the above circumstances, this petition being devoid of merits is liable to be and accordingly rejected in limine. 2024. Disha Bhatt versus State of Karnataka and others. Not structure madam. Okay. Registry shall send a copy of this judgment to the sole respondent by speed post immediately.
One submission, my lord. The respondent applicant ought to have challenged the notification, my lord. They have only challenged the rejection endorsement.
We see ಆ ರೀತಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ the last submission of learned GGA, that in the absence of a challenge to the 2022 recruitment notification,
please,
comma, the tribunal could not have ignored the prescriptions therein, namely reservation for the candidates having low vision is difficult to countenance. First, in every case, a challenge of the kind need not be laid. First, courts, the constitutional courts are there for rendering justice to the needy and deserving, and not for maintaining jurisprudential theories, said the US Supreme Court in Davis Swines. Lord, Justice Oliver Wendell Holmes said like this. Okay. Next. Rejected. In limine, no notice to other side. Yes.
Lord, this matter pertains to 371J, my lord.
371J
please,
is
my
being argued now. Not that.
My lord, the KAT, my lord, similarly situated persons are relief is given. My lord, she belongs to local cadre, but she does not exercise her legitimate right within the prescribed
Option
period.
is not exercised.
Yes, my lord.
What we have done in such matter? That's the matter which is being argued now in the series.
My lord.
You are not aware of
No,
that?
my lord.
Yaar appear?
Allah, that, my lord, AG is appearing. That is different, my lord.
It's a
That is different.
different,
Yes, my lord.
Matter.
The one which is coming up on 22nd.
All right. Issue emergent notice, interim order as prayed for till next date of hearing.
Obliged.
The option is not exercised in terms of governor's order.
Yes, my lord.
Okay. Yes, Rao Saab. Area.
Not a peculiar reasoning.
ನೀವು
is
ಸ್ಮೈಲ್
adopted.
ಮಾಡ್ತಾ ಇದ್ರಿ ಅಂತಂದಾಗೇನೆ ನಮಗೆ ಕೇಸ್ನಾಗ ಏನಿಲ್ಲ ಅಂತ ನಾವು ಅಸ್ಯೂಮ್ ಮಾಡ್ಬೋದು. Yes.
Promotion is not accorded to the petitioner on the ground that criminal case is pending.
ಏನ್ ಚಾರ್ಜಸ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ನಲ್ಲಿ?
ಗಂಡ ಹೆಂಡತಿ ಜಗಳ ಒಂದು 12-13 ಕೇಸ್ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಇದನ್ ಇನ್ಫ್ಲೂಯೆನ್ಷಿಯಲ್ ಪರ್ಸನ್ NGO ನಡೆಸ್ಕೊಂಡು ಈ ಪ್ರಿವೇಲ್ಸ್ ಓವರ್ ಇವನ್ ದಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಅಂಡ್ ಡಿವಿಷನಲ್ ಕಮಿಷನರ್. ಅದೆಲ್ಲ ಆಗಿ he is at serial number 6 in the seniority list.
Serial number 6 in the
Seniority list of first division assistant and stenographer.
Your charges have been framed in the criminal case?
ಇಲ್ಲ ಅಲ್ಲ ಅದನ್ನ ನಾನು ಸೈಟೇಷನ್ ಈ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಎ ಲುಕ್ ಅಟ್ ಇಂಕ್ ಪೇಜ್ 21.
214 ಓದಿ. Read 214. A criminal case is deemed to have been instituted when the charges are framed, where charges are required, where in other cases where cognizance is taken. ಯಾವುದು ರೂಲ್? 214 214
ಇಂಕ್ ಪೇಜ್ 87 ನಲ್ಲಿ
ರೂಲ್ ಪೊಸಿಷನ್ ನೋಡಿ.
ರೂಲ್ ನ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿ ದಿಸ್ ಆನ್ ಕೋರ್ಟ್ ಇಂಕ್ ಪೇಜ್ 87 ಕನ್ಕ್ಲೂಷನ್ ಇಸ್ ಅಟ್ ಪ್ಯಾರಾ 6 ಆನ್ ಇಂಕ್ ಪೇಜ್ 87.
ನೋಡಿ ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದೆ ಏನಿದು?
ಹೌದು.
ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. Learned AGA is requested to accept notice for response 1, 2 and 3. Emergent notice to respond 4.
ಅಲ್ಲ ಅವ್ರ ನೋಟಿಸ್ ಅದು ಎಕ್ಸ್ಪೈರ್ಟೆ ಅವರು ಶಿ ಹ್ಯಾಸ್ ಬೀನ್ ಪ್ರಮೋಟೆಡ್.
Cognizance is taken up.
ಅಷ್ಟೇ.
What is meant by taking cognizance is the subject matter of too many decisions of the apex court.
Latest decision of division bench of the Sound Court is on record.
Application of documents and certificate.
302 ಇದೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. Unless cognizance is taken.
Taken and what the party is also passed.
ಸ್ಟೇ ಆಗೋಗಿದೆ ಅದು.
ಸ್ಟೇ ಆದ್ರೆ ಕಾಗ್ನಿಜೆನ್ಸ್ ಹೋಗಲ್ಲ.
ಅಲ್ಲ FIR ಆಗಿದೆ.
ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ, ನಾಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ. ಮೆನಿ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಇರ್ತಾವ. ಈ ಗಂಡ ಹೆಂಡತಿ ನಡುವೆ ಒಂದ್ಸರಿ ಒಂದ್ ಕೇಸ್ ಸ್ಟಾರ್ಟ್ ಆಯ್ತು ಅಂದ್ರೆ ಅದು ಸಿವಿಲ್, ಕ್ರಿಮಿನಲ್, ಡೊಮೆಸ್ಟಿಕ್
ಆಗ್ಲೇ 12-13
ಹಾಕೊಂಡು ಹೋಗ್ಬಿಡ್ತಾರೆ. ನೋಡೋಣ. ನೆಕ್ಸ್ಟ್
I pay process, date may kind be fixed.
Admission stage naga madidre your friends will mistake us. Yes. Yes. Raghavendra.
Lords, petitioner is Lords, while working as second division assistant in Boring Hospital. Lords, a complaint came to be initiated before the Lokayukta by one of the advocates stating that Lords, medical equipments and medical prescriptions and drug orders are being placed without calling for tenders. Then, my lords, an inquiry came to be, 12-3 report came to be filed, wherein, my lords, the officer responsible, medical officer, office superintendent, who have called in, my lords, have given purchase orders to random medical organization, despite without calling tenders being noticed. Nowhere, my lords, petitioner's allegations are found, but, my lords, in my lords, a general allegation is made in 12-3 report also stating that petitioner being a second division assistant while putting up note has not brought to the notice of these medical superintendent and also office superintendent, medical officer and office superintendent that there are rules stipulate calling for tenders. Then, my lords, in the year 2009, my lords, inquiry against office superintendent, medical superintendent and my lords, treasurer comes to be dropped by the government. They are the one held to be responsible. Saying under 214, my lords, 214 2B2 is affected on them.
How that will come to your rescue?
My lords, now, my lords, my lords, nowhere, my lords, in articles of charges, specific allegations are made against me. But in, my lords,
show your article.
True, my lords, I shall, my lords. Only general allegation, my lords, 1 to 9 is made. I shall show it, my lords.
How you understood them? That's the yardstick.
My lords, tribunal does not make any recommendation.
No, you have, how you have understood the article? How did you respond? Send your reply to the articles.
Shall I show the articles? Articles of charges at 239, lords, page annexure A5, volume 1.
239?
239, lords, annexure A5.
Who are you?
My lords, I am a second division assistant, DGO 9.
9.
9, my lords. Against DGO 1, 2
Satish.
and 4. Yes, my lords. Against 1, 2 and 4, who are primary level, inquiry itself is dropped.
No, that was under 214. 214-6-2.
214, 2B2.
2B.
2B2.
That
But they
again
are
will
the
not
one
come to
lords
you.
who are responsible for the reason that, my lords, entire 12-3 report is against them. Allegations against me is that, my lords, I have, while putting the office note, I have not made any mention against.
ಮತ್ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಿತ್ತು.
ನಾನು
ಇದೆಲ್ಲ ಟೆಂಡರ್ ಕರೆಯೋದಿದು ಹಾಗೆ ಮಾಡಬಾರ್ದು, ಅದು ಟ್ರಾನ್ಸ್ಪರೆನ್ಸಿ ಆಕ್ಟ್ ಎಲ್ಲ ವೈಲೇಷನ್ ಆಗ್ತದೆ ಅನ್ಕೊಂಡು ಒಂದು ನೋಟ್ ಹಾಕೋದು. ಇಟ್ಸ್ ಯುವರ್ ಡ್ಯೂಟಿ.
they are supposed to pass an orders, our ಮೇಲೆ drop ಮಾಡ್ಬಿಡ್ತಾರೆ.
What is your job? Why you are required in
for which, my lords, entire recovery is made on we FDS and SDS.
That we'll see. Where is the job chart of your post? ನಿಮ್ ಜಾಬ್ ಚಾರ್ಟ್ ನಲ್ಲಿ ಏನೇನಿದೆ, ಏನೇನ್ ಮಾಡ್ಬೇಕು ನೀವು?
My lords, job chart I have not furnished, my lords, but they have, my lords, if I may show, my lords, what in the report, my lords, what the dereliction that is in the inquiry report, what dereliction I have told. That is in para 51, my lords.
Brother,
my lords.
ನಿಮ್ ಜಾಬ್ ಚಾರ್ಟ್ ತೋರಿಸ್ಬೇಕು. ನನ್ನ ಡ್ಯೂಟಿ ಇದೆಲ್ಲ ಬರ್ತದೆ. I am not there to give tuition to my higher ups. This is my job chart. A, B, C, D, E, F, G. ಇದರಲ್ಲಿ ಬರಲ್ಲ ಇದು ಅಂತ ಬೇಕಲ್ಲ, ಅದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗ್ತದೆ ಚಾರ್ಜ್. ಇಷ್ಟು ದಪ್ಪ ಪಿಟಿಷನ್ ತಗೊಂಡು ನಾವೇನ್ ಮಾಡೋಣ? You should have said, this is the job chart. My job is not that.
Tribunal does not consider not a.
Where have you argued to consider? Tribunal cannot argue. Consider something which is not argued before.
I have told, my lords, under Rule 13, when the persons who have committed the mischief has been dropped.
That is dropped because of.
And no evidence.
2B.
Not a single evidence against me, not a single averment, at least mention of my name against me.
Charge general articles of charge ನಲ್ಲಿ ಇದೆ.
129 general.
ನೀವು ನಿಮ್ ರಿಪ್ಲೈ ಇದಾಗ how you understood that? ನಿಮ್ ರಿಪ್ಲೈ ತೋರಿಸಿ. ನಮ್ಮ ಮೇಲೆ ಏನ್ ಚಾರ್ಜ್ ಇಲ್ಲ ಹಂಗಾಗಿ ನಾ ರಿಪ್ಲೈ ಕೊಡಲ್ಲ ಅಂತ ಏನಾರ ಹೇಳಿರೋ ಅಥವಾ ಕೊಟ್ಟಿರೋ? How you understood is the factor.
Yes, I have given my detailed reply.
Anmele you have understood. Therefore you can't say it's vague.
In 12-3 reports, my lords, at 1.
Where is that your reply? Reply ತೋರಿಸಿ.
Yes, my reply, my lords will find it. One 519 to 550 notes.
19.
Second show cause notice, A19.
The second check on that.
Articles of charge.
Articles of charge, what the reply you sent?
$259 minutes page.
259.
May.
ಯಾವ paragraph?
Para 10 minutes. But lords, what I have stated is that, my lords, may I read, my lords? It is submitted that DGOs 5, 7, 8 and 9 are employees, my lords, commonly we had filed the reply, are employees of the bottom rung of the administration and they have no role in the purchase of process of drugs. As such, proposal of purchasers are initiated at a fairly higher level of administrative setup. Moreover, the investigation officer has not made any allegations specifically against the involvement of DGO 3 and 5 in the
3 and 5 new ಅಲ್ಲ 9 new.
9 ಮೇಲೂ ಇಲ್ಲ. ಅದನ್ನು ಹೇಳಿದ್ದೀನಿ.
Where is it? 3 and 5 ಮೇಲೆ ಇಲ್ಲ ಅಂದ್ರೆ 9 ಮೇಲೆ ಬರಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ ಅಂತ ನಿಮ್ ಕಂಟೆನ್ಷನ್ ಮಾಡ್ಬೋದು ಅಷ್ಟೇ ಅಲ್ವಾ? 3 and 5 are let out. Then how can you proceed against this man?
3 and 5 are FDS. I am SD.
You are not that. Anyway, sorry, accept my notice.
Against other applicants who approached this honorable court has already granted interim order.
Interim order ಕೊಟ್ಟಾರ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲಿ KT ಮುಂದೆ entry order ಇತ್ತಲ್ಲ?
ಅಲ್ಲೂ interim order
ಇತ್ತಾ?
ಇತ್ತು. One thing I want to submit, my lords. 4 applicants, including FD and SD, approached the tribunal. Tribunal only gives finding applicant 1, 2, 3. I was applicant number 4. No findings at all.
About you,
Indeed.
which paragraph it
My lords, I
is?
shall.
Show that.
My lords, may kindly come to para 26 of the tribunal order, so also 25, my lords. I'll first take my lords to 26 at page 84. Prior paragraph, my lords, tribunal takes consideration with respect to 214(1)(a), with respect to grave misconduct is concerned. 26, my lords, final paragraph at page 84. Only consider about 1 to 3, my lords.
You are still in service?
Yes, my lords. I'm still in service. As of now, my lords, I'm working in Respondent Hospital as office superintendent.
Correct. Why you left all other people? Why, what FDC, SDC will do? ಎಲ್ಲ ಸಾವಿರಗಟ್ಲೆ ತಗೊಂಡ್ರನ್ನ ಬಿಟ್ಟು ಅದು issue emergent notice. First,
What is not mentioned?
Learned Counsel seeks stay of the impugned order, contending that rest of the people who had a greater role to play in the allegations, in the matter of allegations, have been let out, scathe-free. Secondly, his client had advantage of interim order at the hands of the tribunal throughout. Thirdly, not even a whisper is made by the tribunal in upholding the implication of the petitioner, in its impugned order. First. Next part, a prima facie case is made out for granting reprieve, and therefore the interim order as prayed for is accorded to the petitioner till next date of hearing. First. Learned AG accepts is requested to accept notice for response 1, 2, 3. 4 yaru?
4 is
4, 5 rela yaru?
5 and 6, my lords, maybe they have filed another writ petition. Notice may not be necessary.
Party act madbeku.
Yakendre ಅವರು applicants ಆಗಿದ್ರು.
What 4? 4?
Lords, 4 is, my lords, 4 is also, 4, 5 and 6, they have filed independent writ.
2. Respondents, private respondents 4, 5 and 6 is dispensed with. Or co-delinquents, no? Since they were only co-delinquents in the inquiry.
They have filed independent writ petitions.
ಅಲ್ಲ, ಒಂದು ಆಸ್ಪೆಕ್ಟ್ ಬರ್ತದೆ. ಸಪೋಸ್ ಆಸ್ ಅಗೇನ್ಸ್ಟ್ ದೆಮ್ ರಿಕವರಿ ಕ್ವಾಶ್ ಮಾಡಿದರೆ ರೆಸ್ಟ್ ಆಫ್ ದ ರಿಕವರಿ ಪ್ರಪೋರ್ಷನ್ ಮೇ ವೇರಿ. ನೋಟಿಸ್ ಹೋಗಿ
ಆಗಿದೆ ಅವ್ರ ಮೇಲೂ ರಿಕವರಿ.
ಅದಕ್ಕೆ ಇರ್ಲಿ, ಸಪೋಸ್ ಇಫ್ ದೇ ಸಕ್ಸೀಡ್ ಅಂಡ್ ಯು ಆರ್ ಕಾಟ್ ಅಪ್, ಅವಾಗ ಅಮೌಂಟ್ ನಾವೆಲ್ಲ ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಎಲ್ಲ
ನಾನೇ ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ ಅವ್ರಿಗೆ ರಿಟ್ ಪಿಟಿಷನ್. ಹೌದು, ನಾನೇ ಕಂಟೆಸ್ಟ್ ಮಾಡ್ತಿದ್ದೀನಿ. ಮೇ ಬಿ ಕನೆಕ್ಟೆಡ್ ಆಲ್ ಟುಗೆದರ್ ಸೊ ದಟ್ ಇಟ್ ವಿಲ್. ನಾನು ಈ ಮ್ಯಾಟರ್ ಜೊತೆ ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರೆ 26564.
Issue emergent notice to the private respondents. First, call this matter along with WP number
26564 of 24.
Barcode. All right. ಇದರಲ್ಲಿ ಜಾಬ್ ಚಾರ್ಟ್ ಕೊಡ್ಬೇಕು. ನಿಮ್ ಸ್ಟ್ಯಾಂಡ್ ತಗೊಂಡೋದಿದ್ರೆ ಜಾಬ್ ಚಾರ್ಟ್ ಕೊಟ್ಟು ಮೇಲೆ ಹೇಳ್ಬೇಕು, ನಮ್ ಜಾಬ್ ಚಾರ್ಟ್ ನಲ್ಲಿ ಇದು ಬರೋದೇ ಇಲ್ಲ, ನಮ್ದು ಇಷ್ಟೇ ಬರ್ತದೆ. MSTC, FDC, that.
Deeply obliged.
Petitioner by me, my lords.
Happy for the response.
Yes, Mr. Kulkarni, ಏನಿದೆ?
My lords, at 2:30 it may be taken up. I will personally present.
ಅಲ್ಲ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದೆ. ಇಟ್ ಮೇ ಬಿ ಕಾಲ್ಡ್ ಆಫ್ 2 weeks minutes.
2 weeks. ನಿಮ್ಗೆ ನೋಟಿಸ್ ಆಗಿದೆ ಏನೋ?
ಇಲ್ಲ, ಆಗಿಲ್ಲ. ಫಸ್ಟ್ ಟೈಮ್
ನೋಟಿಸ್ ತಗೊಳ್ಳಿ.
ಅಡ್ವಾನ್ಸ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
You take notice.
Please.
A case for admission.
Please.
At least notice it. Issue notice. Learned
DSC has filed.
Appears for respondents.
ಅವ್ರೆ ಶಾಂತಿ ಭೂಷಣ್.
ನೀವೇ ಇದ್ದೀರಿ
ಎಲ್ರಿಗೂ
ನೀವೇ ಇದ್ದೀರಿ.
ಹೌದು.
Postal Department.
ಹೌದು. ಶಾಂತಿ ಭೂಷಣ್
Shri V. Pramod is.
ಅಲ್ಲಲ್ಲ ಶಾಂತಿ ಭೂಷಣ್
Shanti Bhushan.
ಅವರಿದ್ದಾರೆ.
That the DST is requested to accept notice for the respondents. Okay.
ಅಚ್ಚಾ
Copy ಕೊಟ್ಟಾರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ ಅಡ್ವಾನ್ಸ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
Okay.
ಇಲ್ಲ ಆಫ್ಟರ್ 2 weeks ಮತ್ತೊಂದು ಡೇಟ್ ಕೊಟ್ರೆ
Admission ಡೇಟ್ ಕೊಡೋ ಪ್ರೊಸೀಜರ್ ಇಲ್ಲ ನಮ್ಮ ಕೋರ್ಟ್ ನಲ್ಲಿ. ನೆಕ್ಸ್ಟ್.
ಬಟ್ ಬಂದು ಕಳ್ಸ್ಕೊಂಡ್ರೆ ಆಗತ್ತೆ.
50 for the petitioner.
Yes, Jagdish.
This the petitioner is the auction purchaser.
Huh? Auction buyer.
Auction purchaser. One first respondent in the year 2013. And the sale certificate was issued on the order passed by the DRT Bangalore. Subsequently, the borrower filed an appeal before the DART, Debt Recovery Tribunal.
DRAT.
It is not a speaking order as per annexure K may kindly be seen.
Not a speaking order.
So, because when the, as per annexure H, my lord, annexure H may kindly be seen, is the order passed by the DRT to refund the money. Annexure H. This was filed by the borrower because procedure was not followed according to the Surface Act.
You were also a party there.
I'm the party. The second.
You have conceded.
The party, second respondent before.
Correct. Page 47 even. Reasons andre ಏನ್ ಗೊತ್ತೇನು? There is one famous judgment of our court. Perhaps we were not born. I was not. We were not born. ಅಲ್ಲೇನಾಗಿತ್ತು ಮೈಸೂರಲ್ಲಿ he had applied for one wine shop. The commissioner, ಅವಾಗಿನ commissioner ಏನ್ ಹೇಳಿದ್ರು? ಮೈಸೂರು ರಾಜ್ಯದ ಸಾಂಸ್ಕೃತಿಕ ನಗರಿಯಾಗಿರುವುದರಿಂದ ಈಗಾಗಲೇ ಇಲ್ಲಿ ಇರುವ ಸರಾಯಿ ಅಂಗಡಿಗಳ ಸಂಖ್ಯೆಗೆ ಮತ್ತೊಂದನ್ನು ಜೋಡಾವಣೆ ಮಾಡುವುದು ತರವಲ್ಲ. He gave this reason. That was argued before the court by none other than Writ Iyengar, Venkataranga Iyengar, senior of Justice Ramajoyce, saying it is not a speaking order. They said, Justice Govind Bhatt said, it is more than a speaking order. He said, Mysore is the cultural center of the state. Number one. Two, there are many wine shops already. Of course, there is always demand for wine shops is another thing. They said, to this one more need not be added. What else is required? Speaking under volumes together bariyo agattilla. If the reason makes sense, sufficient ಅಂತ ಅವ್ರದ್ದು argument. Very famous judgment.
In this case, this money is involved. Money.
No, your stand, Jagdish. Learned counsel for the parties. Counsel is a plural. It's a singular and a plural. So your client has agreed with that.
Because this.
You are a party.
I am the party as a second respondent.
But then you have a
second respondent.
But you have agreed. Your advocate has agreed. Were you represented by advocate?
Because the order was challenged before the DRT by the borrower. I am the auction purchaser here.
No, were you a party?
I was made a party.
You were not a party.
ಇಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಅಲ್ಲಿ DRT
ಇಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದ್ರು. ಮತ್ತೆ ಹಿಂಗೆ ಹೇಳಿದಾರೆ.
ಪಾರ್ಟಿ ಮಾಡಿದ್ರು.
ಎಷ್ಟು ಅಮೌಂಟ್?
ಅಲ್ಲ, it is about 70 lakhs.
Notice for it.
Please, emergent notice.
Emergent notice.
And also fraud is also played by the bank because this property has been two charges. Now this property has given to some third party now. Money is still lying there only. ICIC Bank
no charge
ಇನ್ನೊಂದು ಕೇಸ್ ಇದೆ.
Shall be created on the subject property till next date of hearing. No alienation or encumbrance shall be created in respect of the subject property. Yeah, notice over. Yes. Yes, Rajashekar.
Kindly pass us the matter, my lords.
ಏನು ಹೇಳಿ ನೋಡೋಣ. ಒಂದು ಸ್ವಲ್ಪ ನಿಂಗೆ ಏನಾರ ಡಿಫಿಕಲ್ಟಿ ಆದ್ರೆ ನಾವು ಟೈಮ್ ಕೊಡೋಣ. ಇದೊಂದು ಅಪರ್ಚುನಿಟಿ ಅಲ್ವಾ ನಿನಗೆ? ಸೀನಿಯರ್ ಇಲ್ಲ, ಬಟ್ ಜಡ್ಜ್ ಸರಿ ಇಲ್ಲ, ಟೈಮ್ ಕೇರ್ ಪಾಸ್ ಕೇಳಿದ್ರು ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಕ್ ಬಂದೇ ಬರ್ತದೆ.
The petitioner was working as a senior health inspector
Huh.
in the office of the second respondent, third respondent.
Huh.
Later on,
Let him argue. Yes, you can assist him sitting beside. Yes, but senior sitting beside is a great embarrassment to the arguing counsel. ಏನಾಗಿದೆ ರಾಜಶೇಖರ್ ಇದ್ರೆ?
Pending inquiry suspension order, my lords.
Suspension order.
Please, my lords.
ಏನ್ ತಪ್ಪಿದೆ?
My lords, admittedly, my lords, I was on deputation, my lords, in the office of second respondent.
During that period.
During that period. My lords, they issued an order dated 5/6/2024, saying that, my lords, I am relieved from my deputation. In the show cause notice, they say, my lords, I have not accepted that relieving order, resulting in, my lords, they have issued the notice on 1/6, my lords. There was no occasion for them to issue the notice on 1/6. May I request, my lords, to kindly turn to annexure A7 for a moment, my lords. Annexure.
Relieved on when?
I was relieved by an order dated 5/6/2024.
5/6.
Yes.
1/6.
They say they have issued show cause notice. And that too.
Is applied for leave.
One
second. Give the dates. Dates.
Please,
give the dates.
Please, my lords, on 12/3/2020.
12/3/2020.
I was, my lords, deputed in the office of second respondent. And the same was further extended in the year 2022. On 12/10/2022.
12/10?
12/10/2022.
The deputation was continued.
Continued. And my lords, I was relieved from the deputation by an order dated 5/6/2024.
5/6/2024.
My lords, I applied for leave on 5/6/2024.
After receiving that order.
They have not served, my lords. Before that, I had applied for, my lords, leave.
But they took time absentia. The charge was taken in absence.
My lords, there was no question of handing over of the charge, my lords.
Anthadenilla.
Illa. My lords, they.
What is your designation?
Senior health inspector.
Senior drug inspector.
Health
inspector.
inspector. My lords, now they contend that, my lords, I have applied for leave on 5/6/2024 till 11/6/2024 and subsequently till 21/6/2024. They have sanctioned
5/6/2024
to 20th June 2024.
You were on leave.
I was on leave. My lords, there is no dispute. They have sanctioned my leave also.
They have sanctioned
They
your
have
leave
sanctioned,
also.
I have produced that also.
Leave
Annexure-
sanction ಆಗಿದೆಯಾ?
I have produced that document at annexure A6. Annexure A6, page 60.
Page
60.
60.
Page 60, kindly see, my lords, ಉಲ್ಲೇಖ ಸದರಿ ನೌಕರರ
ಪ್ರಜಾ ಮಂಜೂರು ಮಾಡಲಾಗಿದೆ. Sanction ಆಗಿದೆ.
Sanction. Now.
That goes to the earlier dates, na?
One ನಿಮಿಷ. Let me point out, my lords.
Answering our question.
Please.
ಅವ್ರಿಗೆ ನೀವು 1 ನಿಮಿಷ ಅಂದ್ರೆ ನಮ್ಗೆ ಕೇಳ್ಬಾಡ್ರಿ ಅಂತ ಹೇಳ್ದಂಗ.
ಇಲ್ಲ. Sorry.
ಏನೋ ಒಂದು ನಾವು ಓದ್ಕೊಂಡ್ ಬಂದಿರ್ತೀವಿ ಅನ್ಕೊಂಡು ಒಂದು ಪ್ರಿಸಪೋಸಿಷನ್ ಮೇಲೆ
Please. I am sorry.
ಅಲ್ಲ ಈ ಒಂದ್ಸರಿ ಲೀವ್ ಸ್ಯಾಂಕ್ಷನ್ ಆದ್ಮೇಲೆ ಬ್ರದರ್ ಯು ಕ್ಯಾನ್ ಆನ್ಸರ್ ನೋ ವಿದೌಟ್ ಹಿಸ್ ಪರ್ಮಿಷನ್ ಆಲ್ಸೋ. ಒಂದ್ಸರಿ ಲೀವ್ ಸ್ಯಾಂಕ್ಷನ್ ಆದ್ಮೇಲೆ ಅಲ್ಲಿ ಏನ್ ಉಳಿತದೆ? ಕಲ್ಪಬಿಲಿಟಿ ಎಲ್ಲಿ ಉಳಿತದೆ?
Purpose for which he had applied for leave document. What has happened is you want to page 92. For what reasons we wanted his services? When we wanted his services for cholera, incidents were more, and for want of staff, we wanted his services. Immediately applies for leave and leave. And he doesn't even take the leaving order, and that is for the dereliction of duty and misconduct.
Why did you sanction the leave? ಅದಂಗೆ
ಅಲ್ಲ ಲೀವ್ ನಾವು ಇಲ್ಲಪ್ಪ ನೀನು ಕೆಲಸ ಬಿಟ್ಕೊಂಡು ಹೋಗಿದೀಯಾ ನಿಂಗೆ ಕೊಡಲ್ಲ ನಾವು ಲೀವ್ ಅಂತ ಹೇಳ್ಬೇಕಿತ್ತು. ನೀನ್ ಕೆಲಸ ಮಾಡಕ್ಕಿದೆಯಾ ಲೀವ್ ಮೇಲೆ ಹೋಗಕ್ಕಿದೆಯಾ ನೀನು ಅಂತ ಕೇಳ್ಬೇಕಿತ್ತು. ಲೀವ್ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡಿ ಅವನ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂಡು. ವಾಟ್ ಕೈಂಡ್ ಆಫ್ ಸರ್ವಿಸ್ jurisprudence? It will write a new chapter to Rama Joyce's services under the state.
And
Learned
may
AG.
I make one request, my lord, here? Kindly turn to page 62 for a moment.
ಅಲ್ಲ ಕರೆಕ್ಟ್
ಅದಾಯ್ತು. ಅವರದ್ದೇ ಕಾಂಡಕ್ಟ್ ಹೇಳ್ತಾ ಇರೋದು ನಾನು. ನನ್ನ ಮೇಲೆ ಎಲಿಗೇಷನ್ ಕಮೆನ್ಸಸ್ ಫ್ರಮ್ 5-6.
ಕೆಳಗಡೆ ಸ್ಟೇ ಇತ್ತಾ?
ಕೆಳಗಡೆ ಸ್ಟೇ ಇರ್ಲಿಲ್ಲ. ನನಗೇನಾಗಿದೆ ಅಂದ್ರೆ ಈಗ
ನೋಟಿಸ್
3 ತಿಂಗಳು ಆಯ್ತು ಆಲ್ರೆಡಿ.
ಅಲ್ಲಿ ಬೇಗನೆ ಕೊಡ್ಸೋಣ ಅಂತ. Issue emergent notice. Learned AG is requested to accept notice for respondents.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
ನಾವು ಡೇಟ್ ಫಿಕ್ಸ್ ಹಾಕಿ ಮಾಡಲ್ಲ, ನೀವು ಬೇಗನೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ. ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟೇವೆ ಅದಕ್ಕೆ. ಲೀವ್ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡಿ ಎಂತದ್ರಿ ಅವನ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೋಬೇಕಿತ್ತು. ಹೂ ಸ್ಯಾಂಕ್ಷನ್ ಲೀವ್ ಇದೆಯಲ್ಲ, ವೈ ಯು ಸ್ಯಾಂಕ್ಷನ್ ಲೀವ್ ಅಂತ ಅವನ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೋಬೇಕು. ಅದು ಬಿಟ್ಕೊಂಡು ಇವ್ರ ಮೇಲೆ ಆಕ್ಷನ್.
ಅದ್ರ ಮೇಲೆ ಅವ್ರು ಹೇಳೋದು ಶೋಕಸ್ ನೋಟಿಸ್ 1 ವಾರಕ್ಕೆ ಕೊಟ್ಟಿದೀವಿ ಅಂತ. ಎಲಿಗೇಷನ್ ಕಮೆನ್ಸಸ್ ಫ್ರಮ್ 5-6. ದೇ ಸೇ ವಿ ಹ್ಯಾವ್ ಇಶ್ಯೂಡ್ ಶೋಕಸ್ ನೋಟಿಸ್ ಆನ್ 1-6. ಇಲ್ಲ, my life and death
such things happen in government.
ಅಲ್ಲ 11-6 I can understand. They dismiss me from service saying that you are served with showcase notice for on 1-6 for the alleged offense committed on 5-6.
Perhaps they could foresee certain things.
And that to my lord, since interestingly KSAT dismisses my application holding that I have not, my lords, given my thumb when I was on duty.
Dispensed. Within a few minutes, we are coming back. You can also have a small outing and come down.
Next week ಅಲ್ಲಿ ಇವತ್ತೈತಲ್ಲ, ಈಗ ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ವಾಪಸ್ ಮೂವ್ ಮಾಡಿ.
ಅವ್ರು ಫೀಸ್ ಕೊಟ್ರಾ? ಇವತ್ತ ನಾಳೆ
Madam, serial number 20 and 20. Next week.
Yes.
Respondent, my lord. But in this,
ಅವ್ರು ಬೇಕಲ್ಲ ಬ್ರದರ್ ಕೃಷ್ಣಮೂರ್ತಿ.
ಹೌದು. They have to update the even appeal memorandum. There are 44 respondents. I don't think they have updated it. And moreover, I have reported death of respondent number 24. It appears they are not, in 21 only I have reported it, along with the death certificate.
ಅಪೀಲ್ ಅಬೇಟ್ ಆಗಿ ಹೋಗ್ತದೆ ನಾವು ಪಾರ್ಟಿಷನ್ ಇದು
Partition suit. But they are purchasers before filing the suit.
ಪರ್ಚೇಸರ್ಸ್ ಬಿಫೋರ್
Filing this.
ಪ್ರೀ ಸೂಟ್ ಬಯರ್ಸ್ ಅವ್ರಿಗೇನು ಅಫೆಕ್ಟ್ ಆಗೋದಿಲ್ಲ
ಅಲ್ಲ ಅವ್ರು ಬರಬೇಕಾಗತ್ತೆ ರೆಕಾರ್ಡಿಂಗ್.
ಯಾಕೆ
ಲಿಮಿಟೇಷನ್ ಮೇ
ಅಲ್ಲ ಹೌ ಡಿಕ್ರಿ ವಿಲ್ ಅಫೆಕ್ಟ್ ದೆಮ್ ಇಫ್ ದೇ ಆರ್ ಪ್ರೀ ಸೂಟ್ ಬಯರ್ಸ್ ಹೌ ದೇ ಆರ್ entitled to protect their interests as they want.
It's true, but
the decree may
practically correct, but using the decree they may trouble us, trouble those this one. That's why.
ಯಾರು ಡೆತ್ ಆಗಿದ್ದೀಗ ಮತ್ತೆ ಬೇರೆ?
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 24.
24 ಸರ್ಡ್ ಅಂತಿದೆ ಜವರಯ್ಯ.
ಅದು ಅವ್ರು ತೀರೋಗಿದ್ದಾರೆ, ಜವರಯ್ಯ ತೀರೋಗಿದ್ದಾರೆ.
ಅಲ್ಲ ನೆಡ್ ಕೌನ್ಸಿಲ್ ಮಿಸ್ಟರ್ ಕೃಷ್ಣಮೂರ್ತಿ submits that respondent number 24 having died on
ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದೀನ ಮೆಮೊ
Memo
ಕೊಟ್ಟಿದ್ದೀನಿ.
having died more than a year ago.
ಹೌದು 2019 ಅಲ್ಲೇ.
Oh.
ಏನ್ ಕೊಟ್ರಿ? ಹಲೋ, ತಾವು ಬರೋದ್ರೊಳಗೆ ವೆರಿಫೈ ಮಾಡೋದು ಪುಟಪ್ ಆಗಿರ್ಲಿಲ್ಲ, ವೆರಿಫೈ ಮಾಡ್ಲಿಕ್ಕೆ ಅಂತ ನನ್ನ ಕಾಪಿನೂ ಅಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟೆ. ನಿಮ್ಮ
No issue, no issue.
21 ಅಲ್ಲೇ ಹಾಕಿದ್ದೀನಿ. ನಿಮ್ಮ ಇವ್ರ ಹತ್ರ ಕಾಪಿ ಕೊಟ್ಟೆ ನೋಡಿ, ವೆರಿಫೈ ಮಾಡ್ಲಿಕ್ಕೆ ಅಂತ ಕೊಟ್ಟೆ.
No, having died long ago and despite reporting death, his LRs having not been brought on record within 90 days, 90 days, appeal against him abates. Full stop. We agree. Accordingly, appeal against the said respondent, respondent number 24 has statutorily abated. No, 2009.
In fact,
having died more than a decade ago, that is date in 24 to 2009. 2009 ಇದ್ರೆ ಎಲ್ಲಾರು ಬರಕ್ ಬರಲ್ಲ, ಇಂಪ್ಲೀಡಿಂಗ್ ಮಾಡ್ಬೇಕು.
ಇಂಪ್ಲೀಡಿಂಗ್ ಮಾಡ್ಬೇಕು. ಅವರು ಹಾಗೆ ತಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಯಾರಿಗೋ ಮನೆಯವರಿಗೆ ಹೋಗಿರ್ಬೇಕು ನೋಟಿಸು. ಅದ್ರ ಅದೇ ಬಹುಶಃ ಇಟ್ ಮೇ ಬಿ ಗಾನ್ ಟು ಹಿಸ್ ಹೌಸ್. Somebody must have taken at that time.
ಒಂದು secondly, in one matter which Mr. G.S. Vishweshwara, the great lawyer, had argued, the question of abatement arises where a party eo nomine dies and he should be proper and necessary or proper party. Only then abates. Persons who ought to have been made parties but were not so made, in respect of them, the concept of abatement is not in.
No, abatement will not. Abatement agalla. They have to implead because now they have this one. They have.
Recall that order. Nodama, recall that order. Learned Counsel Krishnamurthy points out that the respondent number 24, who had died on 24 February 2009, being a necessary party, is LR should be impleaded. First up, there is none from the other side to respond to this submission. First up, steps to be taken in respect of deceased within 10 days.
In respect to other respondents, they may be directed to update the appeal memorandum because from 23 or 24 onwards.
Cause title to be updated by the appellant. First, call after 2 weeks. Absence of counsel for the appellant is noted. NOC obtained ಅಂತಾನೇನಿದೆ? Okay. ಅವ್ರಿಗೆ ಹೇಳಿ, ಒಂದು ಫೋನ್ ಮಾಡಿ. ಬರೀ absence of counsel for the appellant is noted. ಇನ್ನೇನ್ ಡೇಟಿಗೆ ಇದ್ರ ಇದ್ರು.
Up to 44. 44 ಇದೆ. ನಾವು ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ 44 ಆಗಿದೆ. ಅಷ್ಟೇ ಇದೆ. 44 ವರೆಗೆ ಬರಬೇಕು.
Summons was issued up to 44. I have filed the wakalat
To structure the cause list properly by showing all the parties. 41 ಅಷ್ಟೇ ಇದಲ್ಲ. 41 ತೋರಿಸ್ಬೇಕು. ಬರೀ 33 ಅಷ್ಟೇ ತೋರಿಸಲ್ಲ. Okay. Yes, ಅವ್ರಿಗೆ ಹೇಳಿ ಒಂದು ಮಾಡಿ. I'll inform. ಅಲ್ಲಿ ಅಬ್ಸೆನ್ಸ್ ಏನು ಬರೆಯೋದು ಬೇಡ. But he appears generally. ಏನೋ ಬರೀ ಗೊತ್ತಾಗಿರಲ್ಲ ಒಂದ್ಸರಿ. Yes.
I press 1 week time.
1 week time. Two weeks at the request of counsel for the appellant. All after 2 weeks.
Appealing for respondent number 4 and 5.
4 and 5. ಅವ್ರು ಬೇಕಲ್ಲ appellant ಯಾರನ್ನ ಕರ್ಕೊಂಬರ್ಬೇಕಲ್ಲ. ನಾವು ಅಬ್ಸೆನ್ಸ್ ನಡ್ಸಕ್ಕೂ ಬರಲ್ಲ. ಭಾಳ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್ ಮಾಡಕ್ಕೂ ಮತ್ತೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರೆ, ಅದೇನು ಉಪಯೋಗ ಮುಟ್ಟಲ್ಲ. Call after 2 weeks to enable counsel for the appellant to come and argue this old matter. Okay. Okay. ಬಿಟ್ರೆ ಅವ್ರನ್ನ ಕರ್ಕೊಂಬಂದ್ರೆ ನಾವೇನಾರ ಮಾಡ್ಬೋದು. ಇವ್ರು ರಿಟ್ ಪಿಟಿಷನ್ ಟೈಪ್ ಅಬ್ಸೆನ್ಸ್ನಾಗ ಮಾಡಕ್ಕೂ ಬರಲ್ಲ ನಾವು. RFA ಏನಾರ ಪಾಪ ಇಷ್ಟು ವರ್ಷ ವೇಟ್ ಮಾಡಿರ್ತಾರ, ನಾವೇನಾರ ಒಂದು ಮಾಡಿಬಿಟ್ರೆ ರಿಪೇರಿ ಮಾಡಿಕೊಡಿಕೆ ನೋಡಮ್ಮ. ಸೇಮ್ ಆರ್ಡರ್. Call this matter after 2 weeks to enable counsel for the appellant to come and argue. Yes.
Issue pertains to MACP, my lords. It's covered by the judgment of Honorable Supreme Court.
Covered by the judgment.
ಹೌದು.
ರಾಘವೇಂದ್ರ ಆಚಾರ್ಯ ಬಂದಿಲ್ಲ. ಏನದು ಮ್ಯಾಟ್ರ್?
ಇಲ್ಲ, ಅವರು MACP ನಲ್ಲಿ ಪ್ರಮೋಷನಲ್ ಹೈರಾರ್ಕಿ ಪೇ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. Milords, the applicant is seeking for promotional hierarchy pay, milords. In MACP, it's only the grade pay which is there, milords. It won't be a promotional hierarchy. That's the only issue.
It's only compensatory.
ಅಲ್ಲ,
Promotion ಇಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಕೊಡ್ತಾ ಇದಾರೆ ಅದನ್ನ MACP.
ಪ್ರಮೋಷನ್ ಇಲ್ಲ, ಸ್ಟಾಗ್ನೇಷನ್ ತಪ್ಪಿಸೋದಕ್ಕೆ ಫೈನಾನ್ಷಿಯಲ್ ಅಪ್ಗ್ರೇಡೇಷನ್ ಮಾಡ್ತಾರೆ. MACP ನಲ್ಲಿ ಏನಂದ್ರೆ ಗ್ರೇಡ್ ಪೇ ಮಾತ್ರ ಕೊಡ್ತಾರೆ, ಪ್ರಮೋಷನಲ್ ಹೈರಾರ್ಕಿ ಪೇ.
ರಾಘವೇಂದ್ರಾಚಾರ್
ರೆಸ್ಪಾಂಡೆಂಟ್.
ಹಾ ಹೇಳಿ.
ನಾನು ಹೇಳೋದು MACPಗೆ ಪ್ರಮೋಷನ್ ಕೇಳೋದು. ಅದನ್ನು ಆಸ್ ಪರ್ ಜಡ್ಮೆಂಟ್ ಆಫ್ ದಿ ಪಂಜಾಬ್ ಹರಿಯಾಣ ಹೈಕೋರ್ಟ್, you directed to consider my claim. It is for them now to consider. That's all the point.
Supreme Court.
Because more judgments cannot be say automatically. This is case started according to the law prevailing as on that date. Subsequent decision will not come in the aid of the to review the matters which are concluded.
ಅದು MACP ಒಂದು ಮ್ಯಾಟರ್ ಮಾಡಿದ್ವಲ್ಲ, ವಿಕ್ರಮ್ ಫಡ್ಕೆ.
ಇಲ್ಲ, ಅದು ಬರಲ್ಲ, ಅದಾಗಲ್ಲ. ನಾನು ತೋರಿಸ್ತೀನಿ ಬೇಕಾದ್ರೆ. ಪೇಜ್ ನಂಬರ್ 19
ಜಜ್ಮೆಂಟ್ ಇದೆ ನಿಮ್ಮ ಹತ್ರ?
ಅದಿಲ್ಲ, ಮೋಹನ್ ನಾಯರ್ ಜಜ್ಮೆಂಟ್ ಇದೆ. ವೇರ್ ಕ್ಲಿಯರ್ಲಿ ಸೇಸ್ ಪ್ರಮೋಷನಲ್ ಹೈರಾರ್ಕಿ ಇದು ಬರಲ್ಲ, ಗ್ರೇಡ್ ಪೇ ಅಂತ ಹೇಳಿ. ಮೇ ಜಸ್ಟ್ ಪಾಯಿಂಟ್ ಔಟ್ ದಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮಿಲೋಸ್. ಪೇಜ್ 31. ಒಂದ್ ನಿಮಿಷ, ಇದು ಪ್ರಯರ್
ಫಡ್ಕೆ ಕೇಸ್ ನೀವಿದ್ರಿ?
ಇಲ್ಲ ಇಲ್ಲ.
Have you seen that judgment at least?
I did not, but there was merger, my lords, merger, and one is to be ignored. ಇಲ್ಲಿ ಆತರ ಇಲ್ಲ. ತಾವು ಒಂದೇ ನಿಮಿಷ ಪೇಜ್ 19 ಒಂದ್ಸರಿ ನೋಡ್ಬಿಡಿ. ರಿಲೀಫ್ ವಾಟ್ ಇಸ್ sought in the present OA for a moment.
Page
19, my lords.
19.
Please.
19.
Wherefore so and so and
Is
so.
that? No,
Set
table-
aside
set
the
aside
memorandum
memorandum
dated 10/3/2014 bearing annexure A8 and issue
further
further
grants
direction
the
to grant the benefit
MACP
of
in promotional
MACP
hierarchy.
in promotional hierarchy, that is so and so. MACP scheme is also produced, my lords. That may be seen for a moment, my lords.
Page number?
I'll just point out. Page number 106, my lords.
106,
ಹೌದು. Serial number 2. First two lines ನೋಡಿದ್ರೆ
MACPS envisages merely
placement
placement in the immediate next
next
higher
higher
grade
grade
pay in the hierarchy.
ಹೌದು ಹೌದು. ನಾಟ್ ಪ್ರಮೋಷನಲ್ ಹೈರಾರ್ಕಿ ಪೇ ಅವ್ರು ಏನ್ ಕೇಳ್ತಾ ಇದಾರೆ ಅದು ಬರೋಲ್ಲ.
ಅವ್ರು ಪ್ರಮೋಷನಲ್ ಹೈರಾರ್ಕಿ ಕೇಳ್ತಾ ಇದಾರ?
ಹೌದು ಹೌದು. ಪೇಜ್ 19 ತಾವು ನೋಡಿದ್ರೆ
benefit of MACP in promotional
ಹೈರಾರ್ಕಿ ಆತ ಪ್ರಮೋಷನಲ್ ಹೈರಾರ್ಕಿ ಪ್ರಮೋಷನ್ ಏನ್ ಬರುತ್ತೆ ಹೈರಾರ್ಕಿನಲ್ಲಿ ಆದ್ರೂ ಪೇ ಕೊಡಿ ಅಂತ.
ಹಂಗ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಹಂಗ್ ಬರಲ್ಲ.
ಅದನ್ನ ಕೊಡಕ್ ಬರ್ಲಿದ್ದಕ್ಕೆ MACP ಇರ್ತದೆ. ಅಲ್ಲ, ಆ ಪ್ರಮೋಷನ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ದಿಸ್ ಇಸ್ ಕಾಂಪನ್ಸೇಟರಿ ಟು ಸ್ಟಾಗ್ನೇಷನ್.
ಪ್ರೀವಿಯಸ್ ಏನ್ ಗ್ರೇಡ್ ಪೇ ಇರುತ್ತೆ ಅದ್ರ ನೆಕ್ಸ್ಟ್ ಕೊಡ್ತೀರಿ. ಹಾ, ಗ್ರೇಡ್ ಪೇ ಮಾತ್ರ.
ಗ್ರೇಡ್ ಅಲ್ಲ, ಓನ್ಲಿ ಪೇ.
ಆ ಪೋಸ್ಟ್ ಕೊಡು, ಆ ಪೋಸ್ಟ್ ಕೊಡಲ್ಲ, ಓನ್ಲಿ ಗ್ರೇಡ್ ಪೇ ಚೇಂಜ್ ಆಗುತ್ತೆ.
ಈಗ ಏನಂತ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಾರ?
ಡೈರೆಕ್ಷನ್ ಏನಂತಂದ್ರೆ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್
ಏನ್ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ? We dispose of the present way in terms of direction contained therein. ಯಾವ direction? OA number 864 of 2014.
And grant pay
NWP passed in writ petition number by Delhi High Court. In terms of the said decision ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಹೌದು.
ಇದು decision ಏನ್ ಮಾಡಿದ್ರಿ ನೀವು?
ಅಲ್ಲಲ್ಲ, ಇದಕ್ಕೆ we had filed, my lords, there was a stay and Supreme Court, my lords, in the judgment which I passed it on, has held, my lords, at paragraph number page 31, my lords.
Contrary to what Delhi High Court has said. ಅದೇ ಮ್ಯಾಟ್ರ ಬೇರೆನಾ?
ಬೇರೆ ಬೇರೆ
ಬೇರೆ
ಬೇರೆ.
ಬೇರೆ
page 31 son. Relevant one is page 31, fourth line. 31ರಲ್ಲಿ 4ನೇ line, page 4. In the present batch of cases, my lords, got it?
Paragraph 31.
ಅಲ್ಲಲ್ಲ, page 31 son. Para 35, page 31.
Para 35.
35 ಇಂದ ಶುರು ಆಗುತ್ತೆ. Relevant one is at page 31. ಮೇಲೆ ಒಂದು 4 ಲೈನ್ ಆದ್ಮೇಲೆ in the present batch of cases, my lords.
The present batch of cases
Cases
where
where
the
the
respondents are
respondents
claiming financial upgradation in the grade pay of
promotional hierarchy,
no grounds are made out to show that the MACP scheme granting financial upgradation in the next pay is arbitrary and unjust, warranting interference. The implementation of the MACP scheme is claimed to have led to certain anomalies, but as pointed out, the MACP scheme itself is not under challenge. ಏನಿದೆ ಮುಂದೆ?
ಇಲ್ಲ, this is the and they deal with the other cases, my lords, Rajpal case and other things.
No, they are saying give the benefits of this scheme to us.
ನಾವು ಸ್ಕೀಮ್ ಕೊಟ್ಟಿದ್ದೀರಿ.
ಎಷ್ಟು ಕೊಟ್ಟಿರಿ? ಏನ್ ಕೊಟ್ಟಿರಿ? Where is that? Show that. He's not asking for promotion. Though linguistically, pleadings we have to in India.
Page 42.
Court say in India, while construing the pleadings of the parties, the common sense cannot be kept in cold storage. It's what the apex court said in Madhav India's matter. Yeah.
Let's page 42 may be seen for a moment. This is the office order of pay scale which was given, great pay things. Scheme is also
in lieu of stagnation.
How?
What you have given to him is the question.
That's what I point out. Page 42.
42. Do you agree that there is a stagnation? It's a case of stagnation. The career stagnation.
ಅಲ್ಲ, ಏನಿದೆ ಸೆಕೆಂಡ್ MACP ಕೊಟ್ಟಿದ್ದೀರಿ. We have given it grade pay of 4.6. He's asking for 5.4, which is promotional hierarchy. We are saying previous it was 4.2. Page 42 son of the paper book. It's an office order. My lords, got it? Now serial number 6 ನೋಡಿದ್ರೆ ಅದರಲ್ಲಿ ಆ page 42
divided a pay band and GP.
ಹೌದು, ಅದರಲ್ಲಿ 9,300 to 34,800 plus 4,200.
Pay band 2 is 4,200.
ಹೌದು. ಇದು ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ತಾವು ನೋಡಿದ್ರೆ ಸೀರಿಯಲ್ ನಂಬರ್ 17
summary of pay fixation.
ಹೌದು, ಅದರಲ್ಲಿ ಒಂದು 5ನೇದು 19/2008. This was the date from MACP came into effect, my lords. There, my lords, it is given a grade pay ತಾವು ನೋಡಿದ್ರೆ 4.6 ಕೊಟ್ಟಿದ್ದೀರಿ.
Grade pay is 4,600.
Previous
scheme ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
ಯಾವುದು?
MSCP scheme.
Scheme, my lords, it starts with the page 104 on, 3 onwards, my lords.
Well, even consider identical point. My memory says like that. At times it will be wrong also, but why can't we verify that? Vikram Phadke madiddu. Last week we pronounced that judgment, na? Judgment tomani. Acharya.
Oh.
Judgment and salt nodkamani. It may have some you appear agitra?
The grade pay was next hierarchical.
Next hierarchy. Hangagi, to some extent, that point is addressed by us. Vikram Phadke had appeared.
Yes.
Correct. Ad nodkyo money.
Please.
May help.
Please, my lords.
Call week of next. Learned advocates to peruse this court's judgment in WP number so and so and come back. Yes. Yes, sir.
My lord, I have a submission to make.
Yes, sir.
As I approach superannuation from railway service on 31st March 2025, the urgency of resolving my case becomes cannot be overstated rather.
Not understood. Kannadalli ಹೇಳಿ.
Yeah, I am more fluent in.
Okay. Yeah, you have.
No, what I was trying to say, my lord, I'm just left with 4 months before my retirement.
You want us to take up the matter?
Because otherwise, if my
We are agreeable to that. What
yeah,
otherwise?
my plea for quashing
Argue.
yeah becomes infructuous. That's it.
Agreed. Still you want to argue?
Sure.
Yes. When we argue with your proposal,
yeah,
no argument should be made in support of the proposal. Yes.
Well, my lord, I stand before this honorable bench as I've been removed from service without valid cause and credible evidence. The charges based on why I was removed from service is 20. Number one is unauthorized absence for a period of 319 days.
319 days.
4th of July 2010 to, rather it's 4th of July 2011 to 18th of September 2011.
How many years of service you had put?
I put in 20 plus years service at the time of my removal.
20 plus.
Yeah.
What is the qualifying service for pension and other benefits?
I understand it's 20 years.
20 years.
Yeah, and I am given a compensatory allowance by way of pension also, which I am continuing to enjoy to this date. And another charge that was
You retired on attaining age of superannuation.
It's 60 for central government employees, and which will fall on 31st March 2025. And my main plea in this writ petition is to quash the impugn Honorable CAT's order of 18th of November 2016, which had not given proper, which had failed to give a speaking order.
What were the charges?
Charges is unauthorized absence for 319 days, one, and
One is 319 days unauthorized absence.
Yes, madam.
From what to what it is? From?
It is from
411.
411.
4/11.
2010.
2010 to 18th September 2011.
To 18/9/2011.
2011, both days inclusive comes to 319 days.
11. All right, that is first charge.
That's for sure. Charge number
charge?
2 is the petitioner's refusal to accept issue of railway medical memo dated 25th of April 2012
Refusal to receive memo.
Receive the memo issued by,
What that memo
allegedly issued by the department.
Now, what is that memo? What memo
That
say?
memo was basically directing me to go before chief medical officer
Officer for
yeah,
medical-
examination before possible admittance.
refusal to accept memo or refusal to go before the medical officer?
No, refusal to accept the memo.
Accept.
Accept the memo.
You-
The fact remains the memo was not issued.
Memo dated?
Memo date 25th of April 25th of April 2011.
25,
4,
4,
2011.
2000?
11.
2011.
Yeah.
How? 18/9/2011 you were absent. Till 18/9.
Yes.
How this memo
That,
comes to be
that's
issued
the
in-
irony here, my lord.
Between one day he goes to report, my lord. There they say,
At that
please
time
go
it
for a
was-
checkup. He doesn't go.
2011.
So then the absence once again continues, my lord.
Perhaps others may come in the second session. You are free to sit here. We'll be very happy to see all of you, all great advocates, but no require. Chandrasekhar. Test. Your case is such a memo was not issued at all.
Yes.
All.
And based on these two charges,
Third charges? Only two charges.
Only two.
Only two charges. You have put in 20 years of service.
Yes, my lord.
Before during any point of these 20 years, was there any spot in your service records?
No.
ನೀವು ಹೇಳ್ಬೇಕು.
ಹಿಂದೆ ಒಂದ್ಸಲ ಇದೇ ತರ ಚಾರ್ಜ್ ಇಶ್ಯೂ ಮಾಡಿ ಎನ್ಕ್ವೈರಿ ಆಗಿ they went before CAT melody before. On the limited ground of the not giving me opportunity, the matter was remitted back.
ಮುಂದೇನಾಯ್ತು?
Once again he continued.
No, that's related to the same case, which I have made out in my written submission, on page 3. It's a double jeopardy, principle of double jeopardy. It's for the same misconduct. No, they have given, they have split the charges instead of conducting a composite hearing.
Charge memo? Which page? Are you a graduate in law?
No, I'm out of service.
Not a graduate. Have you studied law?
No, my lord. I'm a common man.
Yes. Charge memo ಎಲ್ಲಿದೆ? Where is that charge memo?
Page number 99 and 100, my lord.
99.
99 and 100.
76. Yes.
Why were you, do you agree that you were absent during that period?
Yes,
You were.
because I was forced
You
to.
admit that you were absent.
I was forced to be on absent.
Huh?
I was forced to be compelled to be on absent because.
You were compelled to be out of
Yeah, my lord, for me to report to an office, the elementary thing is they need to give me a relieving memo, or if I'm in the same office, they need to issue a posting order. None of these orders were issued till date, and in their own department inquiry, these two aspects were never substantiated with credible evidence, and it stands.
Where is
unproven.
your reply to the charges? Show your reply. Let us see how you have structured your stand.
It's in page 138.
138.
This was immediately after I was issued a charge sheet, 138, 140, 3 pages.
Where you taken up, what was your defense?
My defense is, I refused, I denied both the charges for the reason that I was not given a posting order.
Where is that?
That's the statement of defense at page.
No, this was reply, na?
This is reply, but there's a formal.
It is against
statement.
inquiry report. No, against the articles of charge.
Yes,
You have filed a reply,
yes, ma'am.
defense statement.
Yeah.
Where is that? What was the defense at the earliest point of time you had taken?
That's the same thing which I said now, 138 to 140.
138 is your representation against
After the
the
inquiry.
report,
After the inquiry.
inquiry report. When they sent articles of charge to you,
Yes,
you denied it.
yes,
How you denied it? Orally or in writing? In writing.
in writing.
When did you send? Tell the reply.
I think it's not filed here,
You're not filed. Do you have a copy of that with you?
not right now, my lord.
All right. Anywhere your reply is referred to?
But, nonetheless, I brought all these matters.
I'm asking, we are asking you. Anywhere your reply is referred to in these documents, any of these documents that you had given this reply? Report enquiry ಆದ್ಮೇಲೆ ಮಾಡಿದ್ದು ರಿಪೋರ್ಟ್ ನಾಗ ಹೇಳಿದ್ದಾನು.
Yeah, in written submission, which was the last document I submitted to this honorable court, at page 2,
Of written submission.
it's a volume containing 48 sheets. Page 2, paragraph 5. Under subheading failure to consider critical facts and legal grounds, despite detailed submissions outlining significant procedural lapses, statutory violations, and breaches of natural justice, the tribunal did not
If
fully
you,
engage
one
with.
small question to you.
Yeah.
This is a simple charge of unauthorized absence. Refusal to accept the memo served by the employer asking you to go for medical examination. If you file 90 pages written arguments, how we should work? It is impossible for the judges to work that way.
I brought this out telling that the charge number 2, which is alleged that I have refused to take railways medical memo dated 25th of April 2011.
Yes.
We
are asking you.
unproven. I mean,
We are asking you.
I said, I've been
That's all.
consistently saying that I'm not.
Listen to us. Listen, please listen to us. This is not, we are not writing thesis. We are here to render justice.
Justice.
We will read the thesis at home, that's another thing. But in a simple case of unauthorized absence and refusal to accept the memo issued by the competent authority, if you write 90 pages written argument, then how judges should work? We have to confine whole 10 days to treat only one matter, but it's not that worth.
Yes.
Because there are many, we have to ration our time.
Yeah.
We have to ration our time. We are not only 3 or 10 people in
I
the court hall. Why we should not dismiss it on the ground that you are wasting, you are abusing the constitutional court's process. Because Supreme Court said that way in one decision from Himachal Pradesh. If somebody writes very, very long pleadings, it's a ground for denying justice. That's the march of law. But otherwise, you will be wasting our time. We have to, till retirement, I have to read this. Cannot be done that way. All right. Now, anyway, you have filed it, we'll make it that one. Then what is the fault in the inquiry proceeding?
Inquiry proceedings, inquiry failed to prove or substantiate with credible evidence the alleged unauthorized.
Who were examined on behalf of the management?
There were two prosecution witnesses, 1 and 2. And both of them could not.
MW1, MW2,
PW1 and PW2.
PW1.
PW2. PW1, PW1 is Rajshekar, who is a head typist in the office of senior safety officer,
He is a typist in which office?
senior safety officer, senior DSO, divisional safety.
PW2?
He is OS grade 2 in the same office.
OS.
Yes.
OS means?
Office superintendent.
Superintendent.
Superintendent. Rather, it's called chief clerk.
By name?
Rajshekar.
No. Typist. He is also-
No, typist is Nyan Prakash. And chief clerk or OS grade 2 is Rajshekar.
PW1 is name?
Jnana Prakash.
Jnana Prakash.
Yeah, he's a head typist.
Rajshekar is OS.
OS grade 2, that is chief clerk, in the same office.
Where is their evidence and how you have cross-examined them?
I brought this out on page 130, page 37 of the written submission.
Page 1
Page 37.
of your written submission.
Yes. P1, who was brought to make a witness statement about my unauthorized absence, stated that he could not specifically state the days of my absence.
No, how they will? It's a matter lying in your special knowledge.
No. That's
Who
what,
will know?
that's what the minutes of the inquiry.
It's not that. How many days you were out of the office is known to you. You should explain. That's how courts have said.
Okay.
How you remained absent. You remained absent is admitted.
Yes.
So absence need not be proved at all. If you say there is a justification, that you have to prove, not the department.
Okay. They say that I refused to take relieving memo.
No, that's all right. We'll come to that one.
Yeah.
The first charge, we are on first charge. You admittedly, you were away from the office during the period between 4/11/2010 and 18/9/2011. This is admitted position.
Yes.
Number one.
But
What explanation you have?
But I was waiting for office direction or communication.
For so many days.
Yes, my lord.
Did you send any?
I have so many
Did you send any representation to the higher ups? Saying
Yes.
that they are not.
Yes, my lord, which
very
is
good.
coming in 226.
Dated? Pagination, page number?
One second. Yeah.
Yes.
Correspondence 2292-262.
Page number?
229-262. In the writ petition,
9. This is dated 22/10/2010.
Yes, addressed to Divisional General Manager.
22/10/2010. But you are absent from 4/11.
Yes.
How
that's
will
what
you
I-
say that in advance?
No, that's what I was about to say. This is second charge sheet which was given in connection with my overlapping of unauthorized absence period. Prior to this period, there was another charge sheet number 1 that was dated 4th of November 2010. This charge sheet is dated 31st October 2011. This charge sheet agreed by which I am before this honorable court
How-
is.
Tribunal has treated your argument. Show that.
Tribunal has said
Your contention before the tribunal, how they have treated it. Show that. Which paragraph, which page?
Para 17, my lord.
Eh?
Para 17, my lord.
Page
Page 393, my lord,
393.
393.
in the writ petition compilation.
You were working in safety department.
Yes, my lord, on deputation. My parent office is Signal and
May I
Telecommunication.
read, my lord? We have gone through the inquiry report and connected records. The inquiry
One second,
officer.
one second. Let him read it, party in person, na? Please read. Page para 17.
We have gone through the inquiry report and connected records. The officer's report states that DRM disposed of the applicant's representation with an endorsement dated 25/10/2010, directing him to continue to work under senior DSO. Thereafter, senior DSO issued a series of letters instructing the applicant to report for duty and issued a charge memo when the latter did not comply. The record shows that the applicant himself testified that he was expecting a posting order from senior DST Bangalore.
Attendance additional absent in the note, you have noted that. You only have made that endorsement.
Yes, because they did not allow me to. The crux of the matter here, my lord, I have not been given an order to report to either my parent office or to the deputed office. That's the whole issue here. Without an order, I cannot go and report to any office. Till this date, they have never issued that letter. And this was,
You were directed to come for duty. Which letter it was? You said, na, in the beginning of your submission.
Yes.
You said, they directed me to report for duty. Which is that letter?
25th April 2011.
Huh?
25th April.
25 April? No, that was a memo
It's a letter.
that directed both report for duty and go for medical test.
Yes. No, memo is different and this is.
This
This
was
letter
issued-
was specifically issued by senior DSO, safety officer, asking me to come and report to his office,
When it
which
was given?
which I,
When it was given?
page 241. 241.
241. Yes. This was issued to you by
Senior DSO,
senior divisional safety
Division
officer.
Safety Officer.
What they said?
This was in pursuant to the letter dated.
Your reply, na?
This is my reply.
No, where is that letter? 18/4/2011.
Not filed. You have, sir.
All right, we'll assume now. Go to your letter dated 25/4/2011. Now you are reading now at page number 241.
Yes,
You have received this letter.
yes,
Therefore, you have sent this reply.
yes, my lord.
You only say earlier letter was not given to me. That was your stand. Kindly come to para 3, unnumbered para 3.
I am in receipt of your memo dated so and so.
No, that's all right.
Yeah.
You said at the unnumbered third paragraph, I have neither received the said communication,
Yes.
nor the same is served on me as on date. I came to know about the exercise. So it's after the report. After you received this letter, how you responded to this?
I went to the office physically and reported with this letter.
But by that time,
Yes,
it was from 4/11/2010.
about 174 days have lapsed.
170.
Yes, and that was not due to my account, my lord.
How? How?
So they
government should
refused to
function?
give a relieving letter.
How?
My lord, first of all, I was on deputation to safety office. My parent office is signal and telecommunication, I think. So I went on deputation, duly exercising my willingness, and I was deputed. This deputation arrangement was approved by none other than the highest authority in railway division, that is DRL. So I went and reported there. On 2 occasions, I availed leave. One is 1-day casual leave on 14/9/2010.
Yes.
It's a casual leave. Still, I supported with a medical memo, which was issued by a railway medical doctor, but they never acted on that medical memo till this date on my leave application. Followed by this, after a month apart, I applied leave on sick leave for 3 days, which is permitted as per railway leave rules. That also they never acted upon. So both these leave applications till date have not been acted upon. I have the right to know the status of my leave application, whether it is granted or it is rejected. When the officer, sanctioning authority maintains silence on this, it speaks that he's biased and is prejudiced against me. That's the point I wanted to establish. Yeah.
All right.
That's
What are the mistakes in the order of the tribunal? Now inquiry proceeding has taken place. You participated in it.
Yes, yes.
You had the battle lines were drawn up.
Yes.
Is it not?
Yes, ma'am.
You were given full opportunity.
Yes, opportunity was given. But for the fact that I was not allowed to examine or cross-examine my side defense side witnesses, which is 2 officers.
Did you ask for cross-examination?
In writing, I had put in.
Where is that?
One 138, 140,
138.
142, 41.
When they were examined first?
They refused, my inquiry officer refused to entertain my request.
Sorry. When the examination in chief was over? Which date? ಯಾವತ್ತಾಗಿತ್ತು brother?
My lord, it is the inquiry report is at page number 131, my lord.
They are not, I am not asking page number. I am asking you simple English question. When examination chief?
2nd of May, 2012.
2nd of May.
Yeah, 2/5/2012.
2/5/2012.
Yes.
You, on the same day, did you ask for cross-examination?
Yes, my lord.
Where is that?
Not during the inquiry proceedings, but
Inquiry you did not ask.
no, but I was given an opportunity to come with a letter, which I did on
When,
through a
After
representative.
chief examination.
Yes,
if
ma'am.
at all
Yes,
it's examination chief.
Yes.
But no. On 2/5/2022, 2012, the PW1 was examined in chief, or two, both were,
Both.
same day,
No, on
subsequent.
specific days.
First witness of PW1 was examined on which day? All right, leave it. All right,
It's on
one second.
13th of March,
Huh?
2012. 13th of March, 2012.
13/3/2012.
2012. 12.
When did you ask for cross-examining them?
As I said, I did not ask during the proceedings, but subsequently I requested through a letter. This letter was taken into account by inquiry officer before he formulated his inquiry report.
But correct, it was not a murder or conspiracy to murder.
Yes.
Case is simple, unauthorized absence.
Yes.
For that, what cross-examine? Where you have taken up a contention? Because I was not permitted to cross-examine, I suffered prejudice. Where is that ground in your CAT application? OA? All right, where have you taken up that contention? Your reply to your representation to inquiry report.
Yes, ma'am. That's 138, 140.
You have taken that. 138 is, this is only representation.
That's a reply to the inquiry report.
Did you
On
argue
page-
that before?
Yes,
the-
yes, on page 140.
Before the CAT, did you argue that point?
I was never allowed to argue my point at all. That's a whole,
Where have you taken up that contention in your OA? Original application before the CAT. Did you take up that contention?
definitely.
Just show that. Brother, when he asked for cross-examination, did he ask for cross-examination? He did. Why did you deny that right
The
of
inquiry,
cross-examination? Huh?
the inquiry report, it says, my lord, it is denied.
Denied.
No,
Cross-examination
no,
is
the
denied.
inquiry officer said it's irrelevant.
ಏನ್ ನಿಮ್ದು ಇಂಗ್ಲಿಷ್ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದಾಗ
ಅದೇ ಅವ್ರು
ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಅಥವಾ ನಾ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ, Your Honor. They said it's irrelevant to your point.
Irrelevant to point.
Yes, what, that is the charges. But their own circular states that I should be given a due opportunity.
This is page number 133 at the bottom, my lord.
But they said, if you want to cross-examine today ಅಂತ ಹೇಳಿದ್ರು. ನೀವು ಮಾಡ್ಲಿಲ್ಲ ಅವತ್ತು. You have not done that.
I said I need time.
No, how, why? What is the needing
Wait,
time? Cross-examination.
I
if
need
it is
time, and
not
the time was granted by inquiry officer.
Disciplinary inquiry, cross-examination cannot be asked as a matter of right. Law has changed now. As a matter of right, you cannot. They have discretion whether to permit or not. If that discretion is abused, you have a cause of action. Not as a matter of right as it happens in criminal trial.
No, the main reason why I wanted these two officers to be examined is my own parent officer, that is signal and telecom engineer, had through his official communication communicated to me through RTI channel that no inquiry letter was issued to me because I was absent. So I wanted to produce this before the inquiry officer and say that I am innocent. I was not
First ground is the officers were biased.
biased and prejudiced against me.
Second one is we had no complete opportunity because you were denied opportunity to cross-examine.
Of being, a reasonable opportunity of being heard.
Party in person seeks to alter order of the CAT on the following grounds. Number one, the charge against him would not have been treated as having been established based on the evidentiary material placed on record. Number two, the opportunity of cross-examination having been denied, comma, proceedings are vitiated. Number three.
And so far as the second charge sheet is concerned, nowhere in the inquiry or in the appellate process or in the revisionary process, this matter was raised, leading to the conclusion that this was just a charge to inflate the allegations against me.
Repeat.
Charge number 2, that is refusal by the charge.
Accept the memo.
A memo was directly brought into the charge sheet before making any ground, building the case against me that I refused.
No, you were absent. You said health was not good.
I was absent. I was present on 25th April 2011. On that day.
You attended the office on that day.
Yes.
When the charge memo was issued.
Yes,
on
yes.
25 April
But they
2011.
refused to take my reporting letter. They said, no, we cannot. They made me sit in the office for half a day till first session ends. Then one section officer calls me and tells, sir, you may leave. I said, no, why should I leave? I come for reporting based on the officer's.
No, they said you should have accepted the memo. Not accepting the memo itself is a charge.
No, that memo was never issued to me, my lord. First of all, that memo, this alleged medical memo was not issued to me at all on 25th of April 2011.
Why they will say false?
As I said,
Why your officers will lie? Where is the need for them to lie as against you?
because this matter is brought much after it is brought in the charge sheet 31st of October 2011, after about 5 to 6 months. In the meanwhile, I've reported to the office with the direction of CAT. Yes. It's an afterthought version.
Yeah, please come to page 128. Read the column on the right-hand side. Read it.
I have nothing to examine.
Yes.
Since he is witness to serving a letter on 1/8/2011. This
You
is
said you
not,
will not cross-examine.
no, this is not the letter which is the.
You could have cross-examined that witness, na? He said cross-examine the witness. You did not avail that opportunity. Not availing, not.
This cross-examination was intended with regard to this specific letter 1/8.
Whichever. You could have put him some few questions in the cross-examination. You said, I will not cross-examine. Not availing the opportunity. Then complaining that no opportunity was given.
No, my lord,
How that
this is different from what I'm trying to, where I am aggrieved by not giving in a reasonable opportunity. This letter, this particular column, with respect to Jnana Prakasham, is nothing to do with my request for giving me a reasonable opportunity to make the presence of these two officers to elicit elicit evidence to prove that I am innocent.
All right.
That is a different aspect and this is different.
All right. Now, see, saying that principles of natural justice are violated because you were not given opportunity is not sufficient. You should show that it has put you to trouble. Suppose you were given opportunity, what you would have elicited by cross-examination?
Number one is I would have proved that I was never issued the relieving memo or posting memo.
Taken up that contention.
It's there.
Sure. Had I been given that opportunity, I would have established my defense. And that opportunity is not given to me. Where have you taken up that contention? You have simply said, I was not given opportunity of cross-examination.
The same page, my lord, 127.
127.
I vote to see you. Do you have any further questions to Mr. C. M. Rajshekar? He says no.
That's what, that's no, just no
you have shown
matter.
it.
So, sir.
You have not taken up that contention.
No, it's there.
Read,
Written submission, page 40.
read.
Serial N, denial of reasonable opportunity
Yes.
to defend against charge sheet, breach of constitutional safeguard under Article 311(2) of the Constitution of India. Refusal to accord reasonable opportunity to the charged employee to bring to his defense against the charges level against him in the charge memo is breach of safeguard guaranteed to a government seven
Not- you have
facing.
only said
No, no,
opportunity is not given, therefore 311.
No, I brought this in the subsequent para. Enquiry officer stands that the defense side witnesses examination is irrelevant and refuse the same, which was not cogent and substantial.
No, that's wrong though. You say, today I am not ready to cross-examine.
Yes, and here will
Not
be time.
denial of opportunity. It is denial of your prayer for time. There is difference between these two. Denial of opportunity to cross-examine is one thing. Denial of time for adjournment, etc. We also say, no, adjournment we will not give you. Because we are against adjournment. That does not per se
No.
amounts to denying
In
cross-examination.
page 127 of writ petition, which your lordship just now brought my attention to, that incident is different from what I am trying to place as aggrieved. That was refusal of charge memo.
You say, why you denied opportunity of cross-examination to him?
The inquiry officer,
Their own statutory rules, railway circular, which is which says that in case the inquiry officer refuses opportunity, he has to record reason why he is refusing opportunity, which he refused to put it down on paper.
page number 375.
370?
375, annexure F17. This is what referred in the CAT order page, para number 17.
Yes.
On 18th, on 15th, he was relieved from the safety department. He goes to signal department. On 18th, kindly on the right side tops, there's a handwritten thing, endorsement. He should continue under senior DSO. At the earliest point of time, my lord, what he is saying is that 19th, there is no order because of waiting of the order. I did not go. On the 19th order, he reads it. He doesn't acknowledge it. Then he gives this representation. Against this representation, the signal and technical department directs him to go and report to the DSO. He doesn't come. Straight away, he comes after 8 months on 25/4/2011. On that day, they ask him to go to medical report. He doesn't go. Then he continues to remain absent. Then from 20th, he works in the safety department from 20th onwards without any orders. That is what the CAT refers, my lord. You are saying that there is no order for you to transfer from signal department to safety department. If that is the case, from 20th September, how did you work?
No, I did not work. My lord, if I may be allowed to intervene. I did not work. I was waiting for relieving a letter. If I may request honorable bench's attention to page 10 of the written submission, my lord.
Apart from this, 4 letters were given, asked him to come for duty, my lord. And he works in the safety department.
What happened to his revision petition?
That is also appeal, revision, everything is went against.
Where is that? When did you dispose of that revision petition?
Revisional orders is page 270, my lord.
270. Yes. Why tribunal said come to 394?
The tribunal has made a attack observation, my lord, for the delay, my lord.
No, you have not disposed of it all.
The first short sheet, not a
Last 3 lines in the para 18.
Yes, they were given liberty to re-examine that. Till it's more than 10 years and they have not.
Wrong observations have been made against the revisional authority, my lord.
That's not true. This allegation is made by the tribunal against your department. Is true or not?
There was some delay in disposal.
Not some delay, 24 months, 2 years.
It was disposed of. Revision petition was
disposed of.
Yes,
Where is that order?
that's exactly.
270.
270.
Page number 270. Annexure C, annexure
70. 269.
216, sorry, my lord. This is the order.
Let us see. Heard, reserved. Judgment tomorrow. Good.
Serial number 28, my lord.
I am for the respondent.
28.
Next
Not
week.
ready.
Not ready, my lord. It's ready in this matter. Short accommodation.
20th. Week after next.
My lord, yes.
meeting serial number 34.
Huh?
Serial number 34.
ಏನದು ನೀವು ಕೊಟ್ರೆ ಮತ್ತೆ ಎಲ್ಲ ನಾವು ಮಧ್ಯಾಹ್ನ ಕೆಲಸ ಮಾಡೋದೇನು?
ಅಲ್ಲ ಬಾಕಿ ಎಲ್ಲ ಬಾಕಿ ಎರಡು ಮಾಡ್ತೀನಿ. ನಮ್ಮ ಸೀನಿಯರ್ ಫಾದರ್ ಇನ್ ಲಾಸ್ ಸೆರೆಮನಿ ಇದೆ ಅವತ್ತು. ನಾನೇ ಮೂವ್ ಮಾಡಿದ್ದೆ ಮೆಮೋ ಬಿಕಾಸ್ ಈಸ್ ಏಜ್ ಪೆಟಿಷನರ್ ಇಸ್ ಏಜ್ ಓಲ್ಡ್ ಅಂಡ್ ಬೆಡ್ ರಿಡನ್. ಅದು ಸೀನಿಯರ್ ಸೆರೆಮನಿ ಇದೆ, ಅದಕ್ಕೋಸ್ಕರ ನಾಳೆ ಹಾಕೊಂಡ್ರು ನಾವು ಅದೊಂದೇ ಮ್ಯಾಟರ್. ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಸ್ ಫಾರ್ ಸೀನಿಯರ್.
Next week.
Last make one submission, my lord.
Yes, sir.
Serial number 29, my lord, is
29.
29, day after tomorrow, my lord.
ಏನು ಮ್ಯಾಟ್ರ್ ಏನದು?
ಅದು the promotion sought for by the
ನಾವು
petitioner.
ಓದ್ಕೆ ಬಂದೇವೆ. No time will be granted. We have
Lama-
read the file. Again and again, we cannot read the files. They are not that beautiful, either in terms of language or law. We have read that file. We will not give time. We cannot be forced to read again and again what is not beautiful. Yes.
29, my lord, will be taken up afternoon.
59, huh?
29.
29. ಏನು ಚಂದ್ರಶೇಖರ್ ಇದರಲ್ಲಿ?
My lord, again, my lord, it's a case of interpretation of the notification issued under Article 371G of the Constitution. Where under, my lord, a reservation for Hyderabad, Karnataka area.
Correct.
My lord, was done. What happened there was, my lord, there were two categories, my lord.
Not ready for today, or you're ready for argument?
I'm ready for argument.
Afternoon?
ಅವ್ರು ಏನೋ ಪಾಪ ಅವ್ರು ಏನೋ
ಯಾರಿಗೆ ಟೈಮ್?
Respond number 6, my lord.
ನೋಡ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನದು ಹಿಯರಿಂಗ್ ಅನ್ನು
Final year. Yes,
29.
29, my lord.
You are not ready?
Not ready. Senior is some inconvenience to us.
Right, call in the first,
Friday,
third week of January.
Friday,
Request of signs. No, sir, we cannot.
Well, it becomes what happened there was that we had moved the matter. Your last may kindly fix up any day.
We have said we cannot fix a date for the other bench. Therefore, we said that way.
Oh,
last
yeah.
week.
Number single.
Sir, court officer, sir. Court officer, sir. Court officer, sir. Court officer. Court officer, sir. Court officer.
ಹಲೋ ಸರ್,
Court
ಹೇಳಿ ಸರ್.
officer, ಅದು 25 ಅರ್ಜೆಂಟ್ ಆಗಿದೆ, ಪಾಸ್ ಓವರ್ ಆಗಿದೆ, ದಯಮಾಡಿ ಹೇಳಿ ಸರ್ ಅಷ್ಟೇ.
ಅದು ಅಡ್ಜರ್ಮೆಂಟ್ ಆಯ್ತು ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 20 ಏನಾಯ್ತು? 20
20 ಔಟ್ ಕಾಸ್ಟ್ ಪೇ ಮಾಡಿದ್ರಾ?
ಸೀಲ್ ಬಟ್ 20 ಅಡ್ಜರ್ನ್ ಆಯ್ತು ಸರ್.
27
ಥ್ಯಾಂಕ್ಸ್, ಥ್ಯಾಂಕ್ ಯು.
27
39.
ಮೇಡಮ್ ನೀವಿದ್ದೀರಾ 20 ನಲ್ಲಿ?
ಯಾವ್ದು ಅಡ್ಜರ್ಮೆಂಟ್? ಅಡ್ಜರ್ಮೆಂಟ್ 28. 28 29 to third week. 29 third week of January. 34 next week. 34 next week. It is absent. All IS dismissed for non-prosecution. All IS dismissed for non-prosecution. ಅದು ಆಲ್ರೆಡಿ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ. ರೀಕಾಲ್ ನೀವು ಇರ್ಲಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ಎಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು. ಲಾಸ್ಟ್ ಟೈಮ್ ಅದೇ ಆರ್ಡರ್ ಆಗಿತ್ತು. WP ಏನಕ್ಕೆ ಯಾವಾಗಲೂ ಅಲ್ಲಿ ಬರುತ್ತೆ ಹೇಳಿ. ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಸರ್, ಮತ್ತೆ ಆ ಮೂರಕ್ಕೂ ಇನ್ನೊಂದು ಆರ್ಡರ್ ರೀಕಾಲ್ ಆಗಕ್ಕೆ ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು ನೀವು.
क्या ನಿಮ್ಗೆ ಅದೆಲ್ಲ ಬೇಕಿದ್ರೆ
next week ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಬೋರ್ಡ್ ಅಲ್ಲಿ list
ನೆಕ್ಸ್ಟ್
ಮಾಡಿ.
ವೀಕ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್
Well, at the kindly have it on tomorrow.
ಹೆಂಗೆ ನಾಳೆ ಅದೇ ಎನ್ಕ್ವೈರಿ ಅಟೆಂಡ್ ಮಾಡಬೇಕು. ಅದೇ ಎನ್ಕ್ವೈರಿ ಅಟೆಂಡ್ ಮಾಡೋದ್ರಿಂದ ಏನು ಹೊಟ್ಟೋದು ಬ್ರದರ್? ಅಟೆಂಡ್ ಮಾಡ್ಬೇಕಪ್ಪ, ಬರ್ಬೇಕು. ಅದೇನು ದೊಡ್ಡ ಪ್ರಶ್ನೆ? ಅಲ್ಲಿ ಏನು ಹೆಂಗ್ ಮಾಡ್ತಾರಾ? ಅಟೆಂಡ್ ಮಾಡಿಕೊಂಡು ಮಾರ್ಕ್ ಅಟೆಂಡೆನ್ಸ್ ಹಾಕಿ ಬರ್ಬೇಕು. ಅದು ತೊಳಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ. ಎಸ್ ಹಾ ಯಾವ್ದು 7 ಕಾಂಪ್ಲಿಮೆಂಟ್ರಿನಾ 7 ಅಲ್ಲಿ ಏನಿತ್ತು? ಆಯ್ತಾ? ಹಾ ಕರೀರಿ, ಎಲ್ಲಿದ್ದಾರೆ ನಿಮ್ಮ ಇವರು?
Appear for the petition.
ಹಾ ಏನು ಹೇಳ್ತೀನಿ ಅದು ಅವ್ರು ಮಾಡ್ತಾರೆ ಅಲ್ಲಿ ತನಕ ನೋಡ್ಕೊತೀರಿ, ಅಷ್ಟರಲ್ಲೇ ಕರ್ಕೊಂಬನ್ನಿ. ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು, ಮತ್ತೆ ಟೈಮ್ ಕೊಡಲ್ಲ ನಾವು.
Challenging the order of entrustment that has been drawn on
14A
14A, 14A, my lords, and also 12(3), my lords, on the ground that after I filing reply, there is no, my reply has not been considered. And
Not
14A
considered.
mechanically passed. Lords, if I can sum up the entirety of the incident.
ಎಲ್ಲಿದೆ? 14A ಆರ್ಡರ್ ಎಲ್ಲಿದೆ? ಪೇಜ್ ನಂಬರ್?
Lords, last annexation, lords, it is at page number
12(3) ನೋ 12(4) ರಿಪೋರ್ಟ್ ಅದು?
Lords, entrustment 14A and
No,
also
no.
12(3).
ಪ್ರಿಸೀಡೆಡ್ ಬೈ 12(3).
12(3), my lords.
ಅದು ಯಾವ್ದದು ಜಡ್ಜ್ಮೆಂಟ್? ಜಸ್ಟಿಸ್ ಶಾಂತಗೌಡ ಸಾಹೇಬ್ರದ್ದು ಅಂತ
I have carried.
ಯಾವ್ದು ಕೊಡಿಲಿ?
I have carried Justice KL Manjunath sir's judgment.
ಹಾ ಮಂಜುನಾಥ್ ಸಾಹೇಬ್ರ has followed ಶಾಂತಗೌಡ ಸಾಹೇಬ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ತಾನೆ?
Lords, he refers to
How
DCT
tribunal have
command.
considered this aspect of the matter? Show that.
My lords, my primary contention was that, my lord,
Answer the question. You are in 227.
page 53, my lords, para 7 onwards it starts.
54, huh? ಅದು ಸೈಟ್ಸ್ ಫಾರ್ಫೀಚರ್ ಮಾಡಿದ್ರಲ್ಲ, ಆ ಕೇಸ್ಗಳೇನದು? In terms of this, did you forfeit the sites allotted to various persons? ಅದೇನಾಯ್ತು ಅಂತ ಗೊತ್ತಾಗಬೇಕಲ್ಲ.
Lords, my instruction sites are not forfeited.
They have not been.
My lords,
No.
not forfeited. My apologies.
These are all 227.
True, my lords.
Instead of appeal to Supreme Court,
My lords, may
because of SP Sampath Kumar, we are treating it in WP, that's all.
My lords, may kindly check once order sheet dated 7/6/2023, my lords. My lords, while granting interim order, my primary contention, which is not at all addressed, though I have pleaded, has been addressed and interim order has been granted after calling the file from the Lokayukta. 7/6/2023 order.
You had no opportunity.
My name is not there in 12(3) report under the delinquent officials.
Correct, but 12(3) ದಲ್ಲಿ his name did not figure at all.
One, the property.
You-
necessary.
Call this matter after 4
My
weeks.
apologies, my apologies. my lord.
Call in the second week of
Lords, my
January.
apologies.
Next. Yes, next.
My apologies. my lords.
Solve. We accepted. Apology accepted. Call in third week of January. Yes.
Petition, kindly pass over the money. Pass over.
ಏನಮ್ಮ?
Pass over money.
Passover.
Is on the way.
This matter. Yeah, argue ಮಾಡಿ. Simple ಇದೆ.
Senior.
21 ಮ್ಯಾಟರ್ ನೋಡಿ, ಎಲ್ಲರೂ ಬೈತಾ ಇದ್ದಾರೆ ಜಡ್ಜ್ಗಳಿಗೆ, ಕೋರ್ಟ್ಗಳಿಗೆ ಎಲ್ಲ. ನೋಡಿ ಪೇಪರು, ನ್ಯೂಸ್ ಪೇಪರು, ವಾಟ್ಸಪ್ಗಳು ಎಲ್ಲರೂ ಜಡ್ಜಿಗೆ ಚೀಮಾರಿ ಹಾಕ್ತಾ ಇದ್ದಾರೆ. ಏನು, ನಾವು ಕೆಲಸ ಮಾಡ್ತಾ ಇಲ್ಲ, ಸಿಕ್ಕಾಬಟ್ಟೆ ರಜೆಯಲ್ಲಿ ಮಜಾ ಮಾಡ್ಕೋತಿದ್ದೀವಿ ಅನ್ನೋ ಇಂಪ್ರೆಷನ್ ಇದೆ ಜನರಿಗೆ. ನೀವು ಟೈಮ್ ತೊಗೊಳ್ಳಿ, ನಾವು ರೆಡಿ ಇದ್ದೇವೆ ಕೇಸ್ ನಡೆಸ್ತೀವಿ, ನೀವು ಬರ್ರಿಯಪ್ಪ ನಡೆಸ್ರಿ, ನಮ್ಗೆ ಬೇಕಾಗಿದ್ದು ಹಿಂಗೋ ಹಂಗೋ ಏನೋ ಒಂದು ಮಾಡ್ತೀವಿ. ದೇ ವಿಲ್ ನೋ. ನೀವು ಬಂದ್ಕೊಂಡು ಟೈಮ್ ಕೇಳಿದ್ರೆ ನಮ್ಮ ಟೈಮ್ ಎಷ್ಟು ವೇಸ್ಟ್ ಆಗ್ತದೆ ಇದರಲ್ಲಿ. ಓದ್ಕೊಂಬರ್ಬೇಕು, ಮತ್ತೊಂದ್ಸರಿ ಓದ್ಲಿಕ್ಕೆ ಆಗ್ತದ ಇವನ್ನೆಲ್ಲ? ಏನ್ ರೈಟ್, ಏನು ಕ್ವಾಲಿಟಿ ಲ್ಯಾಂಗ್ವೇಜು, ಲಾ, ಎರಡು ವಿಷಯದಲ್ಲೂ ಸಬ್ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಎಲ್ಲ. ಯಾಕೆ ಟೈಮ್ ವೇಸ್ಟ್? 4 ವರ್ಷ ಆಗಿದೆ ಇದು, 4.5 ವರ್ಷ ಆಗಿದೆ ಮ್ಯಾಟ್ರ್. ಏನ್ ಮಾಡ್ಬೇಕು? 3.5 ವರ್ಷ ಆಗಿದೆ ಮ್ಯಾಟ್ರು. ಏನ್ ಕ್ಲೈಂಟನ್ ಗತಿ ಏನು? ಲಿಟಿಗಂಟನ್ ಬರೀ ಒಂದು ಟೈಮ್ ಕೇಳೋದು, ಟೈಮ್ ಕೊಡ್ರಿ, ಅದು 2012-13 ಮ್ಯಾಟರ್, ಟೈಮ್ ಕೇಳೋದು, ಮುಂದೆ ಹೋಗೋದು. ಟೈಮ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದಾಗನೇ ಏನೋ ಒಂದು ಕಾರಿಡಾರಿಗೆ ಹೋಗಿ ಏನಾರ ಒಂದು ಮಾತಾಡೋದು. All in the third week of January 2023, on the request of learned counsel appearing for Mr. Counsel, learned counsel Mr. V.S. Naik. V.S. Naik, huh?
Yes.
All right. And but ನಾವು ಎಷ್ಟು ಕೆಲಸ ಆಗ್ತದೆ ಜಡ್ಜಸ್ಸಿಗೆ, ರಿಯಲಿ ವಿ ಟೆಲ್ ಯು, ಬಹಳ ಕೆಲಸ ಆಗ್ತದೆ ನಮಗೆ. ನಿಮ್ಗೆ ಯಾರಿಗೂ ಅವೇರ್ನೆಸ್ ಇಲ್ಲ ಎಷ್ಟು ಕೆಲಸ. ಮನೆಗೆ ಹೋಗೋದು 8 ಗಂಟೆ ಮೇಲೆ ಆಗ್ತದೆ ರಾತ್ರಿ, ಎವ್ರಿ ಡೇ. ಆಮೇಲೆ ಸ್ಯಾಟರ್ಡೆ ಸಂಡೇ ಒಂದು ರೀತಿ ಚರ್ಮ ರೋಗ ಟೈಪ್, ಕಂಟಿನ್ಯೂಯಸ್ಲಿ ಫೈಲ್ ಜೊತೆನೆ ಆಪರೇಟ್ ಮಾಡಬೇಕು, ಡಿಕ್ಟೇಷನ್ ಕೊಡಬೇಕು, ಮುಗಿಸ್ಬೇಕು, ಹೋಗಬೇಕು. ಬರೀ ಇದರಲ್ಲೇ ಆಗ್ಬಿಡ್ತದೆ. ಯಾರಿಗೂ ಪಬ್ಲಿಕ್ನವರಿಗೆ ತಿಳಿಯುವುದಿಲ್ಲ, ನೀವೆಲ್ಲ ತಿಳಿಸಿ ಹೇಳಲ್ಲ. ಜಡ್ಜ್ಗಳಿಗೆ ಭಾಳ ಕೆಲಸ ಇರ್ತದೆ. ಬಹಳ ಜನ ಜಡ್ಜಸ್ಸು ಬ್ರೈನ್ ಹ್ಯಾಮರೇಜು, ಕಿಡ್ನಿ ಫೇಲ್ಯೂರು, ಹಾರ್ಟ್ ಫೇಲ್ಯೂರ್ನಿಂದ ಡೆತ್ ಆಗ್ತದೆ. ರಿಪೋರ್ಟ್ ನೋಡಿ, 67% ಆಫ್ ಜಡ್ಜಸ್ ಡೈ ಬಿಕಾಸ್ ಆಫ್ ದೀಸ್ ಪ್ರೈಮರಿ ಡಿಸೀಸಸ್. These are all associated with sedentary habits because very long time we sit here. ಬಹಳ ಕೆಲಸ ಇರ್ತದೆ, ನೀವು ಹೇಳಲ್ಲ. ನಿಮ್ಮ ಕ್ಲೈಂಟ್ಸ್ಗೆಲ್ಲ ಹೇಳಬೇಕು, ಪಬ್ಲಿಕ್ಕಿಗೆ ಹೇಳಬೇಕು, ಸಂಜೀವ್ ತಿಳಿಸಿ ಹೇಳಬೇಕು. ಭಾಳ ವರ್ಕ್ ಇರ್ತದೆ ಜಡ್ಜಸ್ಸಿಗೆ, ತುಂಬ ಕೆಲಸ ಇರ್ತದೆ. ಅಲ್ಲ, ನಮ್ಗೆ ಬಿಡಿ ಥ್ಯಾಂಕ್ಸ್ ಏನು ಬೇಕಿಲ್ಲ, ಯಾಕಂದ್ರೆ ನಮ್ಗೆ ಸಾಕಷ್ಟು ಸ್ಯಾಲ್ರಿ, ಪರ್ಕ್ಸು ಎಲ್ಲ ವ್ಯವಸ್ಥೆ ಇರ್ತದೆ, ಇಲ್ಲ ಅಂತಲ್ಲ. ಆದ್ರೆ ಬಹಳ ಕೆಲಸ ಇರ್ತದೆ, ಮುಗಿಯೋದಿಲ್ಲ, ಕೆಲಸನೇ ಮುಗಿಯಲ್ಲ ನಮ್ದೆಲ್ಲ. ಆಮೇಲೆ ಪ್ರತಿ ದಿವಸ ನಾವು ಕೆಲವರು ಅವತ್ತಿನ ಆರ್ಡರ್ಸ್ ಅವತ್ತೇ ಸೈನ್ ಮಾಡಿ ನಂತರ ಮನೆಗೆ ಹೋಗುವಂಥ ಹ್ಯಾಬಿಟ್ನಲ್ಲಿ ಭಾಳ ಜನ ಇದ್ದೀವಿ. ಆ ರೀತಿ ಮುಗಿಯೋದಿಲ್ಲ ಅದು. ನೀವು ಇಂಥ ಓದ್ಕೊಂಬಂದು ಕೇಸ್ನಲ್ಲಿ ನೀವು ಟೈಮ್ ಕೇಳಿದರೆ ನಾವೇನು ಮಾಡ, ಅಥವಾ ಈ ಬೆಂಚ್ ಬೇಡ ಅಂತ ನೀವು ಹೇಳ್ಬಿಟ್ರೆ ನಾವು ಇನ್ನೊಂದು ಬೆಂಚ್ಗೆ ಹಾಕಿರಿ ಅಂತೀವಿ. ಅದನ್ನು ನೀವು ಸರಿಯಾಗಿ ಹೇಳಲ್ಲ, ನಮಗೆ ಎಲ್ಲ ಅರ್ಧ ಹೇಳ್ತೀರಿ. ಎನಿವೆ, ಆಫ್ಟರ್ ಕೇಶನ್ ಯಾವುದೇ ಕೇಸ್ ಇದ್ರೂ ನಾವು ರೆಡಿ ಇದ್ದೇವೆ. ಎನಿ ಕೇಸ್ ವಿ ಆರ್ ರೆಡಿ ಟು ಟೇಕ್ ಅಪ್. ಬಂದು ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕಷ್ಟೇ. ಯಾರಾದರೂ ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ರಿ. ಆ ಅಡ್ವೊಕೇಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಯಾರನ್ನಾರ ಕಳಿಸಿದ್ರು, ವಿ ವಿಲ್ ಹಿಯರ್, ವಿ ವಿಲ್ ಮೇಕ್ ಅವರ್ ಓನ್ ರಿಸರ್ಚ್ ಆ್ಯಂಡ್ ವಿಲ್ ಡಿಸೈಡ್ ದ ಮ್ಯಾಟರ್ಸ್. ಟೈಮ್ ಕೇಳಬಾರ್ರಿ ದಯಮಾಡಿ. ಪಬ್ಲಿಕ್ಕಿಗೆ ಭಾಳ ರಾಂಗ್ ಒಪಿನಿಯನ್ ಆಗ್ತದೆ. ಅದರಲ್ಲಿ ನಾವು ಶಾಮೀಲಾಗಿವಿ ಅಂತ ತಿಳ್ಕೊತಾರೆ ಟೈಮ್ ಕೊಡೋದ್ರಲ್ಲಿ. ನಾವು ಜಡ್ಜಸ್ ವಿ ಆರ್ ಅಗೇನೆಸ್ಟ್ ಗಿವಿಂಗ್ ಟೈಮ್. ನಮಗೆ ಕೂಡಲೇಬೇಕು. ನಾವು 4:15 ತನಕ ಕೂಡ್ತೀವಿ. ಯಾವ ಕೇಸ್ ಇದೆ ನಡೆಸ್ತೀವಿ. ನೀವು ಕೋಆಪರೇಟ್ ಮಾಡಬೇಕು. ಮೆಂಬರ್ಸ್ ಆಫ್ ದಿ ಬಾರ್ ಶುಡ್ ಕೋಆಪರೇಟ್. ಬಂದು ಬರೀ ಟೈಮ್ ಕೇಳೋದಲ್ಲ. ಏನು ಎಲ್ಲ WP ಅಪ್ಪ, ಏನಿದ್ರೆ ಏನು ಕೇಶವಾನಂದ ಭಾರತಿ ಇರ್ತದ? 2-4 ರೂಲ್ಸ್ ಇರ್ತಾವು, ಮುಗೀತು. ಎಸ್,
For the petitioners.
Yes.
This issue involved is pertaining to the MACP, my lords. If there is stagnation, they will
Admission,
get ಇಲ್ಲ ಫೈನಲ್ ಹಿಯರಿಂಗ್.
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಸರ್ವಿಸ್ ಆಗಿದೆ ಏನವರು?
ಸರ್ವಿಸ್ ಆಗಿದೆ.
ಏನಪ್ಪ ಇದು ಪ್ರಮೋದ್ ಏನಿದೆ?
MACP ಅವರು he has got 1 promotion, my lords, and 2 financial upgradation erstwhile, whatever it was there earlier available, my lords. My lords may kindly take up page 82 for a moment, my lords. It has the details of service of the applicant respondent. Page 82 ನಲ್ಲಿ brief history of the case ಅಂತ ಇದೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ he was
brief history of the case ಅಂದ್ರೆ ನಮಗೆ brief history of universe ಸ್ಟೀಫನ್ ಹಾಕಿಂಗ್ in book ನೆನಪಾಗ್ತದೆ. Yes.
First one, appointed as postman, 21/3/1971 he was appointed, my lords. After that, my lords, he has got he has got one promotion as postal assistant. That is 2/4/1976. ಅದಾದ್ಮೇಲೆ erstwhile ಅವಾಗ TBOP ಅಂತ ಇತ್ತು, financial upgradation. That he has
Because
got-
of stagnation.
ಹೌದು. That he has got it on 2/4/1992. ಅದಾದ್ಮೇಲೆ ಇನ್ನೊಂದು financial upgradation is the biennial cadre review ಅಂತ ಹೇಳಿ. That he has got it on 1/7/2002.
ಅವ್ರ grievance ಏನು?
Our grievance ಏನಂತಂದ್ರೆ, he is trying to say that under the MACP there are 3 financial upgradation which is available.
ಅದು
So-
ಟೈಮ್ ಬೌಂಡ್ ಒನ್ ಪ್ರಮೋಷನ್ ಅಂತಂದ್ರೆ ಪ್ರಮೋಷನ್ ಆಫ್ ಪೇ ಸ್ಕೇಲ್,
financial upgradation.
ನಾಟ್
ಅಲ್ಲ ಪ್ರಮೋಷನ್ ತರ ಇಲ್ಲ, ಟೈಮ್ ಬೌಂಡ್.
Okay.
As for the time bound melons, one financial upgradation is given. Even BCR is also
ಇದೇನು ಬೈನಿಯಲ್ ಕೇಡರ್ ರಿವ್ಯೂ ಅಂದ್ರೆ ಏನು?
ಸೇಮ್. ಅದು ಫೈನಾನ್ಷಿಯಲ್ ಅವಾಗ ಅಷ್ಟವೇಲು TBOP ಮತ್ತೆ BCR ಅಂತ ಅಂದ್ರೆ ಆತರ ಫೈನಾನ್ಷಿಯಲ್ ಅಪ್ಗ್ರೇಡೇಷನ್ ಹೆಸರಿತ್ತು. ಆಫ್ಟರ್ 12 years or 16 years ಅದಾದ್ಮೇಲೆ ಅದು ಕೊಟ್ಟಿದ್ದೀರಿ. ನಾವೇನ್ ಹೇಳ್ತಾ ಇರೋದು ಅಂತಂದ್ರೆ, ಇನ್ ಹಿಸ್ ಎಂಟೈರ್ ಸರ್ವಿಸ್ ಈಸ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ ಟೋಟಲಿ 3 financial upgradation and he has got 1 promotion, 2 financial upgradation. So that should be suffice. It can't be more than 3 financial upgradation because it says 10, 20, 30 years ಅಂತ financial upgradation MACP ನಲ್ಲಿ ಇರೋದು 3. ಇಲ್ಲಿ ಅವ್ರಿಗೆ ಒಂದು ಪ್ರಮೋಷನ್ ಸಿಕ್ಕಿದೆ, 2 ಫೈನಾನ್ಷಿಯಲ್ ಅಪ್ಗ್ರೇಡೇಷನ್ ಸಿಕ್ಕಿದೆ. ಸೊ that would be the end of that financial upgradation. ಪ್ರಮೋಷನ್ಸ್ ನೆಕ್ಸ್ಟ್ ಏನಾದ್ರು ಇದ್ರೂ ಸಿಗುತ್ತೆ. ಫೈನಾನ್ಷಿಯಲ್
ಮೋಷನ್ ಅಂತ ನೀವು ಅಲ್ಲಿ ಹೇಗೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೋದು? ಈ ಫೈನಾನ್ಷಿಯಲ್ ಅಪ್ಗ್ರೇಡೇಷನ್ಸ್ ಆರ್ MACP that won't apply to promotions.
No, that is
Once he was promoted on in 1976.
2476.
That cannot be considered to be a financial upgradation due to the stagnation.
ಅಲ್ಲ, ಅಲ್ಲಿ ಏನಾಗ್ಬಿಡುತ್ತೆ, ಅವ್ರಿಗೆ ಒಂದು ಪ್ರಮೋಷನ್ ಸಿಕ್ಕಿದಾಗ there won't be stagnation. He will get a higher pay as per that promotion.
No, consider it from 1976.
ಹೌದು. ಅದಾದ್ಮೇಲೆ
ಒಂದೇ ಎರಡೇ ಆಗಿರೋದು.
2 ಕೊಟ್ಟಿದ್ದೀರಿ. This issue was also considered by this honorable court. Same issue, my lords. The page 109, my lords. Subsequent judgments with this was first issue, first matter which was considered, my lords. It starts with page 107. 109, sorry. One not nine first paranally from the bottom 4 lines. Herein the respondent herein has been provided 1 promotion and 2 financial upgradation under the relevant scheme which were in operation at that point of time. ಅದರಲ್ಲೂ ಅಷ್ಟೇ, 1 promotion, 2 financial upgradation ಈ ತರದ್ದು ಸಿಕ್ಕಿದೆ. After considering, my lords, this honorable court, my lords, has held page 113. 113 ಅದರಲ್ಲಿ ತಾವು ಆ ಫಸ್ಟ್ ಪ್ಯಾರಾನಲ್ಲಿ ಒಂದು 6 ಲೈನ್ ಕೆಳಗಡೆಯಿಂದ, ದೇರ್ ಆಫ್ಟರ್ ವೆನ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ವಾಸ್ ಇನ್ ಪ್ರಮೋಟೆಡ್ ಪೋಸ್ಟ್ ಆಸ್ ಪರ್ ದಿ ಸ್ಕೀಮ್ ದಟ್ ವಾಸ್ ಇನ್ vogue at that point of time, the TBOP has been granted on so and so. When he had qualified for the same after putting 16 years in the said position, subsequently on so on 1/7/2008, next BCR financial upgradation has been granted. Para 6. On these aspects, when there is no serious dispute and the respondent has been granted 1 promotion and 2 financial upgradation, the case of the respondent being considered once over for grant of MACP in the manner as directed by the CAT would not arise in the instant case. In that view, the order directing the petitioner to
Right. How this question arose? The fact matrix ಏನಿತ್ತು?
Fact matrix, my lords, it's
Identical?
Identical.
How?
He got 1 promotion.
1 promotion in 76, 74.
My lords, he has got 1 promotion and 2 financial upgradations. Those dates, my lords.
1 promotion, 2 financial upgradation in terms of the scheme.
ಹೌದು, same TBOP, BCR, 1 promotion.
During what period? 1971 ಇಂದ 21/3/71 ಇಂದ 31/10/2010, correct?
ಹೌದು.
Almost 40 years. 1 promotion.
He has got 1 promotion, 2 financial.
Time bound
upgradation. Time bound upgradation. ಅದು ಇನ್ನೊಂದು financial upgradation.
ಇನ್ನೊಂದು ಯಾವುದು?
ಅಲ್ಲ, TBOP ಒಂದು ಟೈಮ್ ಬೌಂಡ್ ಒಂದು.
Correct.
ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ BC ಬೈಆನ್ಯುಯಲ್ ಕ್ಯಾಡರ್ ರಿವ್ಯೂ ಅದು ಒಂದು ಫೈನಾನ್ಷಿಯಲ್ ಅಪ್ಗ್ರೇಡೇಷನ್.
ಎಲ್ಲಿದೆ ಅದು? ಶೋ ದಟ್ ಬೈನಿಯಲ್ ಕೇಡರ್ ರಿವ್ಯೂ ಅಂತ ಹೇಳಿ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಅದರಿಂದ ಏನ್ ಬೆನಿಫಿಟ್ ಆಗುತ್ತೆ ಎಂಪ್ಲಾಯಿಗೆ?
ತೋರಿಸ್ತೀವಿ ಒಂದು ನಿಮಿಷ. ಪೇಜ್ 58 minutes. $57 will be there relevant. From 57. ಹೌದು. ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಪ್ಯಾರಾ ಇನ್ ಪರ್ಸೂನ್ಸ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಗಾಟ್ ಇಟ್. In pursuance the orders contained in so and so and so, the Director of Postal Service so and so and so and so is pleased to extend the order the promotion of TBOP officials mentioned in the annexures who have completed 26 years of service to the scale of so and so under the BCR from the dates shown against their name. Next page 58 ನಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ serial number 31. Serial 31 so D Srinivas Rao so and so ಆ ಡೇಟ್ ಇದೆ 1/7/2000.
7/2002.
ಹೌದು ಹೌದು. Even in the similar matter
ಮತ್ತೊಂದು ಇದು ಬರಲ್ಲ ಅಂತ ಅವ್ರ ಪ್ರೇಯರ್ ಏನಿತ್ತು ಕೇದ ಮುಂದೆ?
ಅವ್ರದ್ದು ಪ್ರೇಯರ್ ಇರೋದು ಫೈನಾನ್ಷಿಯಲ್ ಅಪ್ಗ್ರೇಡೇಷನ್ ಬರಬೇಕು ಅಂತ ಹೇಳಿ ಅದು ತೋರಿಸಿ.
ಫೈನಾನ್ಷಿಯಲ್ ಅಪ್ಗ್ರೇಡೇಷನ್ ಬರಲ್ವಾ?
ಇಲ್ಲ ಅಂದ್ರೆ ಎಂಟೈರ್ ಸರ್ವಿಸ್ ಇಫ್ he does not get any promotion at all my lords, he is entitled for 3 financial upgradation. If he gets a promotion there is no stagnation.
Correct.
So it will be set off. Promotion ಬಂದಾಗ stagnation ಇಲ್ಲ, ಒಂದು MACP ಗೆ set off ಆಗುತ್ತೆ.
That set off happened in this case on
Lords,
2492
76
2476 because first promotion was there.
ಹೌದು, ಒಂದು ಪ್ರಮೋಷನ್ ಸಿಕ್ತು, ಅವಾಗ
76 you are right.
ಪೇ ಚೇಂಜ್ ಆಗುತ್ತೆ. ಆಮೇಲೆ ಇನ್ನೊಂದೆರಡು ಫೈನಾನ್ಷಿಯಲ್ ಅಪ್ಗ್ರೇಡೇಷನ್ ಅವ್ರಿಗೆ ಸಿಕ್ಕಿದೆ. ಅಟ್ ರೆಲೆವೆಂಟ್ ಟೈಮ್ ಏನಿತ್ತು he has got it.
ಏನದು ಎಷ್ಟು ಪೀರಿಯಡ್ ವರೆಗೆ ಪ್ರಮೋಷನ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಈ ಫೈನಾನ್ಷಿಯಲ್
ಅಲ್ಲ MACP ನಲ್ಲಿ ಏನಂದ್ರೆ 10 years ಗ್ಯಾಪ್.
10 years. 1 second. 2476 ನಿಂದ 1486 ಗೆ ಒಂದಾಗಬೇಕಿತ್ತು.
ಅಲ್ಲಲ್ಲ
10 years ಅಂತ ಹೇಳಿದ್ರೆ
ಅಲ್ಲಲ್ಲ ಏನಂತಂದ್ರೆ ಈ ಸ್ಕೀಮ್ ನಲ್ಲಿ ಅಂದ್ರೆ ಫೈನಾನ್ಷಿಯಲ್ ಅಪ್ಗ್ರೇಡೇಷನ್ ಅಟ್ ದಟ್ ರೆಲೆವೆಂಟ್ ಟೈಮ್ ಲಾಟ್ಸ್ ಇಟ್ ವಾಸ್ TBOP ಅಂಡ್ BCR. ಅದು ಪೀರಿಯಡ್ಸ್ ಬೇರೆ ಇತ್ತು.
ಯಾವ್ದಿತ್ತು ತೋರಿಸಿ?
16 years and
shows ಎಲ್ಲಿದೆ ತೋರಿಸಿ?
that it is not
ordinarily time bound advancements, time bound promotions, compensatory promotions in the pay scales are granted once in 10 years because of the stagnation. More than 10 years then torsi. Suppose if we recon 2476 as the date, from there 1486 will be 10 years.
this MACP
1486 ತೊಗೊಂಡ ನಂತರ 1496 ಗೆ ಇನ್ನೊಂದು ಬರ್ತದೆ. If it is 10 years, if it is 15 years, again this is wrong. ಆ ಪೀರಿಯಡ್ ಬರಲ್ಲ.
ಅಲ್ಲ ಏನಾಯ್ತು ಅಂತಂದ್ರೆ MACP
ತೋರಿಸ್ಬೇಕು.
ಅಲ್ಲ ಸ್ಕೀಮ್ ಬೇಕಾದ್ರೆ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ
ಅಷ್ಟೇ ಕೇಸ್. ನೀವು ಸ್ಕೀಮ್ ನಲ್ಲಿ ಈ ರೀತಿ ಇದೆ ಅಂತ ತೋರಿಸ್ಬೇಕು.
20 ವರ್ಷ ಅಂತ ಆಗಿದ್ರೂನು 26ಕ್ಕೆ ಒಂದು ಬರಬೇಕಾಗಿತ್ತು, 96ಕ್ಕೆ ಒಂದು ಬರಬೇಕು.
ಅಲ್ಲ ಅದು ಕ್ಲಾರಿಫೈ
ಬೇಡ, 15 ವರ್ಷ.
ಐ ವಿಲ್ ಜಸ್ಟ್ ಕ್ಲಾರಿಫೈ ದಿಸ್.
ನೀವು ಹೇಳೋದು ಅವ 8 ವರ್ಷ
ಮಾಡಿರಲಿ, 2 ಬರ್ತದೆ.
3 ಅಂತ
ಅಲ್ಲ ಇರೋ ಒಂದು
ಪ್ರಮೋಷನ್ಸ್
ಅಲ್ಲ ಏನ್
ಅವನಿಗೆ ಅಂದ್ರೆ ನೀವು ಹೇಳೋದು ಪ್ರಮೋಷನ್ ಈಗ 4 ಪ್ರಮೋಷನ್ ನಾವು ಕೊಡೋದೇ ಇಲ್ಲ.
ಪ್ರಮೋಷನ್ಗೆ ಬಾರ್ ಇಲ್ಲ. ಅವ್ರು ಎಷ್ಟೇ ಅವ್ರ ಸರ್ವಿಸ್ ನಲ್ಲಿ ಎಷ್ಟು ಪ್ರಮೋಷನ್ಸ್ ಆದ್ರೂ there is no bar.
Logical ಇದೆ.
But you want to say that promotion and the MACP these things will get merged.
No, it cannot be. Supreme Court said
stagnation ಈಗ ಫೈನಾನ್ಷಿಯಲ್
ಕರೆಕ್ಟ್. ಫೈನಾನ್ಷಿಯಲ್ ಅಪ್ಗ್ರೇಡೇಷನ್ಸ್ 3 ಅಂತ ಇದೆ. ಫೈನಾನ್ಷಿಯಲ್ ಅಪ್ಗ್ರೇಡೇಷನ್ ಅಂತಾರ ಹೇಳಿ, MACP ಅಂತಾರ ಹೇಳಿ, ಎಂತ
ಹೌದೌದು ಯಾವ್ದಾದ್ರು ಆಗಲಿ. ಕರೆಕ್ಟ್ ಕರೆಕ್ಟ್.
ಅದು ಗೆಟ್ಸ್ ಮರ್ಜ್ಡ್ ವಿತ್ ದಿ ಪ್ರಮೋಷನ್ ಅಂತ ನೀವು ಹೇಳೋದು ಅಲ್ವೇ?
ಕೊಟ್ಟಿದ್ರೆ ಅವ್ರಿಗೆ ಪ್ರಮೋಷನ್ ಬಂದ್ರೆ
ಕೊಟ್ಟಿದ್ರೆ
That's what he wants to work on that.
Law is not that way. Where a person cannot be granted promotion or ordinarily for want of availability of vacancy. In that case, the stagnation allowances are paid. It's a policy which is considered in 1992 Supreme Court. So if that does not happen, who is otherwise eligible to be promoted but cannot be promoted because of non-availability of the post, or the employer decides that we will not promote anybody because it is left to the prerogative of the employer, then to retain him in the post with attraction, we give him a particular monetary package. That is the idea. That's how the Supreme Court.
The purpose of financial accreditation is that in case of stagnation, he should get some financial benefits so that his grade pay
ಈಗ
pay
ಪ್ರಮೋದ್,
ಜಾಸ್ತಿ ಆಗತ್ತೆ ಅಂತ.
ಅದೆಲ್ಲ ಬಿಡಿ, ಅದೆಲ್ಲ ಉಪಯೋಗ ಮುಟ್ಟಲ್ಲ. ಇಷ್ಟೇ ಹೇಳ್ಬೇಕು ನಮಗೆ. ಟೈಮ್ ಬೌಂಡ್ ಪ್ರಮೋಷನ್ ಪೀರಿಯಡ್ ಎಷ್ಟು?
ನಾನು ಅದು ಸ್ಕೀಮ್ಸ್ DBOP BCR ಎರಡು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ತೋರಿಸ್ತೀನಿ. And I want to just clarify this.
ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
ಅಲ್ಲಲ್ಲ,
ಯಾಕೆಂದ್ರೆ
my lords posed a question.
ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ರು ನಾವು ಜಜ್ಮೆಂಟ್ ಬರೆಯಲ್ಲ ಈಗ. ಅದು ಕ್ಲಾರಿಫೈ ಆಗ್ಬೇಕು ಮೊದಲು. ಫೌಂಡೇಶನಲ್ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಅದು. ಟೈಮ್ ಬೌಂಡ್ ಪ್ರಮೋಷನ್ 10 years, 15 years, 20 years. ಏನಿದೆ ಸ್ಕೀಮ್? ಹೌ ದಟ್ ಸ್ಕೀಮ್ ವರ್ಕ್ಸ್ ಇದೆಯಲ್ಲ, ಅದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್
Please.
ಬರ್ತೀರಾ?
Please.
Okay. Week after next it will. So that you can have, some breathing period. Yes. Justice Ramajais has dedicated half a chapter on this in his services under the state. First edition, 83 or 84, Indian Law Institute publication. Samaraditya Pal also discusses this. He has referred to 2 judgments. Just look into it. Yes. Period fix ಆಗಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಹಂಗದು you have no discretion ಅಲ್ಲಿ. Unless that is shown. Promotion out ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. Promotion is not a time bound allowance at all. Contrary, one excludes the other.
I appear for petition, my lord. Pays for time, my lord. Senior due to some personal.
ಒಂದು 4 sentence ನೀನೇ ಹೇಳು ನೋಡೋಣ.
proxy
Suppose ನಾನು ಪ್ರಯೋಗ ಮಾಡಂಗಿದ್ರೆ.
Proxy counsel.
Just look into what is this, RS ಏನ ಇದು? Transfer petition. ಏನು ಎಲ್ಲಿಂದ ಎಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರು? ಯಾವ ಪ್ಲೇಸ್ ನಿಂದ ಯಾವ ಪ್ಲೇಸ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರು? ಗೌರಿಬಿದನೂರು ಟು ಜಾಲ ಹುಬ್ಳಿ. ಎಷ್ಟು ಕಿಲೋಮೀಟರ್ ಅದು? Hey, do you know the map of the Karnataka? That's what. It cannot be 3. ಈಗ ಕುತ್ಕೊಂಡು ಒಂದು 5 ನಿಮಿಷ ಓದಿ. ಪಾಸ್ ಓವರ್. ಇಷ್ಟೇ ಇರ್ತದೆ ಟ್ರಾನ್ಸ್ಫರ್ ನಲ್ಲಿ ಫೈಲ್. ಅಲ್ಲ ನಿಮ್ಗೆ ಹೇಳ್ಕೊಟ್ಬಿಟ್ಟು ಸಾಕಾಗೋಗಿ.
Please, man.
Transfer guidelines. 24/6/2024. 2013 rules. 2013 guidelines are considered by the full bench. KLM chairman. Both have requested. Requested remember. Read judgment of Supreme Court. Write down. Varadharao versus State of Karnataka. ಓದ್ಕೊಂಬರ್ಬೇಕು. ನಾವು ಕರ್ನಾಟಕದ್ದು ಓದಬೇಕು. DB ILR 85-86 ಕರ್ನಾಟಕ, AR 95 ಅಥವಾ 96 ಅಥವಾ ಆ ಟೈಮ್ನಾಗ ನೋಡ್ಕೊಂಡು ಓದ್ಬೇಕು. ಪ್ರಾಮಿನೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಅವು ಅದನ್ನ ಓದ್ದಂಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬಾರ್ದು ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟ್ರಸ್ ಅನ್ನ. ಇದಾದ್ಮೇಲೆ ಚಂದ್ರ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಫುಲ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್. ಅದು ಇನ್ನೊಂದು ಬರುತ್ತಲ್ಲ ನೆಕ್ಸ್ಟ್ ಯಾವುದು? ಗಂಗಾಧರಯ್ಯ ವರ್ಸಸ್ ಸ್ವೈನ್ ಸುಸು ಎಲ್ಲ ಫುಲ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಓದ್ಕೊಂಬರ್ಬೇಕು. ಹಂಗೆ ಬಂದು ನಿಂತ್ಕೋಬಾರ್ದು ಇಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ ನಮ್ಗೆ ಸಿಟ್ಟು ಬರ್ತದೆ ಹಂಗೆ ನಿಂತ್ಕೊಂಡ್ರೆ. Will ill treat those who come without preparation will be ill treated at our courts. Wasting time of the court. Yes. Pakala reluctantly adjourned by 2 weeks. At the request of. Petition illa enta.
Lord, there are two issues in this. One was regarding the APAR grading. The respondent questioned the APAR grading. The second one is compulsory retirement under 56J of the fundamental rules. There are two separate petitions, my lord. One deals with the compulsory retirement. The other one deals with the APAR grading. If your lordships take up.
Who is this gentleman? Back. Yes.
Lord, if your lordships have.
Why two petitions?
Lord,
Two orders were challenged.
Yes.
One order was?
It's a common order, but two different issues. One dealt with the APAR grading.
Huh?
Grading, APAR grading, APAR, APAR grading.
Apparel.
APAR, that is the appraisal rating.
Appraisal rating. Okay.
They call it
APR.
as APAR.
APAR.
He challenged the correctness of the APR grading in one petition.
That order is dated?
Both are common, Lord.
No, different orders.
Dates in. Lord, that would be 20th of April, 2023.
Another order is?
Another order is.
What is that order?
It's a common order, my lord.
Same order.
Same order.
What is that?
They club together. That is application number 1125 and.
Same order.
588.
Please take us to that order.
Which WP is your lordship having, my lord?
Anyway, whichever order is common.
Yes, 1976, my lord, then page 30. Page 30.
30.
Yes. There, your lordships will see at page 30 that there are two original applications. One is 1125 of 2029, that is APAR. And the other one is 588 of 2021.
Both they challenge the same order.
Yes. Two different petitions. The tribunal clubbed both petitions, heard both petitions together and passed a common order.
For a different period they are.
Yes, and different issues.
Issues also different.
Yes, one dealt with only the APAR grading. The second one dealt with compulsory retirement.
Both the OAs.
Yes.
What was challenged is the same order. It cannot be.
No.
Huh?
Our orders are different.
That is what I was asking.
I'm sorry, Lord.
First order in this petition, OA number 170 ಅಲ್ಲಿ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದಂತ ಆರ್ಡರ್.
OA number 170 stroke 1125. 1125.
ಯಾವುದು?
ಇದು of 2019. Okay. That one dealt with page number 78. Would your lordship have a look at page 78? It shows the relief there.
That aside, order dated 31/8/2018, 18/7/2019.
Lord, the relief sought in the first petition can be found at page 78.
Page 78.
Page 70. Second on the page. Lord, the prayer is to set aside the APAR 2017-18, 2018-19, vide orders dated 31/8/2018 and 18/7/2019.
And further set aside two more orders. ಇವೇನಿವು ಅಂತ ಅಲ್ಲೇ ಪ್ರೇಯರ್ ನಲ್ಲಿ.
ಹೌದು ಇದು ಅದೇ APAR. All are APAR. That after he gave a representation After considering the representation, we passed further orders. Those are those last two. Annexure A23 and A24 are.
Or orders on representation.
Yes. After,
Correct, huh?
yes, after consideration of the representation given by the applicant before the tribunal.
To remove adverse remarks.
Allah, he challenged the grading. He said, my grading is low.
That's what. It's a, Andre, it's not adverse remark, but grading is low antana.
Low, hೌದು.
Not adverse remark.
Adverse. Grading is low.
But when he was entitled to A grade, if you give B, he has a grievance.
It's on a scale of 10, average was 4.
4.
So he said it is very low. And against that, he was given an opportunity of representation. He gave a representation as to why he feels that he should be given higher marks. The authorities considered and held that the grading is appropriate. And the tribunal does not consider his prayer in respect of 2017-18. Only 2018, although the tribunal agrees that there cannot be interference, at the end they say, please ignore the grading for that year.
Oh.
After agreeing, they refuse to interfere. They say nothing wrong. And
Where is that finding?
that finding, would your lordships kindly have a look at page 52. Page 52, para 23 onwards, if I may read. Page 52 in the same volume, para 23. Your lordship got para 23 at page 52?
52.
Yes, page 52, para
You are
23.
right.
Yes, the tribunal refers to a couple of judgments. They say in Gunjan Prasad, CAT principal bench has referred to so-and-so, decided on so-and-so, where it has been held that as per settled law, recording of ACR is within the legitimate domain of the competent administrative authority. There is very limited scope for judicial intervention in such case, whereas previously, according to the prevailing.
What it says is, earlier only requirement was communicating the adverse remarks. Then Supreme Court said, not only adverse remarks should be communicated, all remarks should be communicated. If an employee who is entitled to A grade, if given B grade, he is entitled to make a representation. That is stated in paragraph 23.
Yes, bottom three lines. All remarks which would affect
That's
an employee adversely in grant of service are required to be communicated.
Correct.
This is on the principles of natural justice, so that affected official does get an opportunity to represent his case before the authorities. However, once such remarks are communicated and the representation is considered by the competent authorities, a further probe into the matter is not ordinarily called for.
Correct.
In this, so we have
So
complied.
legal.
Yes, legal. No, yes,
Para
having
23
yes.
discusses legal position.
Yes. Now, under the light of that legal position, please see para 25 at page 54. As regards the competency of the reporting officer in assessing the grading of the APR for the applicant in 2017-18 and 18-18, we are not inclined to accede to the argument advanced by the learned counsel for the applicant. The very same reporting officer has assessed the grading of the applicant in the subsequent year, merely for the reason that lower grading is given for the year 2018-19 in APR. We cannot arrive at a conclusion that the reporting officer had no competency. The reports were written by the ministerial cadre officer is not a ground to declare it invalid, as the said supervisory officer is senior to the applicant and has handled similar responsibilities. However, to meet the ends of justice, principles of natural justice ought to have been adhered to while downgrading the ranking of the APR for the year 2018-19. The same is lacking. The attendant circumstances speak about the tussle between the parties in as much as providing infrastructure, including vehicle for effective completion of the project work. Hence, APR grading for the year 2019 cannot be approved. For the reasons aforesaid, we pass the following. Please have a look at the order dated so-and-so is set aside. And then item 3, the grading of the applicant reported in APR 2018-19 shall be ignored.
This order runs counter to reason.
Well, it's two grounds. Two grounds where.
No, at the most, what they could have done? Principles of natural justice should have been remanded at the most. How can, having said that for principles of natural justice, they have said Downgrading of the year so and so is the lacking, that the principles have not been followed. See, attendance speaks about the between the parties so and so. At the most, they could have referred the matter, remanded the matter for consideration afresh, going by this reasoning.
The reasoning is regarding all the other order also, not regarding the rating. Rating is one aspect, regarding passing an order of compulsory retirement also, is considered here. Two different things. Secondly, as regards the change in ratings, two grounds were raised. One is regarding opportunity of hearing. Second is regarding the competence of the authority who is passing the order. Court has not agreed with us over one of, this is what it is stated. One of the reasons, one of the grounds that we have raised that the officer passing the order is not competent to pass, court has not agreed with us. Regarding the aspect that opportunity had to be given when they are downgrading, court has agreed with us. That is the bifurcation of reasons, your lordship sees here.
Anyway,
And, there is third order. Third order also, reasoning, if your lordship has to see, it's regarding compulsory retirement.
Lord, on the APAR, I would like to take your lordships through the rating itself and how the applicant was given an opportunity. Please have a look at one quote. Please have a look at the APAR rating sheet at page number 128. Lord, it begins at 128. At page number 130, part 3 of the appraisal, question number 1 is, does the reporting officer agree with the statement made in part 2? If not, the extent of disagreement and reason thereof. It says assigned work was incomplete. And then there are
where are you reading?
I am reading at page number 130, my lord. The sheet begins at page 128. The APAR grading sheet begins at 128. The first two sections are to be filled up by the applicant himself. That is page number 128 and 129. 130 onwards is the reporting officer.
These are all self-appraisal at this level.
Yes, at this level, self-appraisal. But what your lordship will see at part 3, page 130, that is the review, the reporting authority's opinion and the reviewing authority's opinion. For example, under column number 2 at page 130, assessment of work output, weightage of this section. The reporting authority gave about 4 on a scale of 10 for the accomplishment of the planned work, quality of output, analytical ability, initiative, and overall grading was 4, whereas the reviewing authority brought it down to 3.5. Then B.
1 second, slowly.
I'm sorry.
This is on 10-point scale.
Yes.
First, A ideyala.
A.
Idu yardu? This is by which authority?
Adralli eredide, reporting plus reviewing ibrudu ide, right?
Idu yavdu yardu?
Left ಗೆ ಇರೋದು
reporting, right ಗೆ ಇರೋದು reviewing.
Two separate authorities. Okay. It is made on 3 parameters. A is assessment of work output, B is personal attributes, and C is functional competency. And at the bottom of each of these parameters is the overall grading for that parameter. And as your lordships would see, the grading is 4, maximum is 4. And
ಇಲ್ಲಿ ರಿಪೋರ್ಟಿಂಗ್ ಅಥಾರಿಟಿ ಕೆಳಗಡೆ ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾನೆ, ರಿವ್ಯೂಯಿಂಗ್ ಅಥಾರಿಟಿ ಹ್ಯಾಸ್ ಗಿವನ್ ಮೋರ್.
ಕೆಲವು ಕಡೆ ಹೌದು, ಕೆಲವು ಕಡೆ ಅವರು ಕಮ್ಮಿ ಕೊಟ್ಟಿದ್ದಾರೆ. But if your lordships would see the overall grading, it more or less matches what both authorities feel. And my lord,
ಅದೆಷ್ಟಾಗ್ತದೆ ಇದೆಷ್ಟಾಗ್ತದೆ ಹೇಳಿ. 1 2 3 4
ಅಲ್ಲ ಬಾಟಮ್ ಅಲ್ಲೇ ಗ್ರೇಡಿಂಗ್ ಇದೆ.
1 ನಿಮಿಷ ಹಿಂಗಲ್ಲ, ಕಂಪ್ಯಾರಿಟಿವ್ 3 6 4 10 3 13 16.5
ಟೋಟಲ್ ಮಾಡಬೇಕಾ?
4 4 8 12 22 4 26 4 30 34 38 43 4 47 5 4 9 3 12 16, 26, 32, 35, 38, 44, 42.
Then would your lordship have a look at page 131 where there is a summary. And my lord, the department with which this officer was working is the Intelligence Bureau. And please have a look at item number 5, where there is a page 131. Page one
Pen picture.
pen picture of the officer reported indicating overall.
What is the designation of this officer?
At that point, he was intelligence officer.
ಅಲ್ಲಿ ಇಂಟೆಲಿಜೆನ್ಸ್ ಆಫೀಸರ್ ಅಂದ್ರೆ ಅದು ಏನೇನು ಗೊತ್ತಾಗಬೇಕಲ್ಲ. ಸೊ ಡಿಸಿಗ್ನೇಷನ್ ಅನ್ನೋ ಬೇರೆ ಇದಾಯ್ತು. What was he?
He joined as subsidiary SIB and transfer. Deputy Central Intelligence Officer.
Deputy Central Intelligence Officer.
Huh?
Deputy Central Intelligence Officer, DCIO.
The office of ಅಂತ ಕೊಟ್ಟರೆ ಕೆಳಗೆ. He works in the office of.
But his designation is Deputy Central Intelligence Officer.
DCIO.
DCIO.
Ah.
My lord, would your lordship have a look at the
Pen picture Odi.
Yeah, pen picture. On a specific work assigned to the officer, he
has come up with a very perfunctory report. On being tasked to get a more detailed report, he resorted to requesting for different types of logistic support, thereby causing delay. He has displayed lackadaisical attitude to work and has not done any worthwhile work during the period under review. Overall grading is 4, and on the right hand side, the reviewing officer agrees with that. Item number 3, do you agree with the assessment of the officer given by the recommending officer? I agree. And then overall grading is 4. So therefore, 2 officers, namely the reporting officer and reviewing. Our designation ಏನು?
ಯಾರ್ದು?
Reporting and reviewing officers.
ಇವ್ರದ್ದೇನಪ್ಪ? The reviewing officer is joint director. Your deputy director. The reporting officer is additional deputy director. After this, he was given an opportunity to file a representation.
Reporting officer designation ಏನು?
Additional deputy director.
Additional
deputy director.
reporting officer.
Oh.
And reviewing officer?
Joint director.
The joint director is above additional director.
Yes. Additional deputy director.
Additional deputy director. Ah, that's what I was wondering.
I'm sorry, if I said additional director, then the additional deputy director. This report was communicated to the applicant by an communication dated 18th July, which your lordship will find at page 127. Salpa ಹಿಂದ್ ಬಂದ್ರೆ page 127. Enclosed, please find FR copy for the period 2018-19. In case the officer wish to make representation against the entries, he may do so within 15 days. Our madudru. So after this was communicated, he gave a representation.
In time?
Yes.
Where is that?
153. So he called it as regarding disagreement with FR grading allotted and request to reassess the FR and reward the grading for the period 2018-19. So he gave some of his reasons, and that was considered Here, which is the authority? E officer. Thank you. Director. Additional director. Lord, this was considered and an order was passed at page 156.
ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಮಾಡ್ಯಾರ ಇವರು?
Join ಮಾಡಿದವಾಗ. Lord.
How many years of service he has put?
90.
And 2020, my lords, he has been consolidated.
So about 26.
2020.
So
How
without
many
any
promotions?
adverse- Look, without any adverse.
How many promotions he has done during the 26-year period?
My lords, cash awards, Kautilya award, my lords, and
Two promotions.
Two promotions.
Two promotions. ಕೂತ್ಕೊಳ್ಳಿ ಅಲ್ಲೇ ಹಿಂದ್ಗಡೆ ಕೂತ್ಕೊಳ್ಳಿ. Sit there.
Lord, at page 156, Lord, his representation is considered. May I take your lordship through that?
On
Page 156.
see order on representation.
Yes, order on representation. Adralli, the last para at page 156. While it remains a fact that the observations of the reporting stroke reviewing officer are based on the overall general behavior of the officer reported upon with his colleagues, which is something primarily within the knowledge of these three assessing officers and therefore hardly requires any report or comment to be put up to the notice unless something highly adverse of exceptional nature is noticed during the reporting period. Remarks on APAR are based on the general assessment of the officer's day-to-day work, conduct, and duties performed. Except for the reporting officer and reviewing officer, none else can have much knowledge about such performance, more so in an intelligence organization. At the same time, in the APAR of the reporting period of in part 1, against para 14, no reward has been indicated. Besides, in part 2, the officer reported upon under para 2 has in some underlined not applicable, and under 3B, against significantly higher achievements, nothing has been written. The reviewing officer in part 4 has fully agreed with the reporting officer, and from her comments, it can be inferred that Sri so-and-so, instead of concentrating on his work, is in the habit of questioning the authority of the reporting officer. Significantly, Sri so-and-so has failed to submit a single report during the period. The contentions of Sri so-and-so challenging the authority of Sri so-and-so, Additional Deputy Director, SIB Bangalore, is not tenable as a senior officer.
Where has he challenged authority of the officer? Where has he challenged?
Page 154.
154.
In the, from the top, the middle parameter, there he makes a reference to that officer, Nigel Fernandez.
Which is that? Read.
The last two para, I'll beginning with the words previous year.
Page?
Page 154. Page 154 is the representation filed by the applicant.
154.
Yes. 154 ಅಲ್ಲಿ last three paras, bottom in them.
Which paragraph he?
Previous year in the Alunda. May, if I may read.
Previous year.
Previous year, the same ADD, ministerial cadre officer has given me upper grading of 6 for the year 17-18. And now he has given the upper grading of 4 for the period 18-19. And this period, he has not issued any single memo to expedite the work. So in my APAR 2018-19, Sri Nigel.
There is nothing like that. Go to the next para.
Allah, now ಓದ್ಬಿಡ್ತೀನಿ. I will.
There is nothing. You can read. I have read it.
Okay.
In seconds.
Okay. Office of the DCIO Special Project Bellary is functioning with only one DCIO not in staff. The loan officer DC was given only one task without any logistic support. So, Sri so-and-so ministerial officer cannot mention in his APAR 2018-18 that I have not done any worthwhile work during the period under review. In this regard, Sri so-and-so officer never issued any memo or reminded me that I am not doing any worthwhile work before mentioning these remarks directly in APAR number so-and-so. So, my APAR. ಇಲ್ಲಿ
Where has he challenged the
ಅಲ್ಲ,
authority
ಅದರಲ್ಲಿ
of the
there
officer?
there are some elements of questioning the authority at page 153 also. Para 2, page 153. Some elements, some strands of that. Para 2, the APAR for the period has been initiated by Sri so and so, and he being a ministerial CAD officer has not assessed my APAR thoroughly and not adhered to the rules and norms of writing APAR. So
Really, that thing.
then this
No,
has been,
procedure is not, learned judge has not followed the procedure established by the Supreme Court.
and he has
New
not,
grounds on-
he is not adhered to the rules and norms of writing ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
Now, where is the challenge to the authority of the officer? He is saying, he norms follow madilla. He has not thoroughly assessed the work. That ground is taken even against the.
Next
High Court
ಪ್ಯಾರಾದಲ್ಲೂ ಒಂದು
judges.
ಸ್ವಲ್ಪ ಹೇಳ್ತಾರೆ. So I am not in agreement with the APAR grading for the year 2018 given by so and so, who has not thoroughly assessed my work.
ಅಷ್ಟೇ. Where is the questioning of the authority? Where has he challenged the authority? See, you have said, internal inspection, Sri Rao was warned for questioning the experience and caliber of the.
ಅಲ್ಲ,
Where has he said?
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ತಾವು?
Page 156.
150.
You read it, na?
Yes.
Same I am reading. Where has he said? He is being warned for taking up a ground for why he should be given relief. What is that warning you are administering to? Whom? Page 156, para numbered para 2, unnumbered para 1, 2, 3.
Yes.
The reviewing officer as agreed, the reviewing officer upholds the grading. Further, in her comments on the representation, reviewing officer has mentioned that reporting officer is head of internal intelligence matters, and Sri Rao was warned for questioning the experience and caliber of the report. Where is that?
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
ನೀವು ನಮ್ದು ಅಸೆಸ್ ಮಾಡುವಾಗ ಯು ನಾಟ್ ಫಾರ್ ನಾರ್ಮೇಟಿವ್ಲಿ ಹ್ಯಾವ್ ನಾಟ್ ಡನ್ ಜಾಬ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಇನ್ ಪರ್ಸನಲೈಸ್ ಯಾಕೆ ಮಾಡಿಕೊಳ್ತಾ ಇದ್ದೀರಿ ಅಂತ.
On whether for the issuance of warning, if there is any material, I can find out. If there is any material. A11, page 104.
No, where has he questioned your expertise and authority at all? He only says, he normative thoroughly assessed has not thoroughly assessed my work. That's the ground in appeal.
No.
Every standard ground it is up in every appeal.
No.
Where has he said anything offensive?
No, from their experience with the day-to-day work, it appears that they found such conduct in their experience of working with him on a day-to-day basis. 10?
Warning is a punishment. Ordinarily, although century is specifically mentioned, warning may partake the character of punishment, says the Supreme Court.
The warnings are produced,
Where have you? Show
page
it.
number 104 onwards. Page 104 onwards.
Where is that?
This is a memo which was dated 11th September 2018, which is issued to the officer concerned. We can see the last paragraph, which kind of
This
captures.
is pursuant to what, on what basis this is issued?
I can read the memorandum that describes the background. May I read the
Yes,
memorandum. This is with reference to your memo dated so and so, dated 6/6/2000, conveying your.
Issues this to whom?
This is issued to the officer concerned by the joint director.
Right.
The senior most officer of that organization has issued it to the respondent. And the memo says, this is with reference to a memorandum dated 6/6/2018, conveying your misgivings with respect to the observation made by the joint director by his memorandum dated so and so, and the demand to withdraw the comments of joint director unconditionally.
ಏನದು? ಫಸ್ಟ್ ಪ್ಯಾರಾ ಏನದು?
ಅದನ್ನೇ ಓದ್ತಾ ಇರೋದು. ಅವರು ಏನೋ he has given some response, some memo was issued to which he gave a reply demanding to withdraw certain comments unconditionally. And then, Lord, may read the entire memo, then we'll get some background. On the directions of the undersigned JDD, as the head of the internal intelligence matters of SIB Bengaluru, had by his memo dated 13/3/2018 instructed you to prepare an exhaustive study report on illegal withdrawal of water from Tungabhadra River by tail-end farmers and various other related developments. In response, you had requested for permission to hire a vehicle for 21 days to undertake a tour for preparation of the study report. However, by his memo dated 3rd March 2018, Joint Director had conveyed to you that your request for hiring a vehicle could not be exceeded due to administrative constraint. It may be mentioned here that on rejection of a request for hiring a vehicle, you should have again approached Joint Director with proper justification for conceding to your demand for hiring a vehicle, since such demands needs to be considered in the light of the requirement of such provision to accomplish the work allotted to you, taking into consideration other practical constraints. Again, it would have been proper on your part to approach the undersigned with your request if you felt that your request was absolutely essential for fulfilling the given task. Subsequently, the study report submitted by you by memo dated 9th April 2018 was discussed with the Joint Director with the undersigned. A perusal of the report, which contained only 2 pages, revealed that the report lacked even the barest minimum details which a study report should have ordinarily contained. These observations were communicated to you by memo dated so-and-so. Your reply by memo dated so-and-so, questioning the decision of JDD and also casting aspersions on the question of competence of the authority.
ಅದೆಲ್ಲಿದೆ? Where is that? He is only
ಆ
this
memo
authority is saying that.
ಇಲ್ಲಿದೆಯಾ?
Where is that?
ಈಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ಬಟ್ ಐ ಕ್ಯಾನ್ ಫರ್ನಿಶ್ ಇಟ್. ದಿಸ್ ಮೆಮೋ ಡೇಟೆಡ್ ಇದು ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆಯಾ ಪ್ರಮೋದ್? ಇದು ಅಲ್ಲ, ದಿಸ್ ಕ್ವಶನಿಂಗ್
Where has he questioned that authority?
ಅದು ಇರುತ್ತೆ, ಬೇಕಾದ್ರೆ ವಿ ಕ್ಯಾನ್ ಫರ್ನಿಶ್ ಬೈ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಕನ್ಸಿಡರೇಷನ್.
ಅಲ್ಲಿ ನಮ್ಗೊಂದು ವೆಹಿಕಲ್ ಕೊಡ್ರಿ ಅಂತ ಕೇಳ್ದ ಅವನು. ಇದು ಕೆಲಸ
ಅಲ್ಲ, ಅಪಾರ್ಟ್ ಫ್ರಮ್ ದಟ್
ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು.
ಅಲ್ಲ, ಅಪಾರ್ಟ್ ಫ್ರಮ್ ದಟ್ ದೇ ಸೇ questioning the decision of the JDD.
Where
and
is that?
Also ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ. It is ಇದರಲ್ಲಿಲ್ಲ. We can secure for lordships, for lordships perusal, I can secure it.
Of the memo or the reply which he has given, there is no such.
I'm sorry.
ಅದಕ್ಕಿಲ್ಲ ಕಂಟೆನ್ಷನ್.
The representation which is at page 154.
Yes.
There is no question of
questioning the authority.
questioning the authority.
No, what they are referring to is this.
ಅದಕ್ಕೆ ಇದನ್ನ ನೋಡಿದ್ರೆ ಇದರಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಇಲ್ಲ.
ಅಲ್ಲ, ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ. ಅದನ್ನ ಇದರಲ್ಲಿ ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅದರಲ್ಲಿ. Because we have produced what was produced before the tribunal. ಆ ಟ್ರೈಬ್ಯುನಲ್ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರಲಿಲ್ಲ. But these reports are not questioned. There is the applicant before the tribunal did not say that the contents of these documents are incorrect.
ಅಲ್ಲ, ನಮ್ಗೆ ಸ್ವಲ್ಪ ಸ್ಯಾಟಿಸ್ಫೈ ಆಗ್ಬೇಕಲ್ಲ.
ತರ್ತೀನಿ.
That the employee had a fair deal at the hands of his superior officer.
Yes.
ನಮಗನ್ಸ್ಬೇಕು.
No, if I may, how I gathered is, your lordships want to know, was there any justifiable material for the officer to conclude that he questioned the authority of the superiors? This document.
ತೊಂದರೆ ಅಂದ ತಕ್ಷಣ ಅಥಾರಿಟಿ ಕ್ವಶನ್ ಮಾಡ್ರಿ ಅಂತ ಆಗಲ್ಲ.
ಇಲ್ಲ, it is not just by the representation which he gave. It is this day to day in 2018, 2019, when you were asked to file reports, he started.
ಅದಲ್ಲ.
ಅಲ್ಲ, ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ.
That is not the point. You are not catching the point at all. Point is, if that were to be the position, could he consider his representations at all is the question.
No, I did not follow that question.
You did not follow. I'll repeat you again. In service law, a biased officer is not supposed to write the APRs at all. That's the law. Suppose if you think that he has questioned your authority, and on that basis, if a normal man can gather an impression that he feels offended, then he cannot write the APR at all. He has to send it to some other authority.
No, but the reporting officer, he has no such bias against the reporting officer.
But the reading gives an impression that he was not given a fair deal.
No, but
ultimately what we are going to do to the judgment is
no,
another thing.
I'll find out who that officer is. Reporting officer, questioning the authority.
Where has he questioned? Prima facie, ನಿಮ್ statement of objection ದಲ್ಲಿ ಎಲ್ಲರೂ ಒಂದ್ ಕಡೆ, he had a question like this. This is the way he does. Therefore, this is a disciplinary.
I will furnish the records. Original record ತರಿಸ್ತೀನಿ.
That record is a proof of pleading.
Yes.
Where is your pleading? Where are your pleadings before the CAT?
CAT pleading produce ಮಾಡಬಹುದು.
Where have you taken up that contention?
I will take your lordship for that. My pleadings before the tribunal begin at page 158.
Where have you taken up that contention?
Oh, just one minute. Page 160.
160.
In response to para 4E. Matter of record that the respondent sought an exhaustive study report from the applicant. The Honorable Tribunal may kindly like to notice that the tone and tenor of the language used by the applicant towards senior officers is abrasive and sarcastic.
ಅದೆಲ್ಲಿದೆ ಅಂತ ಅದನ್ನ ತೋರಿಸಿದ್ದು. We are not yet convinced.
ಅದಲ್ಲ ತಾವು ಕೇಳ್ತಾ ಇರೋದು ಈ ಅಬ್ರೇಸಿವ್ ಲ್ಯಾಂಗ್ವೇಜ್ ಎಲ್ಲಿದೆ ಅಂತ. ಅದನ್ನೇ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. I will bring that record. I will place it before your lordships. And then please have a look at the last line in page 160. Page 160, last line. The language used by the applicant towards senior officers is evidently intemperate.
ಅದೆಲ್ಲಿದೆ ಅಂತ. That gives an impression that something, even pleadings ತಗೊಂಡ್ರೆ ಕಂಪ್ಲೀಟ್ ಎವ್ರಿ ಪೇಜ್ ನಲ್ಲಿ 2-3 ಸೆಂಟೆನ್ಸ್ ಅಂತ ಹೇಳ್ಕೊತ ಹೋಗಿದ್ದಾರೆ ಬಾಬ್ ಸರ್. ವೇರ್ ಇಸ್ ದಟ್ ಅಂತಾನೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ಅಲ್ಲ it may be true, we do not know.
True. It is. Lord, it is not as part of these records, but if your lordship direct me, I will produce them. I will place it before lordship.
Intelligently they have written it. ಅವ್ರು he asked, ನಮ್ಗೊಂದು ವೆಹಿಕಲ್ ಕೊಡ್ರಿ, ಇದು ನೀವು ಹೇಳಿದ್ದನ್ನ ಕೆಲಸ ಮಾಡಿ.
It is not that simple.
ಕೇಳಿದ್ರು.
No, it's not that simple. Vehicle ಅಂದ್ರೆ vehicle ಕೊಟ್ಟಿಲ್ಲ ಅಂತಲ್ಲ. ಈ the department stand is that consistently this officer has shown lackadaisical attitude, questioned the authority of senior officers. There is consistent pattern to it.
Document ಕೊಡಿ. Since you are only repeating, we are not, with which we are not convinced by repetition.
No.
You prove.
Repeating ಅಂದ್ರೆ I am making submissions. I will produce. If your lordships now want me to produce, now produce ಮಾಡ್ತೀನಿ.
If you want to produce, otherwise you will decide the matter based upon whatever is there on the record.
No. You ask me to produce it, I will not ask.
You will not ask. If you want to substantiate your case, you produce it.
Yes, I will produce it. I want to substantiate it, I will produce it.
Call this matter week after next.
Date is fixed.
The other date. 26, all right.
That's all. I'm good. The other matter also can be heard along with
that. Whether ಹೆಂಗ್ ಬೇಡ, ನಾವೇನು ಇನ್ನೊಂದು ನೋಡೇ ಇಲ್ಲಲ್ಲ. Prima facie, Justice E.S. Venkatramanya said, we are telling you, Justice E.S. Venkatramanya says, APRs are not meant for punishing the employee. They are meant for improving, upgrading him by giving the inputs from the higher ups. That is the grand norm of law relating to APRs. This is number one. Number two, if some of the officers feel offended by the language, such officers should not decide the matter, APRs. Because sometimes intemperate languages are used. It's not that every employee will be very temperate, etc. It all depends upon that. In that event, he should be told, don't use intemperate language. You are a good worker. We'll consider that. But that will disturb the hierarchy, discipline, Tomorrow, everybody starts saying anything to anybody. That will disturb the organizational discipline that way. But you have used intemperate language. ಅದಕ್ಕೆ ಯಾವುದು ಒಂದು ಸೆಂಟೆನ್ಸು ಕಾಣಲಿಲ್ಲ ನಮ್ಗೆ ಇಲ್ಲಿವರೆಗೆ ನೋಡಿದ್ವಿ. ನಿನ್ನೆನೂ ನಾವು yesterday, I spent time with this file. Then saying that he had challenged our authority. For that also there is no material. We cannot just go. He has not questioned that. We will be unfairly treating the employee.
I agree.
That we cannot do.
We'll find out more if it
ಅವ್ನು
is.
ಬಂದೆ ಎಂಪ್ಲಾಯ್ ಹೇಳೋದು ಸಿಂಪಲ್. ನನಗೊಂದು ವೆಹಿಕಲ್ ಕೊಟ್ರೆ ನೀವು ಹೇಳಿದ ಟಾಸ್ಕ್ ಅನ್ನು ಪೂರ ಮಾಡಿ ಹೌ ಮೆನಿ ಪೀಪಲ್ ಹ್ಯಾವ್ ಡ್ರಾನ್ ಇಲ್ಲಿಗಲಿ ವಾಟರ್ ಫ್ರಮ್ ತುಂಗಭದ್ರಾ ವಿಲ್ ಗಿವ್ ಫುಲ್ ರಿಪೋರ್ಟ್ ಅಂತ ಹೇಳಿದ ನಾವು ಮಾಡಿ. ದಟ್ಸ್ ಆಲ್. ಬಟ್ ದೇರ್ ಮೇ ಬಿ ಡಿಫಿಕಲ್ಟಿ ಇನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲಿ ವೆಹಿಕಲ್ ಇರ್ಲಿಕ್ಕಿಲ್ಲ. ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್ ಇರ್ತದೆ
No,
ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ.
my instructions are that he was asked to use some private vehicle and then claim the TA, the travel allowance.
ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಅನ್ನು ಯೂಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ.
ಹೌದು. ಅಲ್ಲ, there is documentary evidence to show that he was informed that he can claim some allowance.
Will get reimbursement.
Yes. And my lord, these have to be done discreetly because he was supposed to go there as an intelligence officer.
Correct.
Others should not know who he is. So some discreetness will have to be maintained.
But that is not the ground you have said. You said we don't have a vehicle. You have taken a specific stand. If that were to be the ground, though these things should be done
In fact,
discreetly.
my lord, I am reading page 110. You are permitted to travel to the concerned places using government transport and claim TA in respect of the local tours as per eligibility. So we said you can use some from public transport or other. Not to it helps also maintain to discreetness. Some public transport, auto, bus, taxi.
Private vehicle also.
Public, yeah, it says public transport. But there is, they say as per eligibility, if he's.
Where there are no roads. There won't be any roads.
Lord, now we are diverting into unnecessary terrain. Adantala. The issue is.
ಅಲ್ಲ ಅವರಿಗೂ ಅವ್ರದ್ದೇನು ನೀವು ಒಂದು ವೆಹಿಕಲ್ ತಗೊಂಡು ಹೋದ್ರೆ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಬಿಡ್ತದೆ ಎಲ್ಲರಿಗೂ. ಇವನ್ನೆಲ್ಲ ಬಹಳ ಡಿಸ್ಕ್ರೀಟ್ಲಿ ಮಾಡೋದಿರ್ತದೆ ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ ಇರ್ಬೋದು. ಗೋ ಬೈ ಸಮ್ ಪಬ್ಲಿಕ್, ಇಟ್ ವಿಲ್ ಬಿ ಸಮ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಟು ಇಸ್ ನಾಟ್ ದಟ್ ಇಟ್ ವಿಲ್ ಬಿ. ಬಟ್ ಏನೋ ಒಂದು ರೀಸನ್ ಇಟ್ಕೊಂಡು ಹೇಳಿರ್ತಾರೆ ಏರ್ ಆಫೀಸರ್ಸ್. ಹಂಗೇನು ಅವ್ರಿಗೇನು ಪರ್ಸ್ನಲಿ ಏನಿರ್ತದೆ ಪರ್ಸ್ನಲಿ ಇಂಥ ಆರ್ಗನೈಸೇಷನ್ ಆಗಿ. ಆಮೇಲೆ ಇಲ್ಲೆಲ್ಲ ಸ್ವಲ್ಪ ಡಿಸಿಪ್ಲಿನ್ ಎಲ್ಲ ಮೇಂಟೈನ್ ಮಾಡೋಕ್ಕಾಗ್ತದೆ. ದಿ ಲಾರ್ಜರ್ ಇಂಟ್ರೆಸ್ಟ್ ಆಫ್ ದಿ ಆರ್ಗನೈಸೇಷನ್ದಲ್ಲಿ ಡಿಸಿಪ್ಲಿನ್ ಮೇಂಟೈನ್ ಮಾಡುವಾಗ ದೇರ್ ವಿಲ್ ಬಿ ಸಮ್ ವಿಕ್ಟಿಮ್ಸ್, ಬಟ್ ದೇ ಆರ್ ಹೆಲ್ಪ್ಲೆಸ್ ವಿಕ್ಟಿಮ್ಸ್. ಏನ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಅದರ್ವೈಸ್ ಆರ್ಗನೈಸೇಷನಲ್ ಡಿಸಿಪ್ಲಿನ್ ಇದೆಲ್ಲ ಹಾಳಾಗಿ ಹೋಗ್ಬಿಡುತ್ತೆ. ನಾನು ಕೆಲಸ ಮಾಡಿದೆ, though language is not very happy, we can't immediately say it is intemperate. Maybe they have formed opinion based upon lot of communication, etc. It is not that officers of that rank will say something against some officers. Not like that. We don't subscribe to that view. Unless
all of this started after 2017.
ಅಲ್ಲ ಎಂಥದೇ ಇರಲಿ ಹಂಗಲ್ಲ.
Transfer order was challenged, my lords.
ಇಲ್ಲ ಇರ್ಲಿ, ಅದು ಪ್ರಶ್ನೆ ಅಲ್ಲ.
Challenge ಮಾಡಿರೋದು
ಕರೆಕ್ಟು, ಹಂಗಲ್ಲ ಆ ರೀತಿ ಅಲ್ಲ. ಇಂಥ ಆರ್ಗನೈಸೇಷನ್ದಲ್ಲಿ ಈವನ್ ಲ್ಯಾಂಗ್ವೇಜ್, ಬೈಬಲ್ ಸೇಸ್ ಹ್ಯಾವ್ ಸ್ವೀಟ್ ವರ್ಡ್ಸ್ ಆನ್ ಯುವರ್ ಟಂಗ್. Bible says to me also, that is another thing. But sweet language.
We will use it.
It is sweet language has its own advantages. If you read Ramayana, Lakshmana said after seeing Sugriva, Angada and Hanuman, Lakshmana told Rama, Ravana appears to have sent some Rakshasas to finish us off. Then Lord Rama was very apprehensive. Then he overheard the discussion that was taking place in a chaste language between Sugriva, Angada and Hanuman. It was a very chaste language. Then Rama says, I have overheard the discussion. It is a chaste language. There is nothing which indicates that they are Rakshasa rupis. So language is very, very important. Many times by language, misapplication of language, wars happen. War is a result of failure of communication. Don't borrow the words of some great scholar, I do not remember. So language also, pleasant language. Anyway, we'll look into that. We have not formed any opinion. There are many questions which we will put to you, which you have to answer afterwards. Now he is arguing, therefore we had put those questions. Overall, one feel ಬರ್ಬೇಕು. The employee concerned had a fair deal at the hands of the higher ups. Because they are not slaves. They are not employees of the East India Company, which we very often keep on telling. Ours is a welfare state. Every organization is a welfare state. Okay, that being said, there is one article which curtails in defense forces the fundamental rights. Which is that article? 19A something. There is one article which curtails the rights of the defense personnel. They can't say we have right to speech, therefore we'll say anything. We have right to walk, therefore we'll dance on the parade ground. These things will not run. That curtailment is there. There is a provision in the Constitution. Article 19 ಆದ್ಮೇಲೆ ಯಾವುದೋ ಒಂದರಲ್ಲಿ ಬರ್ತದೆ. Look into all that. There are some judgments which say how the language of employees in the defense forces, police forces, paramilitary forces. There are 3 judgments. Just advert to those judgments. Yes. Okay. Yes.
First of all, my apologies for the other thing.
We forgot. You are reminding us again. We have forgotten all that. We don't keep anything. Because lawyering is a great art. It comes by lot of experience. Yes. Not just by reading. Second respondent. Yeah, appear. ಯಾರು ಕರ್ನಾಟಕ ಯಾರು?
KM Prakash.
KM Prakash. ಇಲ್ಲ ಇದ್ರಲ್ಲ, he was sitting here na. ಎಲ್ಲಿವರು ಪ್ರಕಾಶ್? ಬರ್ತಾ ಇದ್ದಾರಾ? Can you start?
That's very short ground. That I challenge the selection of respond number 4. Selection is with respect to Assistant Professor Kannada.
Selection is to the post of Assistant Professor
Kannada.
That is lecturer post.
Lecturer Kannada, my apologies.
Anyway, now it is a designation changed by UGC na.
Yes,
All lecturers have become assistant professors and readers have become
lecturers.
Enta professors matta readers. Lecturers have become assistant professors. Readers have become associate professors and professors have remained professors.
Assistant Professor grade 2 have also become associate professor.
They also have become associate. Okay.
But after I challenged before the tribunal, my lords.
What you had challenged?
Respond number 4 selection on the ground that his mental disability certificate is not genuine.
Mental disability certificate.
Under mental disability quota I had applied for. And respond number 4 was selected.
Under the Disabilities Act.
Indeed, my lords. Then, my lords, he gave up his selection. He filed a memo saying that I will give up my selection. Then, my lords, during the course of argument, because he has given up his selection, special rules which was found by the department under 8 clause 2, it is mandatory. Shall provision is used. Along with final select list, additional list is also supposed to be done. So, my lords, I prayed, my lords, in the midst of after he filing memo, in the midst, I prayed, my lords, then let them do the additional list. I shall stop at that point of time. Now, tribunal reserve the matter and have passed the order that I have not made a prayer to that effect. So, that cannot be given.
So, if we read entire your application before the tribunal, it gives indication that what was your grievance and what relief you wanted.
There, initially, I filed an application challenging 4th respondent. There, I have not sought for additional list. But subsequently, he filing memo, he gave up his selection.
Because of that,
because 8 clause 2 is not complied, let them comply is what I sought for. That has come in the order portion of tribunal order, my lords.
Have treated that?
Yes, my lords. If my lords may take, my lords. Para 7, page 27. of tribunal's order, my lords. My lords are with me, my lords.
Yes.
May I read?
To prepare additional list.
To prepare additional list.
Why he has said this, why tribunal says we are not bound by pleadings. Supreme Court said, where there was no prayer, Supreme Court said, High Court should have granted the relief by reading it. ಏನು ಸ್ಟ್ರಿಕ್ಟ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಪ್ಲೈ ಆಗಲ್ಲ ಟ್ರೈಬ್ಯುನಲ್ಸ್ಗೆ, ಹೈಕೋರ್ಟ್ಗೆ ಅಪ್ಲೈ ಆಗಲ್ಲ. ಟ್ರೈಬ್ಯುನಲ್ ಎಕ್ಸರ್ಸೈಸ್ ಆಫ್ಟರ್ SP ಸಂಪತ್ ಕುಮಾರ್ ಅಂಡ್ L Chandrakumar. ಹೈಕೋರ್ಟ್ power of the writ court is shared with the tribunals. The pleadings do not much apply. That is the object of forming the tribunal. The object of forming the tribunal is to give up all these procedural constraints. ಅಲ್ಲಿ ಒಬ್ಬ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಮೆಂಬರು, ಒಬ್ಬ ಜುಡಿಷಿಯಲ್ ಮೆಂಬರ್. ಕೆಲವು ಸಾರಿ ಒಬ್ಬರೇ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಮೆಂಬರ್ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್, ಕೆಲವು ಸಾರಿ ಓನ್ಲಿ judicial member will pass the order and they are upheld by the apex court.
In KAT, my lords, administrative member cannot.
Cannot.
2018 circular
Correct,
they have
that
passed.
because of that amendment. You're right.
In CAT it is there, madam.
Correct. In CAT it is there. Anyway, patterns we are saying. Like, how can, he said, this is my prayer. Other pleadings are. Are they?
During the proceedings, if some
New thing happens.
then that should have been considered.
Consider.
For that, how can he anticipate there should be a pleading?
Because he gave up, the other candidate gave up. How?
He has approached the court on the ground that he did not have any disability at all.
So fresh cause of action ಆಗಲ್ಲದು. Associated package.
ಆಮೇಲೆ ಅವನು
He withdrew.
ಅಲ್ಲಿ ಒಂದು ಹಿಂಚಿದೆ
Huh?
ಅಲ್ಲೊಂದು ಹಿಂಚಿದೆ. The final selection list was published on 3/3/2023. The fourth respondent gave the letter on 5/12/2023, stating that I am not interested. Not within period. Not within the period. Now publication ಆದ್ಮೇಲೆ ಕೊಡ್ತಾರೆ ಅವರು. It seems.
Time barred ಇತ್ತು.
Not even time barred. Even after the publication, my lord, after the lapse of almost 8-9 months, he have published in the month of March. He gave the letter to not to consider his candidature in the month of December, my lord.
Subsequently.
Subsequent 9 months afterwards.
Even immediately got to additional list.
Before publication ಕೊಟ್ಟಿದ್ರು ಮಾಡಿ ಹಾಕ್ಬೇಕಿತ್ತು.
ಎಲ್ಲರೂ ಹಾಗೆ.
And even assuming for a moment, my lord, additional list ಮಾಡಿದ್ರು ಕೂಡ, since his name is not there in the earlier list.
He cannot figure it out.
He cannot figure it and he cannot climb to that post. That's the only submission from my side.
My lords, I am not asking for inclusion of my name in final select list. So he giving representation thereafter does not arise. And second clause is along with final list, they are supposed to send the additional list also. That is what 8 clause 2 speaks about.
Additional list ಅದು ಕಳಿಸಿದ್ರೆ ನೀವು ಇರ್ಲಿಲ್ಲ ಅದರಲ್ಲಿ.
Additional list ಕಳಿಸೇ ಇಲ್ಲ.
ಅಲ್ಲ ಕಳಿಸಿದ್ರೆ
ನಾನು ಇರ್ತೀನಿ ಅನ್ನೋದು ನನ್ನ ನಂಬಿಕೆ. Otherwise I will get a cause of action to challenge the additional list if my name is not.
Additional list ನಲ್ಲಿ ನೀ ಇರ್ಲಿಲ್ಲ.
Lords ಕೊಟ್ಟೇ ಇಲ್ಲ.
Because the other candidate is, otherwise also.
Lords.
The other candidate who has withdrawn candidature later, he would have figured in the additional list, not you.
Let us assume that yes, you would have figured or not figured or whatever it is. Do you have a right to insist for the additional list?
Lords, 8 clause 2 provides for me. 8 clause 2 provides me that right. ಅಲ್ಲ ಅವು ಫೈನಲ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅವ್ರ ಹೆಸರು ಬಂದಿದೆ ಸ್ವಾಮಿ.
My lord,
Additional list ಕೊಟ್ಟಿಲ್ಲ.
My lords,
He would not figure there at all.
my lords, may I submit one thing?
Therefore, what is his right?
Lords,
Why then he is in the list, then he can have, as you say, he cannot have grievance because even if it was additional list, he would not have figured there. He ಹೇಳೋದೇನು ಅಂದ್ರೆ subsequently somebody has withdrawn his candidature. In that stead, I will fit into.
may I make one submission?
Additional list should have been published.
May I make one submission?
As on the date it was published, he was very much there. The other candidate was very much there.
May I make one submission? Additional list will only be operated if the person whose name is found in final select list did not
Does
join
not
for
come
duty.
forward.
And he did not, as on the date of drawing final select list, he has not given his willingness.
Correct.
But subsequently, he has not joined for duty.
No.
Additional list will be operative.
No, there is difference between these two. A candidate not reporting for duty is one thing. A candidate withdrawing the candidature is another. Consequence is there.
Both ways vacancy will arise.
Effect will
Very
be
next,
same.
very next person is me.
Where you were not there at all.
My lords, very next, that is.
Very next person ಅಂದ್ರೆ ನೀ ಬರೋದು ಯಾವಾಗ ಗೊತ್ತಾ? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಡಿಷನಲ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಇರ್ಬೇಕಿತ್ತು ನೀನು.
ಅಡಿಷನಲ್ ಲಿಸ್ಟ್ ಮಾಡಿದ್ರೆ ನನ್ನ ಹೆಸರು ಬರ್ತಿತ್ತು, ಮಾಡೇ ಇಲ್ಲ
ಅಲ್ಲ
ಅನ್ನೋದು
ಮಾಡಿದ್ರು ಬರ್ತಿರ್ಲಿಲ್ಲ.
ಬರ್ತಿತ್ತು ಯಾಕಂದ್ರೆ ಅವ್ನ್ ಬಿಟ್ರೆ ನಾನೇ ಅಲ್ಲ.
ಅವನು ವಿಡ್ರಾ ಮಾಡಿದ್ದು ಅಡಿಷನಲ್ ಲಿಸ್ಟ್ ಅದು ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ.
ಫೈನಲ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ.
ಫೈನಲ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ.
ಫೈನಲ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅವ್ನ ಹೆಸರು ಬಂದ್ರೆ ಎರಡನೇ ನನ್ನ ಹೆಸರೇ ಬರ್ಬೇಕಲ್ಲ ಅಡಿಷನಲ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
ಫೈನಲ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ
ಅವ್ನು ಇರ್ತಾನೆ, ಎರಡನೇಲಿ ನಾನು ಇರ್ತೀನಿ.
Though his name was figured in the final list, after, at the time of issuing the appointment letters, he was not issued and his name was not included in that list.
No, in the final, he is saying, in the final list, his name figured. He was serial number?
Well, it's 10.
He was there in the final list.
Yes, my lords.
What he says is, I was under impression in the second list, his name was there. His very case is, you did not prepare the second list at all.
That is my case.
When rule 8(2) provides for preparation, forwarding of additional list, because those who would not join,
Yes,
for
my lord.
them,
Yes, my lord.
ಇಲ್ಲಿ ಬರುವುದು.
In that list, the respondent number 4 was not there, my lord.
Correct.
The name of the respondent number was not there. Since, say for example, like this, my lord, a general merit candidate, he has not joined after the issuance of the appointment order,
Correct.
then he is eligible.
Correct.
Here, my lord, under the PH is claiming, his name was not at all in that list.
In which list?
There's the appointment order of this, my lord.
Brother, you did not prepare additional list is his grievance.
Even
I was also under impression that in the first list itself he was.
Yes, my lord, even assuming for a moment, he prepare, my lord.
Yes.
The person who entitled for, to consider the main list.
He is next in the line.
Because, my lord, the person who has not joined, reported for the duty.
Correct.
To that category he has to fit into.
He is not in that category.
No, my lord.
That is what I have applied.
No, my lord, because in the list which is prepared by the appointing authority and issues the appointment order, his name was not there.
His name was there is correct. He would have figured in the additional list. Had you prepared one,
No, my lord.
that is his grievance.
Because,
Okay.
my instructions to that effect, my lord.
Instructions ಅಲ್ಲ ತೋರಿಸ್ಬೇಕು. ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ನಿಮ್ಮವರೆಲ್ಲ ಏನ್ ಬೇಕಾದ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಡ್ತಾರ ಅಂತ ತಗೊಂಡು ನಾವೇನ್ ಮಾಡ ಶೋ ಇಟ್.
Select ಮಾಡಿ.
ಹಾ. ಹಾ ಮಾಡ್ಲೇಬೇಕು. 8(2), Justice Shivshankar Bhatt Sahab said, 8(2) is mandatory. 8(2) is mandatory. You have to prepare. I was under impression that he was there in the first list itself. He is not. The other candidate was there and he did not join. Therefore, what he says is.
After issuance.
Correct.
Final select list.
Correct.
he has
After
sent
that,
it to the appointing authority.
in that
The
case,
appointing authority has given the letter. His name was not figured out in that list, my lord.
how it will figure? It would figure only in the additional list. Because this fellow has gone, had you prepared additional list, he would have got the appointment. Yes, so simple it is. No argument is necessary.
The thing is, my only submission, my lord, what I understood in this, my lord, the provisional list, my lord, final selection list, after the final selection list, we will send it to the
Government.
government, my lord.
That is where you committed the mistake.
Yes, my lord. No, my lord.
You should have done, additional list also you should have done.
Request my lordship may direct the KA to prepare the.
First, additional list.
My lord sir directed me to bring LIC versus Saurabh's judgment on last date of occasion to read that. and-
That's correct, where we considered the
Importance of
additional list ಇದ್ದಾಗ ಅಲ್ಲಿದ್ದವ್ರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೇಕು
Para 10.
ಅಂತ ನಾವು ಹೇಳ್ದೆ ಪ್ಯಾರಾ 10.
The appoint, unless.
ಇರಲಿ ಅಲ್ಲಿ ತನಕ ಹೋಗಲ್ಲ ಅದು. You prepare additional list. Okay?
It is eligible, ಮಾಡ್ತಾರೆ ಇಲ್ಲ ಅಂತಿಲ್ಲ sir.
That's what. ಅಷ್ಟೇ ಅವ್ರು ಕೇಳೋದು ಅದನ್ನೇ. ಬರ್ಕೊಳ್ಳಿ. The petition is allowed and the order of the tribunal is reversed. First up, a direction issues to the KPSC to prepare additional list of candidates belonging to your category.
Physical,
Huh?
general merit, mental disability, GMM.
General merit, bracket nalli mental disability, comma, candidates.
My intellectual disability.
Intellectual intellectual disability. We all have that. In that Paulo Coelho's famous novel, Alchemist, he says we all suffer from intellectual disability.
Intellectual disability, specific learning disability and mental illness category.
Page
Page 11 ಅಲ್ಲಿ ಇದೆ sir.
Page 11 ಹಾಕ್ಬಿಡಿ. ಅವೆಲ್ಲ ಹಾಕೊಂಡ್ಬಿಡ್ಬೇಕು. Yes. Within a period of, within what period you will do that? 8 weeks? 8 weeks. Within a period of 8 weeks. And prepare and send it to the government for being operated within a period of 8 weeks. First. 6 weeks ಮಾಡ್ತೀವಿ ಅವ್ರಿಗೆ 2 weeks 4 weeks ಕೊಡ್ತೀವಿ ಅಂದ್ರೆ 2.5 ತಿಂಗಳಾಗತ್ತೆ ನೋಡಮ್ಮ 6 weeks. The respondent government shall act upon the said report within 4 weeks thereof. Yes. Correct.
Much obliged.
All. ಯಾವ್ದು judgment ಇದನ್ನು ಕೊಡಿ LIC versus Saurabh. Yes. LIC versus Saurabh to be referred to, not directly on the point, but anyway, it takes a point particular. Okay, correct. 1 minute, yes. Yeah.
Preparing the petitioner.
Yes.
Case of premature transfer.
Premature transfer.
Please, Milords.
Ilva.
Milords, initially, this was the second round of litigation before the tribunal on 8.
First, retention period ಎಷ್ಟಿದೆ?
2 years.
2 years. ಏನು ಇದು ಗ್ರೇಡ್ ಏನು?
Joint Director, Town and Country Planning Department.
Joint Director, Town and Country Planning.
PBMP. Milords, on 8.
He came to that post when?
Milords, on deputation on 8/2/2023.
8/2/2023.
23. Milords, after 1 year on 28/2/2024.
1 year ಅಂತ ಯಾಕೆ ಹೇಳ್ತೀಯಪ್ಪ ನೀನು? 1 year ಆದ್ಮೇಲೆ.
Please. After 1 year.
2 years ಇದೆ retention ಅಂತನಾ?
Yes, Milords.
ಅದು whether it applies to employees on deputation also?
Please, Milords.
Apply ಆಗ್ತದೆ.
Please, Milords.
Okay.
She was repatriated, Milords, on 28/2/2024.
Repatriation.
Please, Milords. That order came to be challenged before the tribunal.
ಏನಾಯ್ತು?
That was allowed, Milords.
Set aside.
That was a repatriation order was set aside and she was directed to be continued in the said post.
In the early round of litigation. ಏನು application number?
Application number 937 of 2024, Milords.
DD?
Milords, and the specific direction of the tribunal was to continue her in the said place. Despite that, Milords, on 2/5/2024, though she was working as the Joint Director, Town and Country Planning East Division, she was posted to Dasaralli Division.
Posted to?
Dasaralli Division. Not in the East Division where she was earlier working.
ಅದೇ ಆಫೀಸ್ನಾಗ ಕಂಟಿನ್ಯೂ ಆಗ್ಬೇಕು ಅಂತನಾ?
That was the direction of the tribunal, Milords, to continue her in the same said post. Page number 76 may kindly be
post.
seen. Yes, Milords.
Said place post.
Post, Milords.
Post ಗೊತ್ತಾ ಈಗ ಅದೇ post ನಾಗ ಇದಾಳು.
No, Milords.
Liberty is given to continue, not mandate to continue.
Milords, the wording, if I may read, Milords, of the tribunal, the applicant is entitled to continue in the same place. However, the respondents are liberty to take a decision in accordance with law. Thereafter, Milords, she has been transferred to Dasaralli Division. She was not allowed to continue in the said place. The tenure of the post is
2 years ಇದೆ.
2 years, Milords.
76 liberty was granted.
Liberty ಯಾದಕ್ಕೆ?
Why she was sent back? Why the first round of application came up to court? There were certain allegations against the petitioner.
ಏನು allegations? ಏನು allegations?
Page 68.
ಓದಿ.
The applicant has failed to perform duties delegated to her such as timely disposal of plan approval, files, obstructions, rejection of application, non-evacuation of building, violating bylaws within the due time,
as per the BBMP Act and as far as hardship and inconvenience to the public. Further, the applicant has shown carelessness in handling and disposing of court cases.
ಈಗ ಅವಳು ಅಲ್ಲಿ ಹೋಗಿ ಅದನ್ನೇ ಮಾಡ್ತಾಳೆ.
What happened, my lord, after that we have known, we sent her back to the parent department. My lord, that was challenged before this one, the tribunal. Tribunal, my lord, passes an order saying the applicant is entitled to continue in the same place. However, the respondents are at liberty to take a decision in accordance with law.
What for?
From East Division, she was sent to Dashanpur. There she has not reported, till date unauthorized absence. She has not gone.
My lords, if I may. My lords, with respect to the allegations, contentions regarding allegations, that
No, why you did not report for duty to the transferred place?
ought to happen.
Then you should have challenged this.
I've immediately challenged, my lords, that
You
order.
have challenged all right. Where is the stay?
The-
Why did you keep away from the duty?
That is, I ought to have.
That goes against you.
My lords,
SR Venkatesha Murthy versus KSFIC.
please,
Not reporting to the transferred place is an indiscipline.
please.
Not gone.
Lords, my second limb of argument is, according to the cadre and recruitment rules, this post has to be filled only by way of deputation, my lords. Now, currently, the person who is holding that post is from BBMP only, is not on deputation, and he is holding that post on in-charge basis. Joint Director, Town and Country Planning of the Southern Division is holding this post on in-charge basis. They have not brought in any other person on deputation, which is which should be as per the C&R rules.
It is by deputation.
It has to be by deputation.
Next week happen, no.
My lords, one submission. This matter initially came up for orders, my lords. It was not heard, however, for preliminary hearing at all. Since they were on caveat, even their caveat was expired, I was directed to serve them a copy. Now it is coming up in B group, my lords. May I request that the matter be taken up in preliminary hearing, because this matter was never heard. It's for the first time this matter is being heard.
ಒಂದ್ಸರಿ ನೋಟಿಸ್ ಆದ್ಮೇಲೆ ಬಿ ಗ್ರೂಪಿಗೆ ಬರ್ತದೆ
My
ಅಂಡರ್
lords, they were on caveat.
ಡಿಫರೆನ್ಸ್ ಇಟ್ ಮೇಕ್ಸ್. ಅದೇನ್ ಬಿ ಗ್ರೂಪ್ ನಲ್ಲಿ ಬಂದ್ರೇನು ಇಲ್ಲಿ ಬಂದ್ರೇನು ಭಾಳ ಡಿಫರೆನ್ಸ್ ಆಗುದಿಲ್ಲ.
May not reach, my lords.
That's all not. Anyway, your client is very happy not joining the duty. First ask her to join the duty.
Please.
Join ಮಾಡ್ತಿದ್ದ 4 ತಿಂಗಳ ಗಟ್ಟಿ ಕೆಲಸ ಎಷ್ಟು ತಿಂಗಳು 8 ತಿಂಗಳು 8 months.
Please.
How that raises an impression that she is not interested to work at all.
I request for a date.
Next week.